Court officer? Court officer? Sir, court officer?
ಹಲೋ ಹೇಳಿ ಮೇಡಮ್.
Sir, ಇದು page wise adjournment ಕರೀತೀರಾ?
ಮೇಡಮ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ಸ್ ಅದರ್ ಸೈಡ್ ಟು ಬಿ ಪ್ರೆಸೆಂಟ್.
ಅಲ್ಲ, ಇದು ಮೆಮೋ ಫಾರ್ ವಿಡ್ರಾವಲ್ ಹಾಕಿದ್ದೀನಿ, ಅದ್ ಮೆನ್ಷನ್ ಮಾಡಕ್ಕೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 31.
ಎಷ್ಟನೇ ಕೇಸ್ ನಂಬರ್?
31 ಸೀರಿಯಲ್ ನಂಬರ್ ಮೆನ್ಷನ್ ಮಾಡ್ಬೋದಲ್ಲ?
ಮಾಡಿ ಬರುತ್ತೆ, ಅದರಲ್ಲೇನಿದೆ. ವಿಡ್ರಾವಲ್ ಹಾಕಿದ್ದಾರೆ. ಆಯ್ತು ಮಾಡಿ.
ಥ್ಯಾಂಕ್ ಯು ಸರ್.
withdrawal ಇದೆ.
End of the list mention ಮಾಡ್ಬೇಕು. End of the list. ನಾಳೆ
ಸರಿ ಇದೆ.
ಏನಾಗಿದ್ರೆ ಸರ್ ನಾಳೆ ಸರ್ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್ ಸರ್ ಏನಾಗಿದೆ 4 ಅರ್ಜೆನ್ಸಿ ಬಗ್ಗೆ ಹೇಳಬೇಕು 151 ಹೌದು ಸರ್ ಇದು 224 ಸರ್
ಕೊಟ್ರಿ.
ಸ್ಟೇಟ್
ಅದೊಂದು ನೋಡ್ಲಿಲ್ಲ. ಅದೊಂದು ನೋಡ್ಬೇಕು.
ಸರಿ ನಾಳೆಗಾದ್ರೆ ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕಂತ ಕೇಳಿದ್ರೆ ಮಾಡಿ. ಇಲ್ಲ ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಫ್ರೆಶ್ ಮಾಡ್ಬೇಕು. ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಸರ್ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರು ಮೂರನೇ ತಾರೀಕು ಒಳಗಡೆ
ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್. ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್. ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್. ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಸಬ್ಮಿಷನ್ ಮಾಡಬೇಕು.
30 ಎರಡನೇ 31 ಇಲ್ಲ
ಫ್ರೆಶ್ ಮೆಮೋಸ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ ಸರ್. ಆಲ್ ಫ್ರೆಶ್ ಮೆಮೋಸ್.
ಅದೇ ಮೆಮೋ ಮಾಡ ಕೇಳ್ಬೇಕಲ್ಲ.
Other side to be present on actually or by this any.
ನಾನು ಎರಡೇ ಮೆಮೋ ಅರ್ಜೆನ್ಸಿ ಮೆನ್ಷನ್ ಮಾಡಿ 151 IM ಆಯ್ತು. Three days ಒಳಗಡೆ ಮೆಮೋ
ತಗೊಳ್ತಾರೆ ಸರ್. ಏನ್ ನಿಮ್ಮ ಅರ್ಜೆನ್ಸಿ?
ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಸ್ಟೇ ಕೊಟ್ಟಿರೋದೆಲ್ಲ अपना नाले ಅವ್ರು random ಗೆ ಕೊಡ್ತಾರಂತ. ಸರ್ ಸರ್ ಅವನು వచ్చురా ఫోన్ చేసిండ్రా ఫ్రెష్ ఫ్లాట్ సార్
ಸೈಟೇಷನ್ಸ್ ಜಜ್ಮೆಂಟ್ ಅವೆಲ್ಲ ಇದೆ ಅಂತಂದ್ರೆ ಕವರ್ಡ್ ಬೈ ಜಜ್ಮೆಂಟ್ ಅಂತ ಹೇಳ್ಬಾರ್ದಾ? ಪೂರ್ತಿ ಹೇಳಂಗಿಲ್ಲ.
ಕವರ್ಡ್ ಬೈಗೆ ಅರ್ಜೆಂಟ್ ಏನಿದೆ ಅಂತಾರ.
ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರೆ,
ಮಾಮೂಲಿ
ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಪೋಸಿಟ್ ಸೈಡ್.
ಕವರ್ಡ್ ಇದ್ರೆ ಹೆಂಗ್ ಕೊಡ್ತಾರೆ?
ಅಂದ್ರೆ ಹಂಗಲ್ಲ, ಈ ಫ್ಯಾಕ್ಟ್ಸ್ ಬಗ್ಗೆ ಅವ್ರಿಗೆ
ಸರ್ ಏನಂತ ಅರ್ಜೆನ್ಸಿ ಇದೆ ನಾಳೆ
ಹೇಳ್ಬಿಟ್ಟು
ಸುಮ್ಮನೆ ಎಕ್ಸ್ಟ್ರಾರ್ಡಿನರಿ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ
ಮೆನ್ಷನ್ ಮಾಡೋದ.
ನಾಳೆ ಅವ್ರು ಅಂದ್ರೆ ನಾಳೆಗೆ ಅಂತ ಹೇಳಿ and leave Lord. Lord,
Matters preliminary matters.
fresh matter Lord. Yesterday it was listed Lord, but it did not reach Lord. The urgency Lord, end of the list because Lord, in respect of
Matter, it was listed yesterday, it did not reach.
please Lord.
What do you mean?
Lord, it was listed on hearing and IS Lord, with the leave of the
Then
court.
how can it be fresh matter?
Lord, fresh matter only Lord.
Please give it, please give it.
Lord, at 2:30 Lord, the
Matters, preliminary matters you can.
Lord,
Let's say, end of
sorry
the-
for interruption Lord. The urgency is Lord, with Tahsildar.
Please give, sir, all of you, please give it.
But let's say end of the list.
You don't have to mention, you please give it, sir. End of the list. not
ನಿನ್ನೆ ಮೂವ್ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ, ಇವತ್ತು
possible.
ಡೇಟ್
Not
ಕೊಟ್ಟಿದ್ವಿ.
possible, not possible. to the end of
Let's
the list.
ಮನೆ ಮುಂದೆ ಟ್ರೆಂಚ್ ಹೊಡ್ತಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಆಲ್ರೆಡಿ ಓಡಾಡ.
Tomorrow, you please give.
Lord, tomorrow at least Lord, my matter.
Give.
Sir,
ನಾಳೆ.
Huh?
sir,
Serial number? Ah, only one matter. is it? Ah. List number 3. List number 2.
This number 2, my lord, serial number 3. A suit is dismissed as not pressed, so writ petition becomes infected.
Ah. You are for the petitioner.
I am for the petition.
Writ petition number?
Writ petition number.
ಸರ್
My lords, 15572 of 2021.
All right. Learned counsel for the petitioner submits that the suit, original suit
Original suit.
from which the present petition arises has been disposed of by the trial court
Dismissed as not pressed.
on
My lords, on 30/11/2021.
and therefore the prayer made in the writ petition has become infructuous. Next para, the submission of the learned counsel for petitioner is placed on record. Accordingly, the writ petition stands disposed of in view of the above. Yes,
My lord, some submission, my lord.
This is fourth time we are moving memo, my lord.
please give it, sir.
My lord,
Matter has been not been listing, ma'am. Even after giving the date.
It is rejected, my lord.
Ah,
Posted for argument.
you don't have to mention if it's a fresh matter, preliminary matter, please give it, madam. Please give it. Don't waste the time of the court like this.
My lords,
Yes,
one more.
With your lordship, kind leave, my
Serial
lord.
number 18, my lords. Serial number 18.
number 2. Original suit,
Original suit, dismissed as not.
disposed of on
My lords, I have applied for certified copy. The order date is, so I have to assert.
We'll have that information, we will do it. Yes,
Please.
yeah, sir?
List number.
Yes.
With your lordship kind leave, my lord.
Serial number 11, list number 2. Learned counsel for the petitioner has filed a memo dated 28/8/2024 stating that the original suit from which the presented petition arises has been disposed of by the trial court. And therefore the prayer made in the petition has become infructuous. Disposed of. Yes.
Serial number 15 in the first list, my lord. I'll inform the other side.
No, they have to be here and say no objection. Yes.
First list, serial number 50, my lordship, 50.
Same thing will apply to everyone. Adjournments, if the other side is here and says no objection, only adjournment. Otherwise,
For the conversion of this writ petition into civil revision petition.
no conversion. I'll dismiss and give you liberty. Please,
My lord, serial number.
please give it. Yavdu?
Serial number 50, my lordship.
50.
50.
Learned counsel for the petitioner has filed a memo dated 28/8/2024 seeking leave of this court to convert the writ petition into a civil revision petition.
Yes, my lord.
Since provision is available to challenge the impugned order by filing a civil revision petition. Full stop. The writ petition cannot be converted into a civil revision petition. Full stop. Next para. The writ petition is accordingly dismissed while reserving liberty to the petitioner to file a civil revision petition on the same cause of action. Yes.
Documents may be.
With your lordship kind leave, my
Certified
lord.
copy, if any, filed by the petitioner may be returned while retaining a copy for the record. Yes.
Least one serial number 52, my lord. I seek an adjournment. Other side.
Pay for the petitioner.
52.
52. It's an application for early hearing.
Ah.
Lordship may kindly fix a date.
Why who is seeking
I am
adjournment?
the respondent is seeking an adjournment.
Why?
There is little inconvenience for the arguing counsel, my lord.
Ah.
The child is not keeping well, my lord. So
Serial number 52. At the request of learned counsel for the respondent, release this matter. On 4th of September,
Lord, is-
next week.
Interim order may kindly be extended.
Interim order granted earlier stands extended till the next date. Serial number?
ಈ ಕರ್ದಾಗ ಪಾಸ್ ಅವ್ರು ಕೇಳ್ಬೇಕ್ರಿ.
ಅದ್ ಹೆಂಗ್ರಿ? ಅವ್ರು ಇದಾರೆ learned counsel for petitioner. Mr. Rajesh DM,
Yes, ma'am. I appear for the
you
petition.
are the petitioner. ನೀವ್ ಯಾವ್ದ್ರಿ?
Serial number 19.
ನೋಡ್ಕೊ.
Filing memo for withdrawal. The matter has been settled in a law.
19.
Yes, my lord.
Same order, ma? Has filed a memo.
List number 2, serial number 19.
Suit,
Yes, my lord.
suit has been disposed of.
No, it's been settled, my lord.
ಅದೇ ರೀ disposed of
Yes, my lord.
on date ಗೊತ್ತಿಲ್ಲ. All right. Disposed of.
Serial number 31, my lord.
Yesterday, one matter was listed, your lordship, that this matter to be connected and posted it for tomorrow. But this matter.
ಯಾವ್ದು?
Serial number 16.
In serial list number 1.
20403. Your lordship directed this matter to be connected with the yesterday's matter and posted tomorrow, or posted it for tomorrow. But it is listed today, my lord, may be taken up tomorrow. May be taken up with WB 20401 of 24, that come up yesterday.
For that one, we have given a date tomorrow.
Tomorrow.
Serial number 16. Release this matter tomorrow along with WP number 20401 of 2020. Yes.
Notes me. This is not a fresh matter, my lords. An ex parte order of temporary injunction was granted by the trial court which is challenged in the
stage
writ
is it?
petition. Now, an application is filed seeking vacating of the interim order which is passed with your lordship's hands because
Ah.
your lordships have directed that the petitioner should not take any precipitative action till 2/9/2024. That's I am seeking for a listing before 2/9/2024 because no date is fixed. But I am unable to pursue the registry to post the matter, my lords, before your lordships.
You are for the respondent.
I am for the respondent.
Ah.
Petitioners are directed not to precipitate till 2/9. Lords, I am requesting for a hearing prior to 2/9, my lord, so that I can seek for extension of this direction which is issued at your lordship's hands.
Extension.
Lords, so the interim order, ex parte interim injunction granted in my favor by the trial court is stayed by your lordships.
Yes.
However, protecting the interest, saying that there should not be no precipitation till 2/9. So that 2/9, my lords, is the date on which the order will expire. Lords, I have sought for vacating of the order also. But now if 2/9, my lords, expires, then they will be at liberty to do anything, for which we already hold an order of ex parte injunction, which is still pending consideration. Any date, my lords, prior to that date, my lords, either Friday or Saturday, subject to your lordship's convenience. That's 2/9, because if 2/9 goes off, then nothing remains for me.
We'll list it on 2nd of September.
Very well, my lords.
Down.
Serial number 31, my lord. The parties have settled the matter out of court and the suit has been disposed on 19/9/22, my lord. I filed a memo for withdrawal. Kindly it may be taken on.
Note serial number 31, withdrawal. Learned counsel for the petitioner has filed a memo dated 19/4/2023, stating that the commercial court has passed a decree in terms of the compromise petition filed by the parties. Therefore, the prayer made in the writ petition has become infructuous. Next para. The memo is taken on record subject to all just exceptions. Accordingly, the writ petition stands disposed of in view of the above.
Much obliged.
Number 1. For 1, for being spoken to, MJ Alva.
Yes.
Maramalki is the subject matter.
Huh?
Maramalki is the subject matter, Anubandha 4. But Anubandha 5 order agide. So that has to be rectified. So batches of writ
This is
petition
the
dispose
batch of
adaga,
writ petition
this
regarding the
mistake-
Hemavati.
In our case allo ade Maramalki subject, Anubandha 4.
Have you enclosed the type of order that you want? You have passed several other orders,
Orders.
isn't it?
Please, please.
Which is the type of order that you want?
That's good. Not that, this is-
This is the one.
Please, please, in all the 6 cases.
It should have been this
Category
Please,
4.
order.
It should have been this order.
This matter has been listed for being spoken to, comma, at the instance of the petitioner. Full stop. Learned counsel submits that the petition pertains to Annexure 4, and accordingly, the petition was directed to be disposed. Full stop.
Anubandha
However,
4. Anubandha 4.
however, what has been the contents of the order would pertain to Annexure 5.
5.
Anubandha 5. Anubandha 5. The next is.
Next para. The submission of the learned counsel for petitioner is accepted. The order dated 22/4/2024 is hereby recalled. Please. And a fresh order is accordingly passed. Yes.
In all the 6 cases.
All the cases same. ಇದನ್ನು ನೋಡ್ಕೊಂಡು ಮಾಡ್ಬೇಕಾಗುತ್ತೆ ಇನ್ನೊಂದು ಆರ್ಡರ್. Yes.
Great.
Preliminary. Serial number 7. SK Acharya.
For responding number 12.
Respondent.
Number 12.
Matter is called out. There is no representation for the petitioner. On the previous occasion, this court had adjourned the matter at the request of the learned counsel for petitioners, as a last chance. Full stop. Next para. Accordingly, the writ petition stands dismissed for non-prosecution.
Serial number 8,
Appear for petition.
Kalimullah Sharif.
In this case, my lord. Server number petitioner, amendment by server number 27, right? Measures about 4 acres, my lord, 4 acres, 17 guntas, my lord. Out of which, my lord, 2 acres, 20 guntas have been sold by their uncles. But there is a pathway between the scheduled land and the, my lord, and the land of the respondent, my lord. That schedule B. That land is being used as a pathway, my lord. That is Kharab land. But the respondent filed a suit against the petitioner, my lord, stating that we are interfering. But I mean, in the suit, I have admitted that there is a pathway and the respondent is being used it as a ingress and outgress. But the remaining land of the petitioner, my lord, he want to put up the fencing in his land, not without objecting the B schedule land, which has been decreed in favor of the respondent. But he files an execution, my lord. Execution is not maintainable. Files execution stating that I am interfering in his possession. So, well, I filed IF for 6, stating that, but I am not, in the suit, I have admitted that there is a pathway in B schedule and is used as a pathway, but the execution is not maintainable. In spite of his, but the
Suit of the plaintiff is hereby decreed with cost.
yes, ma'am.
The defendants and their men are hereby perpetually restrained from interfering with the peaceful possession and enjoyment of
B schedule.
suit
property.
schedule A and B property.
Yes, we are not interfering. I am not interfering.
Ah,
I am putting fencing in my land, to my land. So, like, he has, without interfering.
if you are doing anything in respect of A and B schedule property, then there is a violation of the orders of the court.
I am not putting in his land. You will ask,
Sir, we are not concerned with what you are doing in your land.
Lordship, you are
If you are doing anything contrary to the decree, then you are liable to be punished for that.
You are not told me submission, but I am not doing in contrary to
Then
decree.
you can make the statement there.
But I have, that's why I filed IA number 6,
Ah,
stating that I am not interfering in his land. That IA 6 has been rejected.
where is your this one statement?
Yes, madam.
What have you filed? Affidavit?
I know, IA ಹಾಕಿದ್ದೀನಿ ಹೌದು.
IA?
IA.
ಏನಂತ?
IA to reject the execution petition
Where
as
is
not maintainable. In para 31, madam.
Where is your application, sir?
Application, madam, Annexure C. Annexure C.
ಏನ್ ಹೇಳಿದ್ದೀರಾ ನಿಮ್ಮ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ?
Page 31 you lordship can listen. ನಾನು ನನ್ನ ಹಕ್ಕು ಸ್ವಾಧೀನ ಭವನದಲ್ಲಿರುವ 27/2 1 ಎಕರೆ 20 ಗುಂಟೆ ಜಮೀನು ಕೃಷಿ ಮಾಡುತ್ತಿದ್ದು, ಈಗ ಅದನ್ನು ಬೇರೆಯವರಿಗೆ ಮಾರಾಟ ಮಾಡಬಾರದು ಎಂದು ತೊಂದರೆ ಕೊಡುವ ಉದ್ದೇಶದಿಂದ ಉಲ್ಲಂಘಿಸುತ್ತಾರೆ ಎಂದು ಸುಳ್ಳು ಆರೋಪ ಮಾಡಿ ಜಾರಿ ಅರ್ಜಿಯನ್ನು ಜಮಾ ಮಾಡುತ್ತಾರೆ. ನನಗೆ ವಯಸ್ಸಾಗಿ ಹಿರಿಯನಾಗಿರುತ್ತೇನೆ. ಈಗ ಬಿ ಅನುಸೂಚಿತ ಸ್ವತ್ತು ನನ್ನ ಸ್ವಾಧೀನದಲ್ಲಿ ಇರುವುದಿಲ್ಲ. ಹೀಗಾಗಿ ನಾನು ಸದೇ ಸ್ವತ್ತಿನ ಅತಿಕ್ರಮ ಪ್ರವೇಶ ಮಾಡುವ ಕ್ರಮವೇ ಬರುವುದಿಲ್ಲ. ದಾವಾ ಅನುಸೂಚಿ ಸ್ವತ್ತಿಗೂ ತೀರ್ಪು ಮಣಿಗೂ ಯಾವುದೇ ಸಂಬಂಧ ಆದ ಕಾರಣ ಅಸಲು ದಾವಾ 100 ಡಿಗ್ರಿ ಆದೇಶ ಮೇಲೆ ನನ್ನ ವಿರುದ್ಧ ಜಾರಿ ಅರ್ಜಿಯನ್ನು ದಾಖಲು ಮಾಡಲು ಕಾನೂನಿನ ಅಡಿಯಲ್ಲಿ ಬರುವುದಿಲ್ಲ. State, I am not interfering. I am not. It is not in my possession. I am not putting any fence in his manner. ವಿನ ಕಾರಣ ತೊಂದರೆ ಕೊಡುವ ಸಲುವಾಗಿ ಜಾರಿ ಅರ್ಜಿಯನ್ನು ದಾಖಲು ಮಾಡಿರುತ್ತಾರೆ.
What about A schedule property?
A schedule 2 acres he have purchased remaining out of 4 acres 17 guntas. The respondent has purchased 2 acres 20 guntas.
Sir, the decree is in respect of schedule A and B property.
A and B payment.
What have you said or what is the allegation that you are interfering in
B schedule property.
Huh?
Interfering in B schedule property. I am not at all interfering.
But you said you are putting up something.
In my land.
Huh?
In my land. Remaining in my land.
What is the reasoning?
Reasoning,
Paragraph number 7. ಕಾರಣಗಳು.
para 7. ಅರ್ಜಿದಾರರು ಮೇಲ್ಕಂಡ ಷರತ್ತುಗಳನ್ನು ಸಲ್ಲಿಸಿ ಅವರು ದಾವಾಗಳನ್ನು ಬಿ ಅನ್ನು ಸೂಚಿಸಿದ ಸ್ವತ್ತು ಹಾಗೆ ಇರುತ್ತದೆ. ಹಾಗೆ ನನ್ನ ಸ್ವತ್ತನ್ನು ದಿನಾಂಕ 10ರಂದು ಮಾರಾಟ ಮಾಡಿದ್ದು ಪ್ರಸ್ತುತ ಸದರಿ ಸ್ವತ್ತಿನ ಸ್ವಾಧೀನವಿರುವ ಇಲ್ಲದೆ ಇರುವ ಕಾರಣ ತೀರ್ಪು ಮಾಡಿಯು ವಿರುದ್ಧ ಕ್ರಮ ಕೈಗೊಳ್ಳುವಂತೆ ಸಲ್ಲಿಸುವ ಅಮಲ್ದಾರಿ ಅರ್ಜಿಯನ್ನು ವಜಾಗೊಳ್ಳುವಂತೆ ಕೋರಿ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ತೀರ್ಪು ನುಡಿಯುವ ಅಸಲುದಾರ 100ರಲ್ಲಿ ದಿನಾಂಕ ರಂದರ ತೀರ್ಪು ಮತ್ತು ಡಿಗ್ರಿಯನ್ನು ಉಲ್ಲಂಘಿಸಿ ದಾವಾ ಅನುಸೂಚಿಸುವ ಅತಿಕ್ರಮ ಪ್ರವೇಶ ಮಾಡಿರುತ್ತಾರೆ. ಐ ಆಮ್ ನಾಟ್ ಅಟ್ ಆಲ್ ಡೂಯಿಂಗ್ ಮಾಡಿರುತ್ತಾರೆ ಎಂಬುದಾಗಿರುತ್ತದೆ. ಆದರೆ ತೀರ್ಪು ನುಡಿಯು ತಾನು ತನ್ನ ಸ್ವತ್ತನ್ನು ದಿನಾಂಕ 10ರಂದು ಮಾರಾಟ ಮಾಡಿರುವ ಕಾರಣ ತನ್ನ ವಿರುದ್ಧ ಅಮಲ್ದಾರಿ ಅರ್ಜಿಯನ್ನು ದಾಖಲು ಮಾಡಲು ಬರುವುದಿಲ್ಲ ಎಂಬುದಕ್ಕೆ ತಿಳಿಸಿದ್ದಾರೆ.
ಮಾರಾಟ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ? ಮಾರಾಟ ಮಾಡಿದ್ದೀರಾ?
ಸೇಲ್ ಆಗಿದೆ, ಸೇಲ್ ಮಾಡಿದ್ದೆ.
ಯಾವ ಪ್ರಾಪರ್ಟಿ?
ಅದೇ ನನ್ ಪ್ರಾಪರ್ಟಿ, ಅವ್ರದ್ದಲ್ಲ. ಇವ್ರು ಇರೋದೇ ಬಿ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ. ನಾನು ಇಂಟರ್ಫಿಯರ್ ಆಗ್ತಾ ಇದ್ದೀನಿ ಅಂತ
ಮುಂದೆ ಓದಿ.
ಆದರೆ ತೀರ್ಪು ನುಡಿಯು ಈ ದಿನಾಂಕ 8/2/20ರಂದು ಅಮಲ್ದಾರಿ ಅರ್ಜಿಯನ್ನು ದಾಖಲು ಮಾಡಿದ್ದು ನಂತರ ಅಂದರೆ 10/3/2ರಂದು ಸ್ವತ್ತನ್ನು ವಿಲೆ ಮಾಡಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಅದರಂತೆ ಅರ್ಜಿಯನ್ನು ದಾಖಲು ಮಾಡುವ ಸಮಯ ತೀರ್ಪು ನುಡಿಯೇ ಸ್ವತ್ತಿನ ಸ್ವಾಧೀನದಲ್ಲಿರುವ ಗೊತ್ತಾಗುತ್ತದೆ. ಅದನ್ನಡ್ಡೆ ಈ ನುಡಿದ ಸಂಗತಿ ವಿಚಾರ ನಂತರವಷ್ಟೇ ತೀರ್ಮಾನಿಸಲು ಸಾಧ್ಯವಾಗುತ್ತದೆ. ಆದ ಕಾರಣ ಈ ಹಂತದಲ್ಲಿ ಅಮಲ್ದಾರಿಯನ್ನು ಅರ್ಜಿಯನ್ನು ತಿಳಿಸುವ ಕಾರಣ ವಜಾಗೊಳಿಸಲು ಬರುವುದಿಲ್ಲ.
Yes. Enquiry will be conducted.
No, but I have not at all interfered.
Enquiry will be conducted, sir. We do not know. Let us see.
No, but I will file my undertaking before this honorable court. I will file my undertaking that I am not at all interfering.
You have said so even before the trial court.
Yes.
Isn't it?
Yes, madam.
The court is saying, let us see, we'll have to conduct an enquiry. Let them conduct inquiry.
Unless it is because I am staying at Mysore, madam, and I have sold this land. I am not at all interfering in that, madam. We are not at all interfering. But if
You have disposed of that property.
I have disposed of.
Huh?
I have disposed of. And I am not, neither myself nor my purchase, Wendy has interfered in the B schedule property.
So you don't have any other property
No,
there?
no, I don't
Huh?
have, don't have. I don't have no property there, madam. Except this, madam, I have sold it, I am residing at Mysore, I have settled at Mysore,
This property is situated where?
in Hassan.
Awesome.
Hassan, madam, that is Hassan district, village. Chikkamandiganahಳ್ಳಿ. ಚಿಕ್ಕಮಂಡಿಗಾನಹಳ್ಳಿ.
ಬರ್ಕೊಳ್ಳಿ. Issue notice to the respondent. The petitioner is also permitted to serve a copy of the petition along with annexures on the learned counsel representing the respondent before the executing court. Next para. Learned counsel for the petitioner submits that on the basis of admission made by the petitioner herein, who was the defendant in OS number 100 of 2022, the suit was decreed while restraining the petitioner bar defendants from perpetually from interfering with the suit schedule A and B property, perpetually. Full stop. The judgment and decree was passed on 11th of January 2023. Stop. Thereafter, execution petition was filed by the plaintiff in execution case number 33 of 2023, complaining that the petitioner was the defendant before the trial court has again interfered with the suit schedule B property.
B property.
Full stop. The Execution petition was filed on 8/2/2023. Full stop. However, the petitioner sold his property
His property.
on 10/3/2023 and thereafter filed an application before the executing court under section 151 of CPC. Seeking to dismiss the execution petition for the reason that the petitioner has sold his property and therefore there is no question of interference at the hands of the petitioner. Full stop. However, the executing court is of the opinion that the execution case was filed on 8/2/2023 and the petitioner has thereafter sold his property and therefore there is a need to conduct inquiry. Full stop. Next para. The learned counsel for petitioner has made out a prima facie case, since the petitioner has disposed of his property, which is situated adjacent to Schedule A and B property of
Respondent.
the suit. And therefore, there cannot be any complaint that would require to be gone into consequent to the disposal of the property belonging to the petitioner. Full stop. Moreover, it is contended that the petitioner is residing in Mysore
Yes, madam.
and the suit schedule properties are situated in Hassan. Full stop. Next para. Accordingly, there shall be an ad interim order of stay of the impugned order. Dated 4/11/2023 in execution case number 33 of 2023 and all further proceedings thereto till the next date of hearing.
Lordship's leave me alone. Previous matter, I am ready in the matter. Just held up in the traffic, man.
Kariri.
Tomorrow, man.
No.
Like he has to be there, the respondent is, he is not there. The lordship dismiss him or not.
ಏನ್ ಮಾಡ್ತೀರಪ್ಪ ನೀವು?
Tomorrow, man.
That was called at 10:50.
Held up in the traffic.
10:50, sir.
I thought that, my lord, it will take little time. Man. Serial number 8 ಇತ್ತು.
ಇವೆಲ್ಲ ನಿಮ್ ಇಷ್ಟ ಬಂದಂಗ್ ಮಾಡಿದ್ರೆ ಹೆಂಗೆ?
ಇಲ್ಲ, again, man.
You have been taking adjournment of this matter.
ಇಲ್ಲ, ನಮ್ಮ court ಅಲ್ಲಿ
2019 matter, it's coming up for preliminary hearing.
Yes, my lord, because it was the previous counsel, ನಾನು NOC ಹಾಕಿ ನಾನು latest ಅಲ್ಲಿ ಬಂದೆ. Tomorrow, man, I will argue the matter.
ಅದನ್ನ ತೆಗ್ದಾಕಿ.
8, 9, 7.
ಹಂಗೆ ಇರ್ಲಿ. Subsequently, learned counsel Sri S.K. Acharya has appeared and
Apologies, man.
submitted that he was held up due to traffic and therefore praised that the matter may be taken up tomorrow. Full stop. Next para. The order of dismissal is recalled. Full stop. List this matter for preliminary hearing. ನಾಳೆನೇ ಹಾಕೊಳ್ಳಿ.
Please,
Yes.
please.
Serial number 9, Dinakar, MP.
Okay, for petitioner in this matter. Lord, the petitioner herein has filed a suit for partition and separate possession before the trial court. Lord, he also filed a application under 39 rule 102 not to alienate the suitable property. Lord, the trial court has
What?
partition and separate possession. Lord,
Between the family members,
yes,
relationship is not disputed.
yes, madam. Lord, the trial court has
You are the plaintiff.
plaintiff. Madam.
Yes.
Lord, the honorable trial court has allowed the application filed by the petitioner, my lord.
ಏನ್ application?
My lord, out of 39 rule 1 and 2, for seeking not to alienate the suitable property, my lord. Lord, the operative portion, my lord, page number 33. My lord. Thereafter, my lord, after service of summons, my lord, the respondent number 1 and 2 has 1 and 3 appeared before the trial court, my
Yes.
lord, and filed a wakalat.
Yes.
Then, my lord, the respondent number 4
Hmm.
has filed an application order 1 rule 10 before the trial court.
Hmm.
My lord, thereafter, my lord, the petitioner has filed an objection and
Applicant,
respondent number 4, my lord.
order 1 rule 10
Yes, my
for impleadment.
implement.
Ah,
My lord, thereafter, my lord, the trial court has allowed the application filed by the respondent number 4, my lord. For that reason, my lord, the petition before this court, my
Ah.
lord, my respectful submission is this, my lord.
Hmm.
My lord, the respondent number 4 is the one of the family member, my lord. My lord, earlier, my lord, he executed the relinquishment deed, my lord,
that he is the son of defendant.
number 1, my Kempegowda,
Ah,
brother of the petitioner. Brother of the petitioner.
he is the brother of the petitioner.
Yes,
Applicant is the brother of the petitioner.
yes.
Ah,
My lord, he executed the relinquishment deed, my lord, on 16/11/2011.
ah,
My lord, page number 61, my lord, annexure F, my. Shall I read operative?
ah, it has been taken note of.
Yes.
Yes.
ಆದಾಗಿ ಏನಂದ್ರೆ ನೀವು ನನಗೆ ಕಾಸಾ ತಂದೆಯಾಗಿದ್ದು ನಿಮ್ಮ ಮೂರನೇ ಮಗನಾಗಿ ನಾನು ಜನಿಸಿದ್ದು ನಾನು ಒಟ್ಟು ಕುಟುಂಬದಲ್ಲಿ ಇದ್ದದ್ದು ಸರಿಯಷ್ಟೇ. ಆದರೆ ನಾನು ಈ ಹಿಂದೆ ಸುಮಾರು 3-4 ವರ್ಷಗಳ ಹಿಂದೆ ನಿಮ್ಮಿಂದ ಸುಮಾರು 5 ಲಕ್ಷ ರೂಗಳನ್ನು ಪಡೆದುಕೊಂಡು ಪ್ರತ್ಯೇಕವಾಗಿ ನಾನು ಎತ್ತಂಬಾಡಿ ಗ್ರಾಮದಲ್ಲಿ ಶಾಮಿಯಾನ ಸೆಂಟರ್ ಮತ್ತು ಸರಕು ಸಾಗಣೆ ಆಟೋ ವಾಹನ ಪಡೆದುಕೊಂಡು ಅಂಗಡಿಯನ್ನು ನಡೆಸಿಕೊಂಡು ಅಂಗಡಿಯಲ್ಲೇ ಜೀವನ ಮಾಡಿಕೊಂಡು ಇಲ್ಲಿಯವರೆಗೂ ಬಂದಿರುತ್ತೇನೆ. ಈ ಲಾಗಾಯ್ತು ಇಲ್ಲಿಯವರೆಗೂ ನಾನು ನಿಮ್ಮ ಮನೆಗೆ ಬಂದು ವಾಸ ಮಾಡುವುದಾಗಲಿ ಮಾಡಿರುವುದಿಲ್ಲ ಹಾಗೂ ನಿಮ್ಮ ಯೋಗಕ್ಷೇಮವನ್ನು ಸಹ ನೋಡಿರುವುದಿಲ್ಲ.
It's a registered document.
Yes.
It's a registered document.
Registered document.
Ah,
My lord, thereafter, my lord, the petitioner has filed a partition suit, my lord, on 24/1/2017. My lord, when the summons has been served, my lord,
you
and
please read the reasoning,
my lord,
the order. It is pertinent to note.
yes,
Yeah.
it pertain to note here that in present case filed by the plaintiff for relief of partition, further proposed the defendant come up with the present application stating that he is the necessary party who is having share in the issued property and as a son of defendant number 1. For contra, plaintiff stated that proposed defendant relinquished his right by executing the relinquished deed dated 16/11/2017. Further, during the pendency of the suit, defendant number 1 has been died without executing the testamentary document. Moreover, the plaintiff has not stated any testimony of defendant number 1,
Defendant number 1.
father of the petitioner and respondent number 4.
Ah,
My lord, my respectful submission is this, my lord. My lord,
so
the respondent
court wants to consider
Yes.
whether he will have a share in the property left behind by the father. It is true that he has relinquished his rights, but after the death of the father,
Yes,
his portion of the property,
yes,
which he is retained,
yes.
should be further divided.
My lord, my respectful submission is this, my lord. My lord,
Issue
in
notice
the
to
operative
the
portion, my lord,
respondent. Which is that respondent?
R4, my lord.
Issue notice to respondent number 4. The petitioner is also permitted to serve a copy of the petition along with annexures on the learned counsel representing respondent number 4. Next para. Insofar as respondents number 1 to 3 are concerned,
Yes,
learned counsel submits that they are formal parties and no relief is sought against them in the writ petition.
Yes.
Full stop. Therefore, notice to respondents number 1 to 3 is dispensed with.
my lord.
Yes.
Kindly grant a stay, my lord. Otherwise, my lord, I amend the,
Sir, he has a right, sir, that has to be declared.
my lord, relinquishment is right, my lord, annex.
Do you understand what I said?
Yes, yes,
Father died.
yes,
There is a property which he retained.
yes.
That has to be divided further. He has not left behind any will.
ಆ relinquishment deed ಅಲ್ಲಿ all ಅಂತ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ. ನಾನು ಯಾವುದು
ಹೌದ್ರಿ.
ಬರೋದೇ ಇಲ್ಲ ಅಂತ.
That cannot take away his rights in respect of his father's share. Yes.
Serial number 10, Sunil S. Narayan.
Kindly pass over, my lord. Senior engage in all the matter.
Pass over.
Serial number 11,
Yeah, appear for petitioner
Ahmad
lord
Tayer.
through VC lordship.
Huh?
Lordship, pass over lordship.
ಏನ್ ಎಲ್ರಿ ಪಾಸ್ ಓವರ್ ಕೇಳ್ತಿರಲ್ರಿ?
Here end up in total 2 lordship coordinate.
ಹ್ಮ್.
Kindly pass over lordship.
Yes, pass over.
Number 12,
Yes, must apply.
Gadrappa AV,
Not done. Filing statement of objections, counter of evidence.
Yes,
appear for the petitioner.
yes.
As per the order passed by this honorable court, as per Annexure C, the ginger crop that was standing on the land
Ah,
was
yes, yes.
auctioned.
Yes.
Lord, in the last statement,
And
Lord,
he
I had
was
made
the
submission
successful
that,
bidder.
Lord, we have already cultivating the land and we have already sown maize crop, Lord. Photographs, Lord, kindly appreciate. Lord.
You already grown it.
Yes,
So therefore, that also has to be put for auction.
That's all.
Lord, ಇನ್ನು ಮುಂದಕ್ಕೆ, Lord, Lord, it may take time, my Lord.
What?
Lord, kindly appreciate, my Lord. Now I am cultivating it, my
Yes.
Lord. Lord, after cultivation, Lord, that,
You have taken the risk of cultivating it,
my Lord, kindly,
although there was an application filed.
my Lord, kindly appreciate, my Lord, I have produced one.
When did you file the application?
Yes. I have produced a copy of the application at Annexure D. Yes.
22nd of April.
Yes.
We are in the end of August now.
ಹೌದು.
Yes.
ಅಲ್ಲ, ನಾವು ಅದಕ್ಕೋಸ್ಕರ ಇವಾಗ ಕಲ್ಟಿವೇಟ್ ಮಾಡ್ತೀವಿ.
ಅದೇ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ?
Yes.
Again, the same principles will have to be applied. What took place in the previous year?
My Lord, annexure R3 may kindly be seen, my Lord. That is the previous.
What do you want now, sir?
My Lord, I would only like to emphasize before this honorable court that in the earlier round, when I approached this honorable court in a writ petition 12956/2022, this honorable court, my Lord, taking note of the reports as well as the material on record, has come to conclusion that I am in possession of the property, my Lord. I am cultivating it, and the honorable court, this honorable court was pleased to direct the parties to maintain status quo with respect to possession. So I am in possession.
All right.
My Lord, later on, my Lord, they have filed an application, my Lord, stating that, my Lord, right of cultivation has to be auctioned. My Lord, the trial court, my Lord, has given reasons, my Lord, that the application filed under 39 Rule 6, my Lord, is not maintainable. Such a right of cultivation, my Lord, admittedly, my Lord, he is not in possession. My Lord, he has filed.
ಬಿಡಿ, ಅದನ್ನ ಬಿಟ್ಬಿಡಿ ಈಗ.
Yes.
Right to cultivation, ಅದು that has the by a flex of time, it is all over now.
Yes.
You are stating that you have cultivated the,
Yes.
what should happen to the crop grown now?
My Lord, crop ಇನ್ನು ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ,
What
ಇವಾಗಿನ.
should happen to the crop grown?
Lord, if that situation, ಆಮೇಲೆ ಅದನ್ನ, my Lord, that liberty may be reserved to them.
I will reserve liberty. You file one more application.
He could not be in possession of the property because he had the right of harvesting the standing crop only. Nothing more than that.
ಸರಿ ಆಯ್ತು.
So therefore,
What should be done?
to say that he cultivated the land is not correct because he could not have
Sir,
cultivated the property.
You are not saying that you have cultivated.
It is me.
Filed an application. You filed an application seeking the rights to
Yeah.
grow the crop.
Correct.
ಈಗ by a flex of time,
Now.
he is on affidavit stating that I have already grown I have cultivated and I have already grown.
No, it is not correct. I am specifically denying he has not cultivated. There is no question of cultivation because he was put in possession of the property only for the limited purpose of harvesting the crop. Only for the limited purpose of harvesting the crop. Admittedly, the property belonging to my party. It is my father's property. I got this by way of succession.
You have filed the objections?
Yes, my Lord, today I have filed.
I have received the copy of the objection.
Filed in the office?
My Lord, now.
ಏನ್ರಿ ಇದು?
Sorry.
ಅಷ್ಟೊಂದೆಲ್ಲ ಟೈಮ್ ಕೊಟ್ರು you want to come and file it in the office, I mean before the court.
Sorry. ಹುಷಾರಿರ್ಲಿಲ್ಲ.
I would only submit before the court that may be accepted and taken into record. I will make my submission on the merits of the case.
Yes.
Please. Property, this plaintiff is Srimati Shankaramma is the plaintiff before this honorable, who is the petitioner before this honorable court. The property belonged to her father. She was the only daughter, and after the death of the father and mother, she became the owner of the property. So therefore, she is the owner. That can't be disputed, and it's also not disputed. Even in the return statement also, it is not disputed. Now the respondent claims that my son had sold the property. He did not have any, in fact, he was addicted to drinks. He was addicted to all vices. Taking advantage, they created a document of sale. It is not a sale and there was no consideration at all. Now, subsequently, within 2 months or 3 months thereafter, he died. unmarried, unmarried and he died. So I am the absolute owner of the property and I got the property from my parents. Now, by virtue of that document, which is illegal and without any authority of law, he cannot claim that he is the person entitled to possession and ownership of the property. Therefore, only I have filed the suit for declaration. Kindly see the prayer I have made, Annexure A. Please permit me to read the prayer that I have made. Kindly go to page 19. And I have stated in the plaint also how I got the property.
Yes.
Please go see the prayer portion. Wherefore, at page 19 I am reading.
Yes.
Wherefore, for the foregoing reason, the plaintiff humbly pray that the honorable court be pleased to pass judgment and declare that the plaintiff is the owner and in possession of the suit schedule property. Declare that the alleged sale deed executed by first defendant in favor of second defendant is not binding on plaintiff. Grant permanent injunction restraining the defendants, their agents, assigns and all persons claiming under them from interfering with the peaceful possession and
Now
enjoyment.
let us read that previous order passed by this court.
Please, now kindly go to annexure. T is the order passed by this honorable court.
Yes.
It starts at page 27.
Yes. Paragraph number 5.
Yes, a perusal of the material and record will indicate that there are several contentions issues and disputed questions of law and fact and arise for consideration between the parties, which would necessarily have to be decided only after full-fledged trial. However, in the earlier round of litigation, writ petition number 12,956 of 22, this court issued several directions in order dated 12/9/23. It is also seen that the parties are at loggerhead with each other and are not able to see eye to eye, and question of inter se action in the facts and circumstances of the instant case would not arise. However, in order to ensure that ginger crop which is ready for harvesting is not wasted or damaged and that the yield is auctioned, I deem it just and appropriate to dispose of this petition by setting aside the impugned order and consequently dispose of IA number 4 by directing that a court commissioner to be appointed by the trial court to conduct harvest of the ginger crop and to sell the same in a public auction with cooperation and coordination of the petitioner and the respondents who shall ensure that no law and order problem would be created during the process and issue further direction in this regard. In the result, I pass the following order.
Yes.
The petition is hereby disposed of. Impugned order dated so and so, passed by so and so, is hereby set aside. IA number 4 filed by the petitioner, that is, the petitioner is the petitioner before this honorable court in the present petition. Plaintiff stands disposed of directing the trial court to appoint a court commissioner for the limited purpose of harvesting and selling the ginger crop by way of public auction in the open market. The commissioners who appointed by the trial court would conduct harvesting of the ginger crop and sell the same in a public auction with cooperation and coordination of the petitioner and defendant number 2 and 3, both of whom shall ensure that said work of the commissioner shall be carried out without any impediment, obstruction, or objection from anyone else and will not create law and order problem at the scheduled property. Immediately upon court commissioner selling the ginger crop by auction, the commissioner shall deposit the same proceeds before the trial court, who shall invest the same in a nationalized bank, and the same would be subject to the final outcome of the suit. Liberty is reserved in favor of the parties to file other applications before the trial court, which shall consider and pass appropriators on the same in accordance with law. All rival contentions of
Which is that order of status quo you were talking of?
My lord, I have
One
produced
more
it,
thing,
I have produced it
one minute.
at annexure
I request my friend, just wait.
R3.
Now there, after this order was passed by this honorable court, the trial court placed the matter for appointment of a commissioner and a commissioner was appointed, but none of them came forward to purchase the right of harvesting the ginger crop. Then we filed an application before this in the High Court in this very writ petition, and this honorable court by order, that order is not produced, but I have made the specific governments in the writ petition. Kindly permit me to read that governments. Please go to page 9, paragraph 7.
Yeah, the 12th of September 2023, na?
4th of February 2014, 24. The challenging the order dated 23/1/24, page
ಇದು ಹಳೇದಿತ್ತು.
Page 9, writ petition, I am referring to the writ petition.
Page?
Page 9, paragraph 7. Paragraph 7 at page 9. Challenging the order dated 23/1/24, passed on IA number 4 in OS number 64 of 2019. Petitioner filed writ petition 3409 of 2024. After
Annexure C ಆದ್ಮೇಲೆ thereafter.
ಅಲ್ಲಿ
On the application filed by the petitioner by order dated so and so, the honorable court modified the order.
Yes, modified the order and directed the trial court to auction in between the parties. Now, the defendant in the suit, who is the respondent in this writ petition, he bid for 36 lakhs rupees and he purchased the right of action, harvesting the crop.
Yes.
That is how he came in possession of the property by reason of auctioning of the right of harvesting the crop only. After harvesting, now the land was left fallow. He could not say that I am entitled to cultivate the property. How can he cultivate the property unless there is some direction or order issued by the trial court? That is one aspect of the matter. Now, the rainy season has set in. The cultivation has to be done.
So therefore, he filed the application.
Therefore, I filed an application. Kindly see the prayer that I have made. In the application I filed. It's at page 33. Page 33, Annexure D. ಈ ಕೂಡ ಹಾಜರು ಮಾಡಿರುವ ಪ್ರಮಾಣ ಪತ್ರಿಕೆಯಲ್ಲಿ ಕಂಡ ಕಾರಣಗಳಿಗಾಗಿ ಘನಕೋಟೆನವರು ಕೃಪೆ ಮಾಡಿ 2024-25 ಸಾಲಿನ ಬೆಳೆಯನ್ನು ಬೆಳೆಯುವ ಬಗ್ಗೆ ಉಭಯ ಪಕ್ಷಗಾರರ ನಡುವೆ ಹರಾಜು ಮಾಡಿ ಹರಾಜಿನಲ್ಲಿ ಹೆಚ್ಚಿನ ಬಿಡ್ ಮಾಡಿದರೂ ಸದರಿ ಸಾಲಿನ ಉಳುಮೆ ಮಾಡಲು ಅನುಮತಿ ನೀಡಿ ಆದೇಶ ಮಾಡಬೇಕಾಗಿ ವಿನಂತಿ. This is the prayer that I made. And kindly go to page 34.
So that application was dismissed.
That application has now been dismissed by the trial court. So I am before this honorable court. My submission before this honorable court is, there is no dispute even in the written statement that I got the property from my father and mother.
Please read the operative portion, the last paragraph 12.
Yes.
Of the impugned order.
Impugned order. Now, I will read the order, but before that, may I request the court to kindly permit me to read page 47. Page 47.
Yes.
Fourth line from top of that page 47. As per the guidelines dated 14/2/24 and 15/3/24, permission were given to auction for harvesting and selling the ginger crop, and auction was conducted by this court on 26/3/24. As per the highest bid of the defendant number 3 is accepted and grown ginger crop was auctioned for bid amount of rupees 36 lakhs, and said amount was deposited by defendant number 3. The said amount is deposited in State Bank of India, Afikere branch, in the name of the court with renewable interest. It is evident to note this application is filed at the stage of plaintiff's evidence. The trial of this case is not commenced by the plaintiff. At this stage, the plaintiff has filed the application prior to conduct auction. Interest of right of cultivation in the suit
an order of status quo directed by this court. If the court allows your application, it will be contrary to the orders passed by, that is the reasoning.
That is the reasoning.
reasoning.
But I
Yes.
submit before the honorable court.
Yes,
Kindly once again see the prayer that I have made in the application.
yes,
Kindly permit me to read the prayer that I have made.
yes. 2024,
Yes.
24ನೇ
Kindly,
ಸಾಲಿನ,
kindly go to page 33.
yes,
ಈ ಕೂಡ ಹಾಜರು ಮಾಡಿರುವ ಅನೆಕ್ಷರ್ ಡಿ
yes,
ಪ್ರಮಾಣ ಪತ್ರಿಕೆಯಲ್ಲಿ ಕಂಡ ಕಾರಣಗಳಿಗಾಗಿ ಘನಕೋಟಿನವರು ಕೃಪೆ ಮಾಡಿ 2024-25ನೇ ಸಾಲಿನ ಬೆಳೆಯನ್ನು ಬೆಳೆಯುವ ಬಗ್ಗೆ ಸೊ ರೈಟ್ ಆಫ್ ಕಲ್ಟಿವೇಶನ್ ಅಂಡ್ ಗ್ರೋಯಿಂಗ್ ದ ಕ್ರಾಪ್ ಫಾರ್ ದ season
Therefore, now you read
2024-25.
rule 6.
Yes, I will read rule 6. Power to order interim sale. The court may, on application of any party to a suit, order the sale by any person named in such order and in such manner and on such terms as it thinks fit of any movable property being the subject matter of such suit before judgment in such suit, which is subject to speedy and natural decay, or which for any other just and sufficient cause it may so desire to have sold at once. Right. It refers to movable property. There is no doubt.
Sale of movable.
Right. Sale of movable property, which is subject to
Decay. Yes.
Now, in the case of the present situation, the status quo is such a vague word. I can say that I am in possession of the property.
Well, that is
No,
one thing. That is one thing. The observation of the court is this provision will not enable you to seek
I understand.
right of cultivation.
I understand what is passing in the mind of the court. But my submission is this. This order of status quo gives rise to the mighty person who is mighty and having men at his power and money. He can say that I am in possession of the property. That will lead to
No. Status
both the
quo-
parties clashing
status
each
quo
other.
ಅಂತಂದ್ರೆ both of you maintain status quo.
Therefore,
Don't
the question
do
is this.
anything.
Therefore, the question is after harvesting the ginger crop, who can be in possession? I say that I am in possession because I am the owner of the property. He says that he is in possession because he says that I have purchased the property from defendant number 1.
Yes.
Now that is a matter to be decided by the trial court. True. Now all that I am submitting before this honorable court is when both parties claim that I am the owner and I am in possession of the property, which cannot be decided at this juncture, what should happen to the land? Somebody will have to cultivate and grow the crop. No prejudice is going to be caused if this procedure or the method is adopted by selling the right of cultivation, growing the crop, taking the crop for that season.
Yes.
The interest of both the parties will be guarded. Otherwise, what happens is both the parties will clash each other, taking law into their own hands, and we do not know ultimately what
And
will
according
happen.
to you, he has taken law into the hands now and he has grown it without
No,
permission.
he has not grown anything at
That
all.
is what he is
That is what he
contending
says.
in the application.
That is in the affidavit, the objection he says. In the objection he says, yes. How can you cultivate it? Because he was granted permission to harvest the crop only.
That is another question.
After
We will
harvesting.
come to that question later.
No, I will come to that point only.
Yes.
After harvest, what is the position of the defendant? What is the position of the plaintiff vis-a-vis the property in question? Nobody can claim to be in possession of the property having regard to these circumstances. So therefore, land cannot be permitted to lie fallow. Some crop is required to be grown. Whether I grow it or he grows it, it is immaterial because the interest of both the parties is required to be safeguarded. How the court is going to safeguard my interest? How the court is going to safeguard the interest of the defendant? The only method by which the interest of both the parties could be safeguarded and nobody is going to be prejudiced is put the right of cultivation between the parties by public auction. Supposing I say that I will purchase for 10 lakhs. He says that I am purchasing for 15 lakhs. That's very well. Whoever is the highest bidder, he will take the permission to cultivate the property and grow the crop. It will safeguard the interest of the plaintiff as well. In case I succeed, I will deposit the amount. it will safeguard the interest of the defendant as well. No prejudice is going to be caused in the method that we are seeking for. But the learned trial judge proceeds on very, very technical reason, stating that Order 6, Rule 6 of Order 39 is not the procedure, right? It may not be, but court has got inherent power. Court has got inherent power, and the power of the court is not restricted merely because I quote a wrong provision of law. Interest of the parties who are litigating before the court is required to be safeguarded. Otherwise, it is impossible. Supposing this year he says, no, I have cultivated. Next year also he will do the same thing. Then how I am going to be the interest I have got is protected. So therefore, it is only by this method, and only this is the method that could be adopted in the facts and circumstances of the case. Order of status quo does not say that the petitioner is in possession of the property or the respondent is in possession of the property. It's a question of interpretation by any of the parties in the manner which suits them. So my submission before this honorable court is the only method that could be adopted is put the right of cultivation and growing the crop. It is only a seasonal crop. Let the person who offers the highest bid take the right of cultivation, harvest the crop, then the land will be vacant. For the next year, same thing will have to be done. Otherwise, it is not possible to safeguard the interest of either of the parties.
Yes.
That is the submission I am making.
How did you proceed to grow the crop?
My lord, kindly appreciate, my lord, the earlier order passed by this honorable court, my lord, the impugned order also the court has referred. There is another order, my lord, writ petition, adon copy tagitkondu. Adali, page number 3 of the order, I'll just read it, my lord, it's very brief. This court by order dated 14/2/2023 passed interim order, which read as follows. The learned counsel appear for the petitioner defendants submits that defendant number 1 has executed registered sale date on 13/11/2018. Next paragraph. It is further submitted that on the basis of the order passed in OS number so and so, the sub-inspector of police, Gansi Police Station, Arsikere Taluk, Hassan District, has made out a report to the civil court that the defendants are admittedly in possession for the past 4 to 5 years and have been growing various crops. Peruse the report dated so and so. Subject to further consideration in the light of the report of the police authority and also noticing the dispute that there was a sale deed, registered sale deed in favor of the defendant number 2 by defendant number 1 on 13/8/2018, and the assertion of the petitioner that khata of the revenue record stands in the name of the defendant number 2 remains unrebutted, there would be an order of parties to maintain status quo regarding the portion as on date. My lord, this court was fine, and this observation, my lord, was further upheld, my lord. This court, taking note of the police report and taking note of the registered sale deed executed by defendant number 1 in favor of defendant number 2 dated so and so, directed the parties to maintain status quo regarding portion as on the said date. My lord, hence, my lord, my lord, the interim order, my lord, was followed in the final order also, my lord. And kindly appreciate, my lord, in the year 2016, my lord, the revenue records after a partition, my lord, I also concede, my lord, there was an unregistered partition between the petitioner herein, his son, that is defendant number 1.
We will not go into those aspects.
Yes.
There are certain directions given by this court.
Yes, my lord, I am in possession.
Only for the purpose of selling or harvesting the crops already grown.
Yes, my lord. My lord, that is.
How did you proceed to cultivate the land without taking permission from the court?
My lord, we
already know what has happened last year.
My lord, yes, my lord.
Without taking permission of the court, and in the light of the application filed by the other side, asking for right of cultivation, how did you proceed to cultivate?
My lord, in view of the order passed by this honorable court, my lord, I just read, my lord, I am in possession. My lord, I have been.
Sir, it only talks of maintaining status quo. My lord, it has not given you right to cultivate.
My lord, kindly appreciate, my lord, when this order was passed, my lord,
Right of the fact that you had grown the crops.
Yes, my lord, earlier also.
It was directed to put to auction.
Yes, my lord, earlier also.
The court could have said, anyway, you have grown it, let him harvest.
That circumstances.
The fact that you claimed to be in possession, you claimed to have grown the crop. Despite that, there was a direction to auction the harvest. Why?
my lord,
There was a need to decide as to who is the true owner of the property.
true, my
In
lord.
the light of all this, how did you proceed to cultivate without seeking the permission of the court?
Lord, in view of the
You
order.
have taken the risk, and this time also it will be the same thing. Anyway, this application has become infructuous by efflux of time, and I will dispose of the writ petition, and I'll permit both of you to file necessary application.
My lord, I
Yes,
would
perfect.
request this honorable court, my lord, earlier also, this honorable court directed to dispose of the
I would,
suit, my
I
lord,
would
at
only,
earliest.
I would.
This time, you are not going to get that benefit because you have violated the orders of the court. You have not taken permission of the court before commencing to grow the crops.
My lord, kindly
Because
appreciate, my lord.
You are clearly in violation of the orders of the court.
My lord, they mentioned.
Anyway, that is not the issue now. I'll consider the impugned order. I'll pass orders. Berkeley.
I would only submit before this honorable court, since the honorable court is expressing the view, I would submit that interest of both the parties is required to be safeguarded, and for that purpose, right, liberty may be given. I will file one more application before the trial court seeking for right of harvesting, the public action of harvesting. I will file one more application. I will file one more application, no difficulty. But my submission before this honorable, as the honorable court was pleased to observe, without seeking the permission of the court, he cannot under any circumstances contend before the court that I continue to be in possession of the property or I cultivated the property. He cannot. He cannot. And please see, in the light of the admission made in the return statement, admitting that this property, subject property, is the property belonging to my parents, and they have died after the death of my parents, I have succeeded to the property.
Lord, they have colluded, they have sold the property in
Yes,
my
but
favor. Lord, after
you-
selling the property in
You
my favor, my lord, they are
intoxicated him
doing
and
it.
got a
Let
document.
us not go into all those aspects now. Not necessary. That has to be decided by the court. And you did not wait for any decision. You did not file any application seeking permission. You went ahead. You will have to suffer. The petitioner, plaintiff, in OS number 64 of 2019, is before this court, aggrieved of the rejection of the application filed in IA number 6. Whereby the plaintiff petitioner sought for the assignment of the right of cultivation of crops on the suit schedule property for the year 2024-25. Full stop. Next para. It is not disputed that on the previous occasion, this court in WP number 12956 of 2022 and WP number 3409 of 2024 passed certain orders directing the parties to maintain status quo in respect of the suit schedule property as on the date of the order dated 14/2/2023. And thereafter, in WP number 3409 of 2024, by order dated 14th of February 2024, this court directed the trial court to appoint a court commissioner for the limited purpose of harvesting and selling the ginger crop by way of public auction in the open market. Full stop. It has been clarified in a subsequent order dated 15/3/2024 that the right of harvesting
Shall be made between the parties.
and conduct of auction shall be inter se between the parties before the court. and not by way of a public auction. Full stop. Next para. The plaintiff filed an application invoking Order 39 Rule 6 of CPC on 22/4/2024. Seeking right of cultivation for the year 2024-25. By putting the rights to auction. Full stop. However, the trial court has rejected the application on the ground that there is an order of status quo passed by this court, and therefore the court will not be in a position to permit either of the parties to proceed to cultivate the land in question. Full stop. It was also noticed that Rule 6 of Order 39 cannot be invoked for seeking permission to cultivate the land during the pendency of the suit. Full stop. It was held that Rule 6 of Order 39 pertains to the directions which can be issued by the court for sale of movable property, which may also include crops grown over the suit schedule property, which may be subject to decay. Full stop. However, the present application, the instant application, was seeking a right to cultivate, which was not available in the said provision. Full stop. Next para. Objections have been filed at the hands of the respondent, defendant, along with copy of a receipt showing that the respondent, defendant, has purchased seeds. Seeds. Ginger seeds.
ಅಲ್ಲ ಇದು ಮೈಸ್ ಸೀಡ್ಸ್ ಮೆಕ್ಕೆಜೋಳ ಮೈಸ್ seeds to the particulars NK65 ಅದು it's a particular type of breed.
ಏನಂತ ಬರ್ದಿರಾ ನಿಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ?
ನಾನು ಹೇಳಿದೆ.
That is on 6-8. Only
paragraph 8
is filed.
Paragraph
8, my lord. It is submitted that the respondent herein is in exclusive possession and cultivation of the suit schedule property.
Mais.
ಹೌದು.
Mais ಅಲ್ರಿ.
ಜೋಳ ಹೌದು ಸ್ವಾಮಿ ಅದೇ ಬರುತ್ತೆ.
ಮೈಸ್ ಅಂದ್ರೆ ಇಲಿ ಕಣ್ರಿ.
ಅಲ್ಲ. ಜೋವರ್.
ಆಯ್ತು, ಜೋವರ್ ಸೀಡ್ಸ್ ಅಂತ ನಾಲ್ಕು. And photographs showing the cultivation of the land and sowing of seeds.
This is after the filing of the writ petition and after service of notice.
However, it was pointed out by the learned counsel for petitioner that the receipt is dated 6/8/2024. And therefore, It is clear.
Under 94E, we have filed a application under section 10 and that is still pending till date and that is taken as one of the IA, that was IA number 4. New order sheet al nodidre swami alli they say that for objections it is IA number 5 and IA number 6 anta. So it is 6, that was 94E mele they may pass an order stating that by the trial court without giving an opportunity to the plaintiff to make his submissions or objections.
What did you claim in the suit earlier filed?
Earlier, we were claiming for permanent injunction.
On what ground?
From not evicting the premises.
On what ground?
Huh?
What ground? That you were in lawful possession?
Yes,
Or were you claiming to be owners of the property?
We were not claiming.
So you were claiming to be in lawful possession.
Lawful possession.
And therefore, direction that you can be evicted only in a manner known to law.
Oh.
Huh?
Oh.
So you continued as a tenant.
Yes. Tenant, yes, ma'am.
Yes.
At the time of, without considering the fact or giving an opportunity, there was an order which was passed.
Now they have taken action in accordance with law. They have filed a suit for eviction.
On 2020. But this order is dated on 10th July 2023. Only then we filed applications seeking that
10th of July 2023.
Permanent injunction. Regarding permanent injunction, we have obtained the order from the same court.
Sorry.
After that, we have filed an application.
So even before that, a suit has been filed.
Yes.
For eviction.
Yes.
What is wrong?
The same cause of
Anyway,
action.
we are not concerned with that one. The application was filed by the plaintiff.
Yes.
Seeking directions to you to deposit the arrears of rent.
Arrears of rents.
ಏನಾಗಿದೆ ಇವಾಗ?
Mellets ನಾವು ಬಾಡಿಗೆ ಕೊಡಕ್ ಹೋದ್ರೆ they are not taking into
Allowed. The
consideration.
defendant is hereby directed to deposit rent amount of rupees 4,80,000 before the court.
Yes. Mellets, so we would like to say that the proceedings of the trial court has to consider the application filed under section 10 with regarding or give an opportunity to the our parties who are present before this court to make the representation that because of the same cause of action hingagide anta it is to be stayed and
ಏನು cause of action? There is a
because
decree.
there arises
You have obtained a decree that you shall not be dispossessed without due process of law. Now the owner has gone before the court seeking eviction, which is also a due process of law. What is wrong in that? Anyway, we are not concerned about that. We are concerned regarding the application filed by the plaintiff seeking directions to you to deposit the arrears of rent. What is wrong in the order?
Mellets, just page number 115 of ink page number 115 of annexure J, Mellets. We had first filed an application under section 10 of the CPC
Present suit.
6/12/2023 without
Same is against the principle of res sub judice.
res sub judice. Same cause of action where the trial court has again passed the order and helbuttu we are claiming.
ఏంటి same cause of action? No?
Because they are in peaceful possession and not to interfere with the possession of their said scheduled property. Amele we will pay the rent and the rent kodak hodrano they are not taking it by hand, my lord.
Direction ಇದೆಯಲ್ಲ ಕೊಡಿ. There is a
Court
direction.
ನಾವು deposit ಮಾಡ್ತೀವಿ.
ಮಾಡಿ. That the direction is to deposit before the court only.
20% deposit ಮಾಡ್ಬೋದು, my lords.
ಅವೆಲ್ಲ ಇಲ್ಲ.
Because the IA is
The
pending before the
defendant is
court.
hereby directed to deposit rent amount of rupees 4,80,000 before the court.
My lords, 20% we could deposit
Why?
before the court because because the IA is also pending and they are in hard difficulties ಆಗಿರೋದ್ರಿಂದ. And what IA we have filed, they have not disposed of or they have not shown any till date it is pending, my lord. So they have not even disposed of the IA which we have filed. And it is
That
an
application
expiry
is
order.
bound to be dismissed, sir.
But anywhere it is not mentioned even in
They
the.
are not
order.
taking law into their hands. They have approached this court seeking eviction, which is also a due process of law.
So you got a permanent injection.
ಎಷ್ಟು ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀರಾ?
23.
ಎಷ್ಟು ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀವಿ?
20%.
20%.
25.
25% ಮೇಲೆ.
50% you'll have to deposit
Before the course.
in 4 weeks time.
2 months.
2 months.
4 weeks time. Again, another 4 weeks for the remaining 50. So within 2 months, you'll have to deposit. Workers. Issue notice to the respondent. The petitioner is also permitted to serve a copy of the writ petition. Next para.
Before the court. Court ಮುಂದೆ
Huh?
depart.
Before the trial. The learned counsel for petitioner submits that
And also give the direction to the considered.
the impugned order has been passed by the trial court, while allowing the interlocutory application filed by the respondent plaintiff under section 151, read with section 94(e) of the Code of Civil Procedure, while directing the petitioner defendant to deposit a rent amount of rupees 4,80,000 before the court. Stop. However, no time frame is fixed by the court, and moreover, an application filed by the petitioner defendant in IA number 4 under section 10 of the CPC is also pending consideration at the hands of the trial court. We'll stop. It is the contention of the petitioner that the respondent plaintiff could not have filed the suit having regard to the admitted fact that the petitioner defendant herein had earlier filed OS number
108 of 2021 minutes.
ಎಲ್ಲದು
Page number 26. Annexure B. Annexure
Annexure
B.
B, page number
Text filter. Annexure B.
26.
26.
in OS 108 of 2021. Seeking permanent prohibitory injunction to restrain the defendant from evicting the plaintiff from the suit schedule property without due process of law. Full stop. Learned counsel submits that the said suit was decreed by the court on 10th of July 2023, while directing the respondent herein and restraining the respondent herein from dispossessing or evicting the petitioner herein from the suit schedule property, unless due process of law is followed by the respondent. Full stop. Next para. Nevertheless, when this court expressed that it is not satisfied or that no prima facie case has been made out by the petitioner, the learned counsel for petitioner submits that reasonable time may be given to the petitioner to deposit the amount as directed by the trial court. Full stop. Next para. Accordingly, the petitioner is directed to deposit 50% of the amount as directed by the trial court within a period of 4 weeks from today. Full stop. The remaining 50% shall be deposited within 4 weeks thereafter. Full stop. Yes.
Scheduled property till the amount is cleared up, they will clear up within
Huh?
8 minutes, not to evict the suit scheduled property.
I have given you time for 4 weeks to deposit. Please deposit.
No.
How can the trial court proceed in the light of the orders passed by this court?
Much of-
Yes.
Serial number 14 is be noted. Please.
The suit for declaration and injunction filed by the respondent stating that I have encroached upon 1.5 feet of the property. That suit was filed by respondent, and then we filed the written statement. Immediately after filing the written statement, they filed an application under order 26 rule 9 for appointment of the court commissioner. And court has allowed that application, my lords, even without framing the issues, without even, there is no evidence has not yet commenced. All of a sudden, the court has allowed the application stating that to end and shorten the litigation between the parties, so the application.
There is one judgment of His Lordship Justice Kumar,
Please, my lords.
which uses the same words to cut short the proceedings. If the court feels a court commissioner can be appointed,
Please.
to elicit information, it is permitted to do so at any stage.
But here he says that I have encroached upon the 1.5 feet of the property. But the property which was purchased by me is in the year 1972. He demolished his own house, the respondent demolished his house, and he has constructed without leaving any setback, my lords. And now I am putting up construction by leaving 1 feet. Now, since there is no any evidence, my lords, to prove
ನಿಮಗೆ
that.
ಏನು ಹೇಳ್ಬೇಕು ಅನ್ಸುತ್ತೋ ಕೋರ್ಟ್ ಕಮಿಷನರ್ ಮುಂದೆ ಹೇಳಿ, he will record it, he will go and place it before the court.
My lords, it is
The
at the
entire exercise is only to elicit the factual information.
Yes, my lords,
What is wrong?
no, my lords, it's at the premature stage.
a-
At least issues has to
ಅದಕ್ಕೆ
be.
you please go through that order. It can be done at any stage ಅಂತ ಹೇಳ್ತಾರೆ. If it is going to reduce the time of the suit, it can be done ಅಂತ ಹೇಳ್ತಾರೆ.
No, it's a burden on the respondent, my lords. It's a prayer, my lords.
Anyway, instructions are to be given by both the parties.
Yes, my
To
lords.
give instructions.
My lords,
What is
here,
wrong in the order?
my lords, the wrong in the order is that, my lords, at least they should be reasoning, my lords, why this application
If
should be
the
allowed.
provision says it can be done only after certain stage, you please point out.
There is no any such in the provision, my lords, but it's
Issue
settled.
notice to the respondents.
Lords, I sought for stay of that.
ಏನು ಆಗಲ್ರಿ, it is better. This will all help in reducing the time to decide the case.
Lords, at least if, my lords, it is nothing but collection of evidence by the respondent, my lords, if at all, if the commissioner is appointed.
Provision is there, sir, in CPC.
Yes, my lords,
This
provision
type
is
of,
there. They should have to prove their.
this type of an argument has also been considered by another coordinate bench. The provision itself is to collect evidence.
Yes, my lords, it is for
Then
collection of.
How
the-
can you say no, evidence cannot be collected?
My lords, it is burden on the respondent to prove his case, my lords, that is there, there is a encroachment.
But if
When
there
he
is
himself
certain
is not
factual information that can be collected to decide the case, why there provision then? If according to you, only court can do it, no one else can do it, then why is the provision mentioned in the CPC?
My lords, after leading evidence, my lords, after leading evidence.
ಇಲ್ಲ
then-
sir, ಆತರ ಎಲ್ಲೂ ಇಲ್ಲ. There is no such procedure which says you do it only after this stage and don't do it after this stage. ಅವೆಲ್ಲ ಏನು ಇಲ್ಲ.
May be permitted to serve a copy on the trial court.
Petitioner is also permitted to serve a copy of the writ petition. Yes.
15 TCS Girao. Plaintiff's writ petition. Kindly see for one moment. Amendment application is rejected. I'll just point out. ಯಾವ್ದು case ಯಾವ್ದು order.
Before that, I'll.
ಯಾವ್ದು case ಯಾವ್ದು order.
ಯಾವ್ದೋ case ಯಾವ್ದು ಆಡಲ್ಲ.
1 minute, not 1 minute, for one moment, for 1 minute. The amendment application for my lordship's perusal is at 71.
Huh?
71 is the amendment application. It's just a 2-para amendment application.
Page number 71.
71.
Who filed the application?
Plus plaintiff has filed it.
You are the defendant.
No, no, I am the plaintiff, plaintiff.
You are the plaintiff.
Suit for
Ah.
partition, intra-family suit.
2006 suit.
Yes, Manoj. Now, Manoj.
This application is filed.
Even earlier to that, ಇಲ್ಲಿ court ಇದ್ದಾಗ ಹಾಕಿದ್ suit ಅದು, ಅಲ್ಲಿ transfer ಆಗಿ, transfer suit.
Point out what I had to make.
Application is filed in
Manoj.
February 2024.
Yes, Manoj. What happens, Manoj says, one of the defendants pass away. She executes a release deed in favor of plaintiff. That is, Manoj, pendent litigation this week. That is a fact which is brought to the notice of the court. Kindly see, Manoj, this is what is supposed to be brought. Manoj, that
Released it when, executed when?
But this is, she passes away somewhere in the year 22. Not this is brought to the notice of the court, not immediately saying that there is a release date and that share is to be allotted to in my favor. This is what is sought. It's a subsequent event. Now kindly see, Manoj, if the trial court goes on the merit of this matter, I am all right. Your lordship may come down to the reason. 15 is the impugned order, Manoj. 20 the reason start. Manoj, 20 the reason starts at 4 lines. The 5th line from the top of Manoj, para 7. At this belated stage, the plaintiff has filed the present application for amendment. I hope, my lordship. I'm sorry, it is 20 minutes is the reason. 20 minutes. I hope your lordship got it.
Yes.
5th line from the top minute. At this belated stage, the plaintiff has filed the present application for amendment of plain to insert para 6 to 8.
Item.
Para 6 to 8. Where is it?
27 I filed objections to 27.
Minutes, sir. Kindly see what is the.
Kindly go through this.
Please,
I
Page
instructed
17, I
my,
don't want to be wrong on fact.
I requested my colleague at Devanali to obtain certified copies of the IS.
Please,
I may be permitted to file my objections. I will file my objections.
I can't be.
The objections file ಮಾಡಲಿಲ್ಲ ಅವರಲ್ಲಿ. Application 26 file ಮಾಡಲಿಲ್ಲ.
Where is that application?
Minutes,
Application copy ನನ್ನ ಹತ್ರ ಇಲ್ಲ ಸ್ವಾಮಿ. ದೇವನಹಳ್ಳಿಗೆ ನಾನು ಹೇಳಿ ಕಳಿಸ್ತೀನಿ ಅಪ್ಲೈ ಮಾಡಿ. Certified copy ನ ತರ ಕೇಳಿದ್ದೀನಿ.
ಹಾಗಾಗಲ್ಲ ಒಂದೇ ಒಂದು.
2018 I is not tender for cross examination. One after another application is
wrong on
filed.
facts.
Yes.
71, your lordship may see it is numbered as IA number 26, not by me, by the court. Now, my lordship may come down to, not page 17 for a moment. What is the orders passed on IA number 26?
Huh?
17 ನಲ್ಲಿ ತಾವು ನೋಡಿದ್ರೆ running page
17.
Yes, not Roman 26, IA number 26. Now kindly come down to page 71. Minutes. These, I mean, I may be wrong on law or I may be wrong on interpretation. Minutes.
Which is that other application you are talking about?
Kindly, minutes. This
He has filed 2 applications for amendment.
Which is the other application?
IA number
ನನ್ನ ಹತ್ರ ಸದ್ಯಕ್ಕಿಲ್ಲ ನಾನು ಅದಕ್ಕೆ ಇನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡಿದ್ದೀನಿ ಕೊಡಕ್ಕೆ.
Filed 2 applications. for
Yeah,
amendment.
yeah, he has filed 2 applications. In my IA number 27,
an order passed on IA number 26.
in IA number 27, I have taken same
Filed one
contention.
more application seeking amendment.
Minutes, I shall have to verify that aspect. Minutes. I am
That's
not.
what he is saying.
I am not aware because there is another advocate who is appearing. Kindly see minutes, but by what I see, running page 17 and 71 for a moment. 17 and 71. Your lordship will see 26 Roman and 26 numbered on 71. This is what I believe minutes is, this is 26 and that is also 26. And now minutes, what is happening?
Amendment application ಒಂದು 4
Now, what is
applications ಇದೆ.
happening, minutes is.
This is your objections to
To IA number 26.
IA 26.
But IS 26 is different, not this. Through IA 26, he wanted to insert four items of properties. ಇಲ್ಲಿ ಬೇರೆ ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. Even this application is not maintainable because along with application is not produced that release date.
There is a memo file, sir. There is a memo file, sir.
If at all there was any release date, he should have produced that. Moreover, mother has no share to release, execute
Because
release date.
I really am not able to understand his line of arguments on this.
No, he has produced a copy of objections that were filed before the trial court.
Please, minutes.
As regards IA number 26.
27.
26.
I'll just have it.
ಇಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿರೋದು 26 and the same type of items and survey number ಅದೆಲ್ಲ what is found in the impugned order, same thing is found here. Therefore, your contention is,
yes,
there were 2 applications filed by you.
Very well, fine.
This pertains to the other application.
For a moment, I will accept he is right. For a moment, I will.
In that application,
for a moment, I will accept he is right.
these were the
For
items.
a moment, I will accept he is right.
Yes.
Then, minutes, what should be the? I'm just pointing out to myself, minutes, not against anyone. 17 nal tavu nodudre. It runs on IA number 26. Minutes, if we were asked to argue on IA number 26.
ಏನೋ ಒಂದು ಸ್ವಲ್ಪ
ಏನಾದ್ರು ವ್ಯತ್ಯಾಸ ಆಗಿದೆ ಅಲ್ಲಿ.
It may also be read as 27.
Very well, very well.
I see it.
Very well, minutes.
So therefore,
very well.
We'll have to get information whether there were 2 applications filed by you.
Very well.
And
I have
this order pertains to other applications.
File now ತಾವೇನಾದ್ರು ನೋಡಿದ್ರೆ ಫೈಲ್ ತಾವು ನೋಡಿದ್ರೆ ಫಾರ್ ಇನ್ಸ್ಟೆನ್ಸ್ ನಾನು ತಮ್ಮ ಒಂದೇ ಒಂದು ನಿಮಿಷ ಪ್ಲೇಂಟ್ ಅನ್ನು ತೋರಿಸ್ಬಿಡ್ತೀನಿ ಯಾವ ಪರಿಸ್ಥಿತಿಲಿ ಇದೆ ಅಂತ. Annexure C 29 ಇದು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಆಫ್ ದಿ ಪ್ಲೇಂಟ್. This is the, I mean,
2007 tender for cross examination. ಏನಾದ್ರು ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾರ,
ಹಾಗೇನಾದ್ರು ಇದ್ರೆ
ಏನೋ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾರ.
ಫೈಲ್ ರೀ ಏನೋ ಒಂದಲ್ಲ ಇದ್ರಲ್ಲಿ. ಐ ವಿಲ್ ಪಾಯಿಂಟ್ ಔಟ್ ದ ನಂಬರ್ ಆಫ್ ಅಪ್ಲಿಕೇಶನ್.
ಆಲ್ರೆಡಿ ಪಾರ್ಟಿಷನ್ ಆಗೋಗಿದೆ. ಪಾರ್ಟಿಷನ್ ಆಗೋಗಿರೋದಕ್ಕೆ ಅವರು ಇನ್ನೊಂದು ಸೂಟ್ ಹಾಕೊಂಡಿದ್ದಾರೆ.
There are 2 suits which are pending and minutes they were running on the court file. Minutes, because there were additional courts established in Devanhalli, minutes, the 2 suits got bifurcated. Now there is a miscellaneous pending.
Bifurcated ಅಲ್ಲ, ಸಿಸ್ಟರ್ ಇನ್ಸಿಯೇಟ್ ಮಾಡಿ 94 ಅಲ್ಲಿ ಪಾರ್ಟಿಷನ್ ಆಗಿದೆ.
1 minute.
ಸಿಸ್ಟರ್ ಮತ್ತೆ ಇವರು ಪ್ಲೇಂಟಿಫ್ ಕೊಲ್ಯೂಡ್ ಆಗಿ ಡ್ರಾಪ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ನಮ್ಮನಲ್ಲಿ ಏನು ಮಾಡಕ್ ಮುಂದುವರಿಯಕ್ಕೆ ಬಿಡ್ತಾ ಇಲ್ಲ.
There is a miscellaneous pending on the file of the district judge. Now, minutes, the defendant wants to read evidence, minutes, divorcing the plaintiff.
Learned counsel, P.S. Venugopala is entered appearance for
Caveat respondent number 3.
respondent number 3. Only one defendant.
No, there are five dependents.
You are entering appearance for whom?
Only 3. Respondent number.
Only 3.
Third respondent. Before trial court, I am appearing for defendant number 2 and 3.
2 and 3.
I undertake to file wakalat for defendant number 2. Respondent number 2
Learned
also.
counsel would also undertake to appear for respondent number 2.
Narayana.
Issue notice to the other respondents. The petitioner is also permitted to serve copies of the writ petition along with annexures on the learned counsels representing the other respondents before the trial court. Full stop. Next para. In view of the confusion as to whether there were 2 applications filed by the petitioner plaintiff before the trial court under order 6/17, probably in IAS number 26 and 27, the entire records of the trial court shall be made available to this court by the next date of hearing. Stop. Release this matter. On 9th of September 2024.
9th ಬೇಡ 9th ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಪೋಸ್ಟ್ ಆಗಿದೆ 8th ಅಥವಾ ಯಾವತ್ತಾದ್ರೂ ಪರವಾಗಿಲ್ಲ 9th
10th of September. Office is directed to secure the entire records from the learned additional senior civil judge and JMFC, Devanalli, in OS number 1759 of 2006. Yes.
16 order passed. Serial number 17. Vinay V.
16, sir.
Serial number 17.
Lords, appear for the petition.
My lord, the petitioners before my lords are the LRs of defendant number 1 in OS number 102 of 2011. My lord, page 82.
Suit for
A partition, my lord. There was a partition and a compromise was arrived at and referred to Adalat. Adalat compromise is effected.
Relationship is not disputed. Relationship is not disputed.
Illa. My lord, compromise is effected, but of course with the Lok Adalat. And matter by way of the Lok Adalat compromise, matter ended. That ended in 2020, page 82, my lords. Page 82. Called in daily Lok Adalat, so and so present. And matter is accepted decree by virtue of the compromise. My lord. It is 26/11/2020. Now, my lord, in this matter, what is under now challenge is page 83. Page 83 may read with kind permission, my lord. That is impugned before my lords.
An application was filed.
Application is filed in 2024, date of disposal, 2024 by the plaintiff, stating that the compromise has to be amended. There are some errors in the compromise. Some survey numbers have to be substituted. What is allotted to this party has to be allotted, etc., etc. Application is filed. And that application in the absence of this defendant is allowed. Defendant is not present. Case is taken up on board, application filed by the plaintiff. Plaintiff present, advocate present, defendant absent. The next sentence important, advocate present. I pause here and submit what happened, my lord.
Defendants.
Idrolage, defendant number 3 defendants, my lords, 1 to 3. Originally, 1 to 3, my lords.
And all of them were represented by one advocate.
One advocate. Now, my lord, what happened is, this application shows, my lords,
advocate defendant, say advocates present, defendant not present, my lords. Then next sentence I beg to read. Plaintiff filed 2 applications, Order 6 Rule 17 for amendment of the compromise petition. Amendment of the compromise petition. Another for amendment of the decree. Advocate for defendant endorses no objection for allowing both.
Could not have been done without the consent of the parties.
Cannot be done, my lords.
Party should have been present.
Present. And moreover, there is a clear act of misconduct, my lord. What happens is, my lord, the same advocate, my lord, for defendant, subsequently, and one more suit is filed to challenging this decree. And he appears for the plaintiff in the other suit. That's in 2020. That also we have produced. And 2 suits are filed. He appears for the plaintiff in that case. Dispute is going on. Now this suit is advanced at the instance of the plaintiff, and the very same defendant's advocate who is appearing for the plaintiff in other suits between the same parties.
Why suits again?
Suits again, my lord, one more suit is filed stating that this original decree itself is obtained fraudulently by advocate, etc., my lords. Now, since the subject matter this, my lord, the subject is this, the same advocate again appears and the complaint is also filed against him, the Bar Council, my lords. And the 2024, he appears and says, after 3 years, after practically 4 years, he says,
issue notice to the respondents. The petitioners are also permitted to serve copies of the writ petition along with annexures on the learned counsels representing the respondents before the trial court. It's okay even if it is disposed of.
Please.
Next para. Learned senior counsel Sri P.P. Hegde appearing on behalf of the petitioners who are the legal representatives of defendant number 1, submits that in terms of a compromise petition filed before the Lok Adalat, the suit in OS number 102 of 2011 was decreed on 26/11/2020. Full stop. However, an application under Order 6 Rule 17 of the CPC was filed by the plaintiff seeking amendments to the compromise petition and correction of the decree. Stop. Learned counsel draws the attention of this court to the order sheet and submits that it is clear from the order sheet that no notice was issued to the parties. Full stop. It is recorded that defendant absent, but advocate present. Full stop. Learned senior counsel submits that a correction to the compromise decree cannot be permitted without the presence of the parties, even if the advocate was present. Full stop. Moreover, allegations are made against the advocate, since subsequently suits have been filed between the same parties and the matter is being hotly contested between the parties and complaint has been lodged before the Bar Council against the concerned advocate. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order dated 24/4/2024 in OS number 102 of 2011.
All the 2024, my lord, 24/4/2000.
Other
OS number 1.
Please. 2011.
and all further proceedings pursuant to the impugned order.
Please, my lord.
Come on till the next date.
And also, my lord, respondents be restrained from causing any transfer of the RTC based on this record of rights or any other alienations, my lords.
ಅದಕ್ಕೆ all further proceedings pursuant to the impugned order,
Please, my lords, and specifically,
including the mutation entries
please,
in the land records.
or any other encumbrance. They may obtain loan on or sale it, as my lord, please, please. I'm grateful.
Number 18, Amaresh A. Angadi.
Yes.
Defendant petition, my lord. The plaintiff has marked the three documents, the exhibit P9. Exhibit
Put for?
Suit for a recovery of amount, my lord. He has produced three documents, exhibit P9 to P11 with improperly not stamped, my lord. Then defendant made application should be make it good to the stamp paper and a penalty. Whereas my application rejected only on the ground that, my lord, there are 15.
Rental agreements.
Yeah.
Rental agreements.
Yes, ma'am.
Dated 1/5/2017, 1/4/2018, 1/3/2019.
Yes, ma'am. They are improperly stamped, my lord. They are not properly stamped. Hence, made application on the section 115, 33 and 34 of the Stamp Act, my lord. Let the direct the plaintiff to make a good to the stamp paper and penalty. My application rejected only on the ground that already the document is admitted in the evidence. Already document is admitted in the evidence. Para 15, my lord. The impugned page 18. That's the only reason, my lord.
ಯಾವಾಗ mark ಆಗಿರೋದು?
Pardon?
When was it marked in evidence?
During the course of the exam chief of PW1, in absence of the defendant, it's marked. Thereafter, after cross examination, came to know that it's a mark. It is unstamped paper, not properly stamped. Then it brought to the knowledge of the court below.
Yes.
He asked for the law laid on this honorable court in several decisions, my lord. Mere marking the document is not sufficient. And more of bench decision says, my lord, it is a bounded duty of the trial court to see that whether it is properly stamped or not, even before evidence, even after evidence also. And marking a document is as per the Article 13 Rule 4 of CPC, my lord. There is some prescription is given. That is not been done, my lord.
Yes, which is the judgment you are relying upon?
My lord, ILA 1996. It's a classical judgment, my lord. Para 13, my lord. Para 13. Referring the Article 13A4. Below, I'm reading. Even your also cut. Even accepting this argument, it may be seen as pointed out by the learned counsel for the petitioner. There is nothing on record to show that the court has applied its mind to the prior act of examining whether document exhibit P1 is admissible in evidence. The second act, namely marking the endorsement under Order 13 Rule 41 CPC, also has not been made, admittedly. It is no doubt true that the defendants did not raise any objection at the time of marking the document in question as exhibit P1, but I do not think it absolves the responsibility placed on the court in examining the document for admissibility. The facts of the case discloses that
according to the plaintiff himself exhibit given represented in an agreement to say a completed contract, whereas the defendant have contended that the document indicates only proposal is not a completed contract. It is neither necessary nor proper for this court to express any opinion on this aspect, as it may be prejudice the case of either party before the trial court. But what is important to know is that admissibility of the document exhibit given, which is not stamped, was serious question to be considered by the trial court at the time marking the document. There is nothing on record to show that the trial court had applied its mind consciously to the question whether the document was admissible or not. By no stretch of imagination could be said in this case that document has been admitted in evidence. Therefore, decision relied on the behalf of the first respondent have no application to the case. On the other hand, decision relied upon the learned counsel for petitioner are applicable, and they fully support his contention that document exhibit given cannot be said to have been admitted in evidence. Therefore, the impinned order passed with trial court rejected.
Please see paragraph number 14.
No question arises as to what is the order that has to be passed in this revision. I have set out the prayer made in the IA 12 above. Officially, none of these prayers can be granted because with regard to prayer 1 and 2, the plaintiff cannot be compelled to pay duty and penalty if such a duty and penalty is payable on exhibit given under law. It is for the plaintiff to decide. The prayer depends upon whether the plaintiff pays for duty or penalty on exhibit given. It is payable under law. So, in my opinion, proper order that could be passed to keep in open the entire question of the admissibility of the document exhibit given, leaving it to be decided by the trial court at the time of final decision of the suit.
This is a suit for recovery of money.
Yes, madam.
This is not a suit for ejection or anything like that. No declaration, nothing.
Yes, madam.
The suit for recovery of money.
Marking
So,
I'm only
by what is stated in paragraph number 14.
Yes.
It is left to the other side. If he wants to rely upon the document, he is required to pay stamp duty. Otherwise, he'll say, I don't rely upon this.
not that marked, that is marked my documents.
ಇರ್ಬೋದು ಇದ್ರಲ್ಲೂ ಅದೇ ಆಗಿರೋದು.
Allah, this marked another decision.
So we'll have to ask the other side.
The bench decision, my lord.
Sir, the same principles are applied here.
Allah, what is the court says?
Yes.
Yes.
You cannot compel the other party to pay stamp duty if he says, I don't want to rely upon the document.
No, when marking the document concern, my lord.
See, if he comes before the court and says, all right, I don't want to place reliance, you believe it.
That is stage is over, my lord.
Aste.
Allah, that stage is
You
over.
cannot compel the party, sir. That is what the court has held.
No, no, no. When you mark
He
the,
doesn't want to rely upon the document.
but he is a
Suit for money recovery. Please understand.
correct, ma'am.
He may say, all right, you impound, you do whatever you want. I don't want to pay the stamp duty.
Let him say, my lord.
Astene. So
Allah,
therefore, that is what is found
no,
in
what-
paragraph number 14.
Yes.
In paragraph number 14, having regard to the same situation,
And penalty has to pay, my lord. That is-
no, not necessary. You cannot compel. That is what, you please read paragraph 14 again. You please read it again, sir.
Living to be decided by the trial court, my lord. The trial court has to decide whether it's a payable or not. Then
Please read the entire paragraph again, sir.
no question arises as to what is the order that has to be passed in this revision petition. I have set out the prayer made in so and so. Obviously, none of these prayers can be granted because with regard to prayer 1 and 2, the plaintiff cannot compel to pay the duty and penalty. Such a duty and penalty is payable payable under law. Payable under law.
Even if it is payable under law, we cannot compel.
It is for
Yes.
the plaintiff to decide.
Yes.
The prayer 3 depends upon whether the plaintiff pays the duty and penalty on execution. It is payable under law. So in my opinion, the proper order that could be passed to keep open entire question of the admissibility of the document, executive given, leaving it to be decided by the trial court
Yes.
at the time final decision of the suit. That court has to decide.
Correct.
For the reasons stated above, the revision petition allowed and the impinned order passed to trial court and so rejecting the application set aside. You will not see. Next paragraph. On IN1, ordered that the question of admissibility of the executive given in evidence kept open to decide the trial court at the time of final decision of the suit.
So that is to be kept open to the trial court decide the matter.
Issue notice to the respondent.
One more submission.
The petitioner is also permitted to serve a copy of the petition along with annexures on the learned counsel representing the respondent before the trial court. Next para. The suit filed by the respondent plaintiff is for recovery of money at the hands of the petitioner defendant. Full stop. 3 documents.
Exhibit P9 to
At
P11.
exhibits P9,
10, 11.
P10 and 11 being rental agreements dated 1/5/2017, 1/4/2018 and 1/3/2019 have been marked and have been taken on record. Full stop. Thereafter, an application was filed by the petitioner defendant under section 151 of CPC
preferred the first appeal and challenging the judgment and decree before the Honorable High Court of Karnataka. The said appeal disposed and ordered that second respondent are entitled for one-fourth share in the planned schedule properties by excluding the 7 guntas of land in item number 1 sold in favor of the third dependent. Further, present application is filed. Amend the amendment application in OS number 4/2011 to change the survey number and kata number of this suit properties as per the orders, rectified the mistake in preliminary decree. On the basis of preliminary decree, present petition is filed. These two amendment applications to rectify the petition schedule as per the preliminary decree and also order passed by the Honorable High Court of
Can you tell
Karnataka.
what is the order passed by this court?
If I may, my lords, there was an RFA pending. During the pendency of RFA, I instituted FDP. Therefore, as on the date of filing of FDP, my plaint schedule was confirmed. It was decreed. Therefore, I filed the very same schedule in the FDP proceedings. By virtue of RFA decision of this Honorable Court, which was disposed on 10th of February 2023, in item 2 of the schedule, 7 guntas of land was to be excluded as per the modified preliminary decree passed by this Honorable Court. Once there was a modification to the preliminary decree, the FDP proceedings, schedule in the FDP proceedings was to be amended. Therefore, I made an application. That application is allowed.
Where is that orders passed by this court?
It is not placed on record in the writ petition.
Kodi, ನಿಮ್ಮ ಹತ್ರ ಇದೆ ಕೊಡಿ.
I have not got copies. I filed
It
my
is
objections
only
along
in
with.
respect of one property, not in respect of all the properties. This amendment application is made in respect of schedule item number 1, schedule item number 5, schedule item number 6. The item number 7 guntas deleted in respect of only in respect of schedule number 5, not in respect of all the properties. Even the amendment is allowed prior to the commencement of the evidence. The 6th rule 17 is very much clear. May kindly see the provision.
My lords, if I may.
Provided that an application for amendment shall be allowed
Yes, sir.
after the trial has been commenced, unless the
Please,
court
that is understood.
Yes,
We are
ma'am.
now in the stage of
Final decree. The application for amendment is not allowed.
provided, sir. If it is not going to in any way alter the judgment of the trial court, it is still permissible. Even before the appellate stage, even before the second appellate stage, it is permissible. So that you can't simply read that provision like that.
No.
There are any number of judgments, even before the first appellate court. You can seek for amendment and it can be allowed. So therefore, just by saying it is now in the final decree proceedings and that cannot be a good argument. But you can succeed by saying, by seeking amendment to the schedule, and they are trying to add some new property, which cannot be done without the express admission or no objection being given by the other side. Or if they have some objection to raise, it has to be considered. So therefore, what is your objection? Other than the technical submission that you are trying to make, how is it going to change the nature of the suit? Or is it the submission of the other side that there are certain typographical errors? ಅದನ್ನ ಸರ್ವೆ ನಂಬರು ಅಥವಾ ಇದು ಪ್ರಾಪರ್ಟಿ ನಂಬರ್ ಮೆನ್ಷನ್ ಮಾಡುವಾಗ ತಪ್ಪಾಗಿದೆ, ಅದನ್ನ ರೆಕ್ಟಿಫೈ ಮಾಡ್ತಾ ಇದೀವಿ ಅಷ್ಟೇ ಅನ್ನೋದಾದ್ರೆ, ವಾಟ್ ಅಬ್ಜೆಕ್ಷನ್ ಕೆನ್ ಯು ಹ್ಯಾವ್ ಇಫ್ ಇಟ್ ಇಸ್ ಅ ಪ್ರಾಪರ್ಟಿ ಬಿಲಾಂಗಿಂಗ್ ಟು ದಿ ಫ್ಯಾಮಿಲಿ and whatever was shown in the suitable property earlier was a typographical error, wrong numbers were given or wrong measurements were given. But according to the factual position, according to the documents, this is the proper description. Adana now we are seeking, because Defendants are also given a share.
Dependents also given.
Plaintiffs are also given a share. Defendants are also given a share. You are required to partition the property. If it is not properly described, then it is going to create problem for all of you. Isn't it? You also have a share now in that.
I am also having one more
The
share.
share of each person has been declared in terms of the preliminary decree. Now, what is to be done in the final decree proceedings is to how to further divide it by meets and bounds. So therefore, if there is some typographical error in the suit schedule property, and they are trying to bring the proper description, it is not going to affect your rights, because the rights of the party have been crystallized. Therefore, you will have to make your submission in this manner. How would it affect your rights?
No. What happened?
Please take instructions. Yenadru genuine agi, there is some objections, I can consider.
That too.
For technical reasons.
My lords, if I
Police
may.
protection is issued by the FDB court. That is the apprehension.
My lords, this is only to protract the proceedings, my lords.
One thing is, there is a order, a judgment passed by this court in RFA, and at least in respect of one item of the property.
That too,
Aita.
the property sold in favor of third dependent had been deleted. In respect of that, we don't have any objection.
For all family members, isn't it?
Yes.
There is no dispute regarding relationship.
There is no relation.
Iga, as I said, I am repeating again. Merely because there was a typographical error in the description of the suit schedule properties, and that is sought to be rectified. That will be in the interest of all of you. Otherwise, you will also not get a share. If the description is not proper, you are also not going to get anything out of it. The court has taken into consideration all the properties belonging to the family, and therefore a decision has been given by the trial court in respect of your rights, individual rights, yes to nimge share anbuto. That has been crystallized. Now, only thing that is to be done in the final decree proceedings is to how to divide it. Description sari illa antandre adan correct ಮಾಡಿ ಅಂತ ಅವರು ಕೇಳಿದ್ರೆ ಏನು ತಪ್ಪಿದೆ?
Sorry to interrupt, my lords. Sorry to interrupt, my lords.
Yes.
Page number 60 for a moment. Paragraph 4 in page number 60. What necessitated this caveated respondent to file this application? During the pendency of the appeal, the concerned ADLR authorities have ordered and given new Hissa number as survey number 8/1 and 8/2 in suit item number 1. As per Hissa number, the third defendant HP Ramaswamy has got survey number 8/2 measuring 7 guntas, and the first defendant has got survey number 8/1. This is the reason why I had to seek amendment.
ಅಷ್ಟೇ subsequent code ಆಗಿದೆ. Numbers
Yes. And page number 65 for a moment, my lords. This is with respect to the other schedule what my learned friend is
65.
Page 65, paragraph number 6. Further, I submitted that in respect of suit item number 5, house property situated in so and so village on the southern side of the house, in between this property as well as the house of Lakshmaya, recently the government has formed a road, and as per location and subsequent event of house of Lakshmaya is situated on the further northern side. So ivaga road agide during the pendency. Therefore, I have to seek. Therefore, my lords, the trial court and page number 18 has observed this. Specifically observed this.
Yes.
Very first line. Respondents have not objected regarding the proceedings and also not opposed to 4D work and kata number and boundaries of the suit schedule properties. The only contention raised by the respondent that these applications filed by the petitioner is belated stage.
That submission cannot be accepted.
In view of the subsequent developments, my lords. And in the very same paragraph, ಕೆಳಗಡೆ in the 6th or 7th line, I'll read out the entire paragraph.
Yes.
Except that no specific and contrary view taken by the respondent in respect of the amendment application. No doubt, petitioner has filed amendment application after order passed by the Honorable High Court by filing application number in so and so. After the amendment, the decree and the plain schedule, he has filed the present applications. So there is no inordinate delay from the side of the petitioners. Moreover, the proposed amendment is very much needed and necessary to dispose the final decree
Dispose of.
proceedings.
Hmm.
Otherwise, while measuring the extent and demarcating the share of the petitioners, the respondent, it creates complication.
Then that is what I am saying. It will create complications for all of you. You will also not be able to enjoy the fruits. Berkeley. Learned Counsel. The Vinayaka S. Pandit has entered appearance for
Give the respondent 1 minute.
respond number 1. The Learned Counsel also undertakes to appear for respond number 2.
Very well.
Next para.
My lords, I'm sorry, I don't have instructions with respect to respondent number 2.
Yar same family.
Same family. She's the wife of, the mother of the petitioners. Also my mother.
Huh?
Also my mother.
Next para. The petitioners.
Is the second plaintiff.
Huh?
She is a second plaintiff in the voice.
The petitioners are aggrieved of the impugned orders passed by the learned senior civil judge and JMHC, Kottagere in FTP number 3 of 2017 on IAS number 8 and 14. Full stop. The 2 applications were filed by the decree holder. Yes. In a suit for partition.
Not by the decree holder.
Preliminary plaintiff.
Decree is in favor of the petitioner.
Petitioner.
A petitioner. Suit filed by the petitioner.
Partition suit, Alvin.
Partition suit filed by
all of you are. It is decreed in favor of all of you.
Yes, yes.
Were filed by respond number
1 and 2. The suit was filed by
the respondents. By the respondents for amendment of the suit schedule property
in the FDP proceedings.
During the final decree proceedings. Full stop. Objections were therefore raised at the hands of the petitioners, contending that such application filed during the final decree proceedings, should be held as an application filed belatedly, having regard to the provisions contained in Order 6, Rule 17 of CPC. Full stop. The trial court, considering the final decree proceedings, has, however, rejected the objections raised by the petitioners and has proceeded to allow the applications. Full stop. Next para. Learned Counsel for the petitioners once again reiterates the very same objections that were raised before the trial court, saying that no application for amendment can be permitted after commencement of the trial. Full stop. However, Learned Counsel for the respondents would submit that the trial court has rightly considered the application, having regard to the fact that certain modification was made by this court in the regular first appeal.
RFA number 745 of 2017.
RFA
745 of 2017.
2017,
Disposed on 10/2/2023.
which was disposed of on.
10/2/2023. 10th February 2023.
Could you please give the
Judgment copy.
ಅದ್ಯಾವ್ದು ಇದು ಅದ್ಯಾರ 7 ಗುಂಟಾಸ್ ಏನಿಲ್ಲ.
Yes, my lords, I'll furnish a copy. I'll just furnish a copy.
ಅಲ್ಲ, you don't have a copy also.
I have a soft copy, my lords, it's on my.
ಆಯ್ತು, ಕೊಡಿ, ಅದನ್ನೇ ಕೊಡಿ. It was pointed out from the judgment in the RFA that item number 5 ಆದ್ರು.
Item number one.
Item number 1.
In item number 1, ಯಾರದು second respondent ಅಂದ್ರೆ?
Third dependent who got purchased the property, 7 gunters of land in.
Third dependent,
Third dependent,
purchaser
purchaser.
will be entitled for 1/4 share in the plain schedule property by excluding 7 guntas dependent number.
Third dependent got purchased the.
Allala. See, what is excluded in favor of third dependent is only 7 guntas.
7 gunters.
ಮಿಕ್ಕಿದ ಯಾರಿಗೂ ಹೋಗುತ್ತೆ 1/4.
ಎಲ್ಲರಿಗೂ equal.
That the parties are entitled for 1/4 share. By excluding 7 guntas in item number 1, which was already sold in favor of dependent number 3.
3.
Yes. Insofar as the other application is concerned, it was pointed out that in the affidavit itself, it was made clear that during the proceedings before the trial court and before the first appellate court, certain hissa podi were made to the other items of the suit schedule property,
Other properties road farm ಅದಕ್ಕೆ bifurcate ಆಯ್ತು.
ಅಲ್ಲ ಅದಲ್ಲ.
In respect of item number 5 ಗೆ
Page number 60.
item number 5 ಆಯ್ತು.
Page number 60, my lords.
Page number 60 ಅಲ್ಲಿ ಇದೆಯಲ್ಲ. ಇಸ್ಸಾ numbers 8/1, 8/2.
8/1 ಆಗಿದ್ದು item number 1 ಗೆನೆ.
ಅದೇನೆ.
Other
they are
item
only bringing the subsequent coded numbers. In the same schedule, there are different numbers assigned after podi, and therefore they are trying to bring it. That's all. Ad bitre bere ಏನು ಇಲ್ಲ. There is no change.
ಇದರಲ್ಲಿ item number 5 ಮತ್ತೆ 6 ಗೆ.
Yes. ಏನು ಹೇಳಿದೆ? To item number 1 of the suit schedule property. Namely, survey number 8/1. Which was also coded as 8/2. Full stop. Therefore, necessary changes were sought to be incorporated in the suit schedule accordingly. Full stop. It was also submitted in the other application that insofar as item number 5 of the suit schedule property is concerned, which is situated at Buruganahalli village, on the southern side of the house, in between the property as well as the house of Sri Lakshmaya, recently the government has formed a road, and therefore the said aspect of the matter was to be brought on record. Full stop. Learned counsel for the respondents would therefore submit that no infirmity can be found in the impugned order. Full stop. Next para. On hearing the learned counsel for the petitioners, the learned counsel for the respondents, and on perusing the petition papers, this court is of the considered opinion that it is no doubt true that a plain reading of the provision in Order 6 Rule 17 would make it clear that no amendment can be permitted to the pleadings after the trial has commenced. Full stop. However, the proviso to Rule 17 also makes it clear that under certain circumstances, if the party is able to convince the court that certain information which was earlier not available to him or her has subsequently come to the knowledge of the party, and therefore the amendment is sought, it is always permissible for the court to accept such a contention. Full stop. It is also clear from the law laid down by this court as well as the Honorable Supreme Court that even at the appellate stage, such amendment to the pleadings can be permitted if the court is convinced that such an amendment is required regarding the compliance of the proviso to Rule 17. Full stop. That being the position, the contention of the petitioners that during the course of the final decree proceedings, amendment to the pleadings, more particularly the schedule of the pleadings, cannot be allowed, has rightly been rejected by the trial court. Full stop. The court, considering the final decree proceedings, has rightly taken into consideration the judgment passed by this court during the regular first appeal and the reasons given by the respondents along with the application seeking amendment, where subsequent developments have been pointed out to. Full stop. This court is also of the opinion that the amendment, if not brought to the schedule, it would create further problems for all the parties while executing the decree passed by the court. Full stop. The trial court has also mentioned the same in the final portions of the order. Full stop. Next para. This court is therefore of the opinion that the writ petition is bereft of merits. Full stop. Accordingly, the writ petition is dismissed.
Twenty-two.
Appear for the petitioner, my lord.
Yes.
My lords, I have filed this writ petition challenging the order of the trial court dated the 13th of August 2024, wherein my application for recalling the, my lord, recalling the order dated 13th of August 2024 and reopening the stage of cross-examination was rejected, my lord. That is why I am before, my lord.
I appear for the respondent, my lord. Copy was served on 24th as per the order of this court. I could obtain the signature of the respondent today morning. Hence, I could not file the wakalat. However, the wakalat is ready with me here. I undertake to file the wakalat and I pray time to file objections.
Senate Counsel Sri
Abhishek Charan.
Abhishek
Charan.
Charan.
My lord, my senior's name is Ayantika Mondal, so I'm appearing for her. Senior's name is Ayantika Mondal. I'll write it.
Ayantika
Mondal.
Mondal.
Yes.
Undertakes to appear for the respondent. Learned counsel, our place for a short accommodation. Come on the ground that the copy of the petition was served this morning.
No, my lord.
No, my lord.
That's served on
24th.
24th.
But copy was served on 24th. However, the respondent was out of station. Hence, I could obtain the signature on the wakalat today morning.
Seeks for a short accommodation to go through the petition and make submissions. Full stop. Release this matter on 2nd of September for preliminary hearing.
My lord, interim order may be extended, my lord. Further proceedings before the trial court have been stayed, my lord.
Not stayed, sir. Directions issued earlier shall continue till the next date of it.
My lord, 2 weeks time.
No, 2 weeks time.
My lord, at least.
September.
All
Yes.
right.
Number 23, Srinivas here.
Plaintiff's petition, please, my lord. The petitioner had filed a suit for possession, declaration, and mandatory injunction, please, my lordship. The trial court has ordered for emergent notice on the IA. That is under challenge before this honorable court. The case of the petitioner is that the grandfather of the petitioner, one Hira Lingaya, was absolute owner of survey number 110/2 of Dodderi village.
What are you praying in the application?
My lords, I had sought for restraining the respondent from putting up construction, my lords.
Putting up construction.
Please, my lords.
Yes. Yes.
The petitioner's grandfather was the absolute owner of the survey number 110/2. With regarding to the same, the revenue documents have been placed before the trial court, my lords. They are produced at Annexure D. That is RTC from 1970 to 80, which was in the name of Hirlingaya, are produced at Annexure D and E, my lords. Thereafter, the RTCs were mutated in the name of father of the
Siddhappa.
Siddhappa, who is the father of the petitioner. In 2007, there was a partition wherein 30 guntas of lands was divided into two parts. 18 guntas of land fell into the share of petitioner and his brother, and 12 guntas of land was handed over to his brother. That is at page 47, Annexure J, please, my lordship. Twelve guntas of land was given to the brother Hemavataya, and 18 guntas was written by Shivanna and his brother, please, my lords. Thereafter, the RTCs.
Shivanna has really 12 ಗುಂಟೆ ಇದ್ದಿದ್ದು
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಬದಲಾಯಿಸಿದ್ರು ಸ್ವಾಮಿ.
ಹೇಮಾವತಯ್ಯ.
ಹೌದು ಸ್ವಾಮಿ, ಅವ್ರ ಹೆಸರಿಗೆ 12 ಗುಂಟೆ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಶಿವಣ್ಣ ಯಾರು?
ಶಿವಣ್ಣ ಇಸ್ ದಿ petitioner, please my lords.
How did it get
My lords, totally 30 guntas of land.
ಹೌದು.
ಅದರಲ್ಲಿ 18 ಗುಂಟೆ ಇವರು ರಿಟೈನ್ ಮಾಡ್ಕೊಂಡು 12 ಶಿವಣ್ಣ and his brother ರೇವನ್ ಸಿದ್ದಣ್ಣ.
ಎಲ್ಲಿದೆ? Page number 47 doesn't say so.
My lords, if my lordship sees the RTC, please my lordship. Typed copy at page
Survey number 110/2 ಅಲ್ಲಿ
please my lord.
ಶಿವಣ್ಣ 12 ಗುಂಟಾಸ್. It is transferred to ಹೇಮಾವತಯ್ಯ.
Yes, my lords. That is under the partition deed. Total extent is 30 guntas, my lords. That is in the RTC. If my lordship sees page 45.
Is it in survey number 110/2 or 131/5A?
No, my lords. There were two properties.
Yes.
This is with regarding to 110/2. If my lordship.
The suit itself is only regarding 110/2.
Please, my lords.
Yes.
Thereafter, the revenue records were mutated in the name of petitioner, please, my lords.
Shivanna 16 guntas.
Please, my lords, including that includes 2.
Hemavataya 12 guntas.
Please, my lord. Now the defendant, that is the respondent herein, without any valid title or a document, has started putting up construction on the land of the petitioner, please, my lords.
Who is he?
Totally stranger to the property, my lords. Immediately, the petitioner has filed a police complaint. Thereafter, he has filed the present suit, my lords, wherein an emergent notice has been issued against the defendant, my lords. All the revenue records stand in the name of petitioners, please, my lords. And even petitioner has put up construction of a house, and next to that, the defendant is coming up with the construction, my lords.
Suit schedule property. Suit schedule A property.
A is the total extent, my lords.
18
B is the extent wherein the defendant is putting up construction, my lords, which is the part of schedule A property, my lords.
Why are you showing this description?
My lords,
you have not carved out any site.
No, my lordship. No, my lordship.
Then
But
how can you say exactly this is the measurement?
My lords, exactly next to the house of petitioner, he is putting up the construction, my lords.
Lala. See, if you are claiming the entire 18 guntas is your property.
Yes, please, my lord.
And he is trying to put up a construction in your property.
In the 18 guntas, my lord. Within the 18.
Why are you further giving this description that he is trying to put up construction in 26 feet into 36 feet?
That is the measure.
Want to give the description?
My lords, that is the measurement in which the defendant is putting up the construction, my lord.
Why are you giving the measurement, sir? Have you carved out sites?
No, my lord. Then it is the revenue land itself, and he has.
Where was the need for you to give that description?
Very well, I understand.
Which is the latest RTC?
My lordship, 2024 RTC, my lords. It is at page 48, annexure K, my lords.
23, 24.
Please, my lordship.
24, 25 ಇರಬೇಕಲ್ಲ. ಇಲ್ವಾ?
No, my lords. 23, 24 RTC.
ಅವ್ರು ಏನೋ ಹೇಮಾವತಿ ಅವ್ರ ಕಡೆಯಿಂದ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದಾರೆ.
No, my lords. ಅವ್ರದ್ದು ನೇಬರಿಂಗ್ ಲ್ಯಾಂಡ್ and there is no discrepancy. ಅವ್ರ ಕಡೆಯಿಂದ ಏನೂ ಇಲ್ಲ, my lords. ನೇಬರಿಂಗ್ ಅಲ್ಲಿ ಅವ್ರ ಬ್ರದರ್ ಇದ್ದಾರೆ, ಬಟ್ ಅವ್ರ ಕಡೆಯಿಂದ ಏನೂ ಇಲ್ಲ. This is the extent which was retained by the petitioner plaintiff.
showed certain documents ಅಂತ ಹೇಳ್ತೀರಾ? ಏನ್ documents ಅದು?
My lords, ಬರೀ ಒಂದು ಖಾತಾ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ ಸ್ವಾಮಿ, but no title documents have been given by the
ಖಾತಾ ಆಗಿದೆ ಹಂಗಾದ್ರೆ.
ಖಾತಾ ತೋರಿಸ್ತಾರೆ ಸ್ವಾಮಿ, but which is fabricated according to the petitioner, my lords. He claims that he has a khata for that property, but no title documents in support of the same, my lords.
ಬರ್ಕೊಳ್ಳಿ. Issue notice to the respondent. Next para. The grievance of the petitioner is that in a suit for declaration and possession,
Please, my lords.
filed by the petitioner against the respondent, the trial court has only ordered emergent notice on the application filed under Order 39 Rule 1 and 2 of CPC, whereby the plaintiff sought for an ex parte ad interim order of temporary injunction restraining the defendants from putting up construction over the suit schedule property, during the pendency of the suit. Full stop. Next para. Learned counsel for the petitioner submits that the petitioner has placed on record all the necessary information, including the latest RTC of the year 2023-24, which shows that the petitioner is the lawful owner of 16 ಅಂತಾರಲ್ರಿ.
2 guntas of Karab, my lords. 2 guntas of Karab. Total extent is 30 guntas. 12 guntas was given to Hemavataya. 16 guntas and 2 guntas of Karab is retained by the plaintiff and his brother, please, my lordship.
ಏನ್ ಹೇಳಿದೆ? Of 16 guntas of land in survey number 110/2. Along with 2 guntas of Kharab land, by virtue of mutation entry in MR number 65/2006-2007.
Please, my lords. Earlier it was brother's ಹೆಸರಿಗಾಗುತ್ತೆ ಸ್ವಾಮಿ. ನಂತರ partition deed ಪ್ರಕಾರ 65
in terms of a partition deed.
Please, my lords.
Between the family members.
Yes, please.
Full stop. The other portion of 12 guntas have been retained by the petitioner's brother, Sri Hemavataya.
Please, my lords.
And therefore, it is clear from the records that the defendant has no manner of right, title or interest in respect of the suit schedule property. Full stop. Next para. Consequently, there shall be an ad interim direction issued to the respondent not to put up any construction in the suit schedule property till the next date of hearing.
Great.
Court officer. Court officer. Court officer?
This number 2 ಒಂದಿದೆ ಅಷ್ಟೇ. ಮಧ್ಯಾಹ್ನ ಅದನ್ನು ಹೇಳ್ಬಿಟ್ಟು ಏನು that's said to be present in our can mention adjournments.
Sir, 14 ಸೈನಿಕ್ ಕಳಿಸ್ಬೇಡಿ ಸಬ್ಮಿಷನ್ ಮಾಡಿ.
ಹೊಟ್ಟೋಗಿದೆ ಸರ್,
ಸ್ವಲ್ಪ ಕಳಿಸ್ಬೇಡಿ ಸರ್, ಸೈನ್ ಮಾಡಿ.
ಬೆಳಗ್ಗೆ ಹೊಟ್ಟೋಯ್ತು ಅದು.
ಸಬ್ಮಿಷನ್ ಮಾಡ್ಕೊಡ್ರಲ್ಲಿ
ಕೊಟ್ಟಿದಾರಲ್ಲ ಅಷ್ಟೇ.
ಅದೇ
ಏನಾಗಿದೆ
ಡೇಟ್ ಫಿಕ್ಸ್ ಆಗ್ಬೇಕು, ಅವರೇ ಸಿಮಿಲರ್ ಇದ್ರಲ್ಲಿ ಕಮಿಷನರ್
ಸರ್ ಅದು ಹೊಟ್ಟೋಗಿದೆ, ಅವ್ರು ಬೇರೆಯವ್ರಿಗಾಗಿದೆ, ಅದು ಹೊಟ್ಟೋಗ್ಬಿಟ್ಟಿದೆ.
ಫೋನ್ ಮಾಡ್ತೀರಾ?
ನೋಡೋಣ ಇರಿ, ಕೇಳಿ ನೋಡಿ ಅಷ್ಟೇ. ನಾನು
Court officer?
ಆಗಲ್ಲ, ಅದೇ ಅವ್ರಿಗೆ ಸಾಹೇಬ್ರ ಅವ್ರು ಚೇಂಜ್ ಮಾಡಿದ್ರೆ ಆಮೇಲೆ ಇದು ಮಾಡ್ಬೇಕು. ನೀವು ಸೈನ್ ನೀವು ಟ್ರೈ ಮಾಡಿ, ಟೇಕ್ ಕೇರ್ ಚಾನ್ಸ್.
Court officer?
ಇದೆ 2040/1/24 RMS
ಈ ನಂಬರ್
Court officer?
100 rupees ಪೇಮೆಂಟ್ ಮಾಡಿದ್ದೇನೆ, ರಿಸಿಟ್ ಅನ್ನ ಕೊಡ್ಬೇಕಲ್ಲ ಸಬ್ಮಿಷನ್ ಸರ್. ಇಂಟ್ರಿ ಮಾಡ್ರೆ ಇಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆನ್ಷನ್
ಸರ್
ಜಾಸ್ತಿ ತಗೊಳಲ್ಲ. ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಆವಾಗಲೇ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೀವಿ. 34 ಲಾಸ್ಟ್
ಫೋನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಸರ್, ಅದು ನೀವು ಸಬ್ಮಿಷನ್ ಮಾಡಿ ನೋಡೋಣ. ಸುಮ್ನೆ ಅನ್ನೆಸರಿ ಎಲ್ಲ ವರ್ಕ್ ಮಾಡೋಣ. ರಿಸಿಟ್
ಹೌದಾ,
ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಆಮೇಲೆ ಎಲ್ಲ ಮಾಡೋಣ.
ಆಮೇಲೆ ಡೇಟ್ ನೆಕ್ಸ್ಟ್ ಅಕಸ್ಮಾತ್ ಕನ್ಸಿಡರ್ ಮಾಡಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ
ಮಾಡಿದ್ರೆ ವಿಲ್ ಸಿ
ಮಾಡ್ತಾರ ಸರ್, ಅವ್ರ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ.
Court officer? Court officer?
ಎಸ್ ಮೇಡಮ್.
ಸರ್ ಇದು ಸೀಲ್ ನಂಬರ್ 62 ಇನ್ನು ಅಜರ್ನ್ ಏನು ಆಗಿಲ್ಲ ಅಲ್ವಾ ಸರ್?
ಅದರ್ ಸೈಡ್ ಟು ಬಿ ಪ್ರೆಸೆಂಟ್ ಟು ಗೆಟ್.
No. It's not adjourned, right, sir?
No.
Will the 230 matters be taken up before the list continues, sir? Or
You should know, it will be known at only at 2:30 PM.
okay, sir. Thank you, sir.
ಸರ್ ಮನೆ ಮೂವ್ ಮಾಡಿ ಅಲ್ಲಿ ಇದನ್ನ ನೋಡಿ ನಂಬರ್ ಅದು ಕೊಟ್ಟಿದ್ದಾರೆ. ನಿಮ್ಮ ಹತ್ರ ಮೂವ್ ಮಾಡಿ. ಆಯ್ತು ಸರ್. ಅದು ನಂದು ಯಾವ ತಾನು ಬರಲಿ ನಾಳೆ ಸ್ಕೂಟ್ನಿ ಬ್ರಾಂಚ್ ಸ್ಕೂಟ್ನಿ ಬ್ರಾಂಚ್ ಕೊಟ್ಬಿಡಿ.
ಸಿಗಲ್ ಮತ್ತೆ ಟೀಚರ್ ಹಂಗೆ ಫಾರ್ ವಿಕೆಟಿಂಗ್ ಇದೆ. ಅದ್ರಲ್ಲಿ ಆಫೀಸ್ ಆಫ್ ಡಿಕ್ಷನ್ ಇದೆ, ಕೀಪಿಂಗ್ ಓಪನ್ ಆಫೀಸ್ ಆಫ್ ಡಿಕ್ಷನ್. ಅದು ಆಫೀಸ್ ಆಫ್ ಡಿಕ್ಷನ್ ಮೇಂಟೈನಬಿಲಿಟಿ ಮೇಲೆ ಅದು ರಿಟ್ ಹಾಕಿದ್ದಾರೆ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಮೇಲೆ.
ಸೀರಿಯಲ್ ನಂಬರ್
37. ಹೌದು, ಅದು ಕೀಪಿಂಗ್ ಓಪನ್ ಆಫೀಸ್ ಆಫ್ ಅಲ್ಲ ಹಂಗೆ
ಎಲ್ಲಿ ಬಿಡಿ ಅದು ಕೀಪಿಂಗ್ ಓಪನ್ ಅಂದ್ರೆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು, ಅಲ್ಲ ಅದು ಸ್ವಲ್ಪ ನೋಡ್ತೀರಾ ಅದು ಏನು ಆಫೀಸ್ ಆಫ್ ಡಿಕ್ಷನ್ ಇದೆ ಅಂತ.
ಆಫೀಸ್ ಆಫ್ ಡಿಕ್ಷನ್ ಇಲ್ಲ, ಪಿ ಎಫ್ ಕಟ್ಬೇಕಷ್ಟೇ.
ಅಲ್ಲ ಅದು ಬೇರೆ ಮೇಲೆ ಇಲ್ಲ. ಹಳೆ ಆರ್ಡರ್ ಅಲ್ಲಿ ಇದರಲ್ಲಿ ಎಂಟ್ರಿ ಆರ್ಡರ್ ಕೊಡುವಾಗ ಕೀಪಿಂಗ್ ಓಪನ್ ಆಫೀಸ್ ಆಫ್ ಡಿಕ್ಷನ್ ಅಂತಿದೆ. ಎಂಟ್ರಿ ಆರ್ಡರ್ ಕೊಡುವಾಗ ನಾವು ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ ಅದರಲ್ಲಿ ಕೀಪಿಂಗ್ ಓಪನ್ ಆಫೀಸ್ ಆಫ್ ಏನಂತ ಹೇಳ್ತೀರಾ?
ಫೈಲ್ ಬಂದಾಗ ಕೇಳ್ಬೇಕು ಸರ್, ಮಧ್ಯದಲ್ಲಿ ತೆಗಿಯಕ್ಕಾಗಲ್ಲ.
ಈಗ ಮಧ್ಯಾಹ್ನ ಸ್ವಲ್ಪ
ಫೈಲ್ ಬರುತ್ತಲ್ಲ,
ಅಲ್ಲ ಫೈಲ್ ಬಂದಿದೆಯಲ್ಲ 37.
ಕರಿಬೇಕಾದ್ರೆ 2 ಫೈಲ್ ಮುಂಚೆ ಬನ್ನಿ ಹೇಳ್ತೀನಿ.
ಸರ್ ಲಿಸ್ಟ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್
ಹೇಳ್ಬಿಟ್ಟು ಕಂಟಿನ್ಯೂ.
ಇಂಡಿಯಾ ಕಾಂಗ್ರೆಸ್ ಇದೆ.
ಏನ್ ಸೌಂಡ್ ಬರ್ತದೆ? ನಂಬರ್ ಪ್ರೊಫೆಸರ್ ಬಂದಿರಲ್ಲ ಅವ್ರದ್ದೇನೋ ಹೋಗಿಲ್ಲ ನಮ್ಮ ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಏನ್ ಕಳ್ಸಿದ್ರ ಹೇಳಿಲ್ಲ ಮತ್ತೆ ಯಾಕೆ ನಾನು ಹೇಳಿಲ್ಲ ಹಂಗೂ ಮೆಮೊ ಕೊಟ್ಟ ಇವರು ಪ್ರೊಫೆಸರ್ ಇದು ನಮ್ದು ಇದು ಟೇಲರ್ ಅವರೇ ಪ್ರಿಂಟ್ ಮಾಡೋದು ಅಫಿಷಿಯಲ್ ಲೆಕ್ಕ ಬರ್ತಾ ಗೌರ್ಮೆಂಟ್ ಹಂಗೆ ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಟ್ಟೆ ಎಲ್ಲ ಹೊಸಬ್ರು ಆಗ್ತಿದಾರಲ್ಲ ಎಲ್ಲ ಹೊಸಬ್ರು ಬರ್ತಾ ಇದಾರೆ ಯಾರು ಹೊಸ ಬುಕ್ಗಳು ನೋಡೇ ಇಲ್ಲ ಅಂತೀನಿ ಮುಖಗಳೇ ನೋಡಿಲ್ಲ ಒಂದು ಸೈಡ್ ಇದೇ ಈಗ ಸಿಗ್ನಿಸಿಟ್ಟಿದೆ ಏನೋ ಇದೆಯಾ
ನಿನ್ನೆ ವಿಟ್ರಾಗ ಮೆಮೊ ಕೊಟ್ಟಲ್ಲ ಕಳ್ಸಿ ಇಲ್ಲ ಅಂತೆ ಬ್ರಾಂಚ್
ಬಂದಿದೆಯಲ್ಲಮ್ಮ
ಎಲ್ಲಿ ಬಂದತ್ತೆ ಬಂದಿಲ್ಲ
ಬಂದಿದ್ದಲ್ಲ
ಏ ನೋಡಿ
ಇದೇ ತಾನೆ ನಿಮ್ದು
ಯಾಕೆ
1255 ಬರೀಲಿ ಕೇಸ್ ನಂಬರ್ 18842 ಅಣ್ಣ
ಅಲ್ಲ 25184
ಹೌದಾ
ಕಳ್ಸಿಲ್ಲಂತೆ ನೀವು
ಹೇಳಿದೆ ಕಳ್ಸಿದೆ
ಅಲ್ಲಿ ನೋಡಿ ಅಂದ್ರಲ್ಲ ಅವರು ತಿಳಿಸಿ
ಹೌದಾ
ಏನ್ ಮೆಮೊ ಹಾಕಿ ಫೈಲ್ ಮಾಡ್ಲಾ ಅಲ್ಲಿ
25182 ಬಂದಿಲ್ವಲ್ಲ
ಇಲ್ಲ ಅಲ್ಲ ಫೈಲ್ ಮಾಡ್ಬಿಡ್ಲಾ ಅಲ್ಲ ಅದನ್ನ ಹಾಕಿ ಫೈಲ್ ಮಾಡೋಣ ಇನ್ ಕಳಿಸ್ತೀರಾ ಅಂತ
ನಾಳೆ ಏನ್ ಹೇಳಿ ನಾಳೆ ಬರುತ್ತೆ ಅಂತೇಳಿ ವಿಚಾರ
Lordship's kind permission. Serial number 14 in the morning leaves. Respect to the appointment of commissioner. Your lordship's judgment is that the commissioner could not be appointed before the commencement of the year.
Yes.
Continuation.
Date
number
may be
24.
given in that. The notice ಮಾಡಿದ್ದೀರಿ. ಒಂದು 10 days ಬಿಟ್ಟು date ಕೊಟ್ರೆ so.
24 Gangadharappa AV.
Yes.
This repetition is by the defendant. Suit for specific performance of the agreement of sale dated 11/4/2009. Filed by none other than the brother of the husband of the petitioner. He says in the plaint that the defendant had agreed to sell the property for rupees 9,50,000, received the entire sale consideration in 2009, and he has to come forward and execute the sale. Return statement is one of complete denial. Issues have been framed. I have produced the issues also. And actually see the issues. At page 20.
Agreement was entered into between?
According to the plaintiff, between the petitioner, who is the defendant number
And respondent number 1.
and respondent number 1. That is in the year 2009, 11/4/2009.
There's a written agreement.
That is a written agreement.
Yes.
It's a total denial of the entire case pleaded by the plaintiff. And issues have been framed at page 20 and at C. On behalf of the plaintiff, initially he did not enter the witness box. One person claiming to be the power of attorney holder for the plaintiff got examined as PW1. 2 attesting witnesses have been examined. The scribe has been examined as PW3. Later on, he entered into the witness box and got himself examined as PW4. Evidence on behalf of the defendant is also over. Case was heard for some time, and the matter was posted for further hearing of the argument. At this stage, application is filed, IA number 33, seeking for appointment of a commissioner to compare the signature and to make this report. This application was opposed on the ground that it is virtually fishing the evidence and asking the court to collect the evidence for the plaintiff. The trial court has allowed the application. My submission before this honorable court is, the burden is on the plaintiff to establish that the defendant had entered into an agreement of sale on a particular date, received the
Now,
entire
since you
sale.
are denying
Yes,
the agreement
Yes.
and you are denying the signature,
yes.
the application has been filed.
Now, my submission before this honorable court is this. Burden is on the plaintiff. It has to be proved by the plaintiff to show that on a particular date, he had entered into an agreement of purchase with the defendant by paying the entire sale consideration. Now, no justification when he has paid the entire sale consideration not to get the sale deed. On that day itself, he says in the plaint, possession of the property was also delivered. Nothing has been produced. Now it is for him. He has examined 2 witnesses as attesting witnesses who claims and the scribe of the document. In view of these circumstances, it is virtually asking the court to collect the evidence for the plaintiff.
No. If you had admitted, yes, had entered into an
If
agreement,
it's a case of
then there was no
admission,
need for you to ask for this.
right? No, it is.
Since you have denied.
No, the plaintiff has filed this application.
Huh?
Plaintiff has filed this application.
Correct. You are the defendant.
Yes.
You are the defendant.
I am the defendant.
You have denied.
Yes, I have denied. I have denied. It is for him to establish.
Correct.
Now, where is the question of appointment of a commissioner as an handwriting expert to compare the signature and make the submission? It could be decided even on the basis of the evidence that has been produced. Where is the need for sending the document to the report, opinion of the handwriting expert?
Since you have denied the execution of the agreement,
yes,
he is saying the signatures found on the document can be compared with the admitted
not
signature.
necessary at all.
Then?
Because He, in addition to getting himself as examined as PW4, he has examined 2 attesting witnesses.
Correct.
The scribe has been examined in this case. There is ample evidence. The attesting witnesses and the scribe will necessarily, they will give evidence on behalf of the plaintiff saying that on such a date, the defendant has received the consideration, entire consideration, executed the document, this is the signature, etc., etc. With all this, when the matter was argued for some time on the merits of the case, and the matter was posted for further argument, application is filed. My submission before this honorable court is, it is asking the court to collect the evidence for the plaintiff in the guise of making an application for appointment of a commission. That is not permissible. Kindly see the order passed by the learned judge. Annexure of
issue notice to the respondents. The petitioner is also only one, is it?
Only one.
Respond number one.
Yes.
Respond number one.
Respond number one only. Notice to other respondents, maybe they are only formal parties.
The petitioner is also permitted to serve copy of the writ petition along with annexes on learned counsel representing respondent number one before the trial court. Next para, insofar as the other respondents are concerned, learned counsel submits that the other 2 respondents are the co-defendants along with the petitioner.
Yes.
And no relief is claimed against them in this writ petition. We'll stop. Therefore, notice to response number 2 and 3 is dispensed with. Yes.
They are further. 25. They are further.
No.
Otherwise, commission warrant will be issued and the document will be sent
Yes,
for.
yes.
So therefore, I am seeking for.
No.
They are further proceedings.
No, sir.
They are further proceedings. I am seeking.
No, sir.
25
Yes.
P.N. Harish.
Lord, the defendant number 4 petition, my lord, in a suit for specific performance. An application came to be filed after my examination chief to summon certain documents, because what has happened, my lord, on the relevant, the suit for specific performance. And the relevant period of time.
Application was filed?
For under Order 16 Rule 16 to summon the documents and produce the original documents, that is medical records, because.
You filed the application?
Yes. That came to be rejected. Holding that they are not relevant. Millard, my kindly see, my specific defense was that at the time of particular incident, that is on 11/9/2020, the first defendant being my father was totally unwell and he was in a financial difficulties and he was admitted to hospital and for continuous treatment. From 4/4/2020, he underwent angioplasty, then open heart surgery.
Number 4 has filed application.
Yes, Millard. Different number 4 has filed an application under Order 16 Rule 1 and 2. So, Sambandhi.
The manager.
Yes, the manager.
Star Health Insurance.
Please.
The direction to produce original medical records.
Yes.
And discharge summary.
Well, the burden is heavily on me. We will kindly see the additional issues that has been framed. The additional issue was framed on my written statement that to make me to prove that the agreement is said to have been executed by defendants, including me, is fabricated and concocted one.
Whether defendant number 4 proves.
Please.
That agreement for sale dated 11/9/2020 is fabricated and concocted document.
Millard, in order to substantiate that issue, Millard, these records are necessary because my defense was that at the time the father was unwell. He underwent an angioplasty, then open heart surgery. Those records have been submitted to claim medical insurance. Those are the original documents with the insurance company.
You are the defendant.
Yes. So the learned trial judge rejects it, saying that it is not relevant. It is a suit for specific purpose. It is not relevant.
Why do you want that information?
Millard, that is for the reason, Millard, those medical records are relevant for the simple reason that the first defendant was unwell and he underwent an angioplasty in the first instance. Then there was a father of the petitioner. The defendant number 1, the case of the plaintiff is that defendant number 1 to 4 jointly executed.
Then you should get the information. Why should the court issue summons?
Millard, those are the documents.
If you want someone to come and produce information.
Those are the original documents.
Support your contention.
Please, Millard. Those are the original documents which have been submitted to the medical insurance company. That I want to place it on record to the trial court.
These are not official witnesses, sir.
Millard, the production itself is sufficient, Millard.
So therefore, you get it.
Millard,
you want the information, you get it.
These are the
Why
original
should court
documents.
issue notice for that?
Lord, original documents need to be summoned because I cannot get the certificate
Sir, if
copy.
there is a difference.
Please.
If there are any official witness to be summoned, I can understand. It is not so.
Lord, it is not.
You
question of-
say your father was admitted there.
Yes. No, father was admitted and he was discharged and
Correct.
twice he was been operated.
Correct.
And these are the medical documents.
You produce the
Lord,
document.
I don't have those copies, my lord, this because of, there are the originals which has been submitted to encash the medical claim. That is the reason.
No.
Because otherwise certificate copy, my lord, the court may not believe it because
Issue
the
notice
court
to
has.
the respondents.
My lord, now the difficulty is, my lord, the court, my lord, may I make a one submission, my lord?
Oh, no.
My lord, may I make a one submission, my lord? Now the court has closed the evidence of the plaintiff, the defendant, and posted the case for arguments of the defendant. my
Yes.
lord. Tomorrow it is posted.
Yes, sir.
My lord,
See,
it is-
you want to bring some material on record, it is up to you.
my lord, I may be given liberty. to-
Your documents, sir.
That is true, my lord, but they are the original documents which are I am asking to summon. I am asking for original documents to be summoned.
Request them.
My lord, is that
Have you
liberty-
placed any information that you have requested them and are not, they are not doing
My
it?
lord, because it is a original documents, my lord, that is the reason, my lord, in that case, my lord, we are also, may
Next
grant
matter,
me a
please.
liberty, my lord,
No, sir.
to really grant me liberty to produce certificate copies at least.
Sir, it is up to you, sir.
That may, that observation, because tomorrow the case
No.
will posted for judgment.
Yes, yes.
That is the reason, my lord. Tomorrow the case may post for judgment,
Next
because
matter, please.
after rejecting my prayer, it is posted for a document argument.
Yes, yes.
I'm the impleading defendant number 81, Your Lordship. The suit for declaration and possession, Your Lordship. I'm for the defendant number 18, Your Lord, 81, Your Lordship.
81.
81. I'm impleaded in the year 2024, Your Lordship.
Oh, ಇದು society,
And the land.
house building cooperative society.
House one.
Huh?
House.
House building cooperative society is the plaintiff.
Plaintiff, Your Lord.
Who are the defendants?
The defendant all who are constructed their house over the suit schedule property. In survey number
Suit for
20.
declaration and possession.
Possessions. Your Lordship, you filed an application for recalling of PW1 and PW2 for cross-examination even. Myself impleaded in the year 2024. Thereafter, Your Lordship, no diligent on part of the defendant number 81 immediately filed a return statement. Thereafter, Your Lordship, kindly say, we had already produced the witnesses for chief examination which was completed. Thereafter, Your Lordship, on Your Lordship, kindly, the impugned order is at page number 76, Your Lordship.
Impleadment, what was at your instance or at the instance of the
The
plaintiff?
instance of the plaintiff.
Plaintiff.
Yes, Your Lordship. Kindly, Your Lordship, 77 relevant portion of the order of the trial court, Your Lordship. The D81 files IA number 40 under section 151 of CPC for reopening of the case for cross of PW1 and 2, and also files IA number 41 under order to 18 rule 17 of CPC for recalling the order dated 14/8/2024, wherein the cross of PW1 and 2 by the D81 was taken as closed. The application filed by the D81 at IA number 40 and 41 are hereby dismissed for the reason that in this case, the Honorable Apex Court had directed this court to dispose of this suit within 9 months from the date of disposal of SLP. The said period will get expires on 8/10/2024. In this case, when the matter was stood for hearing, the arguments on the defendant number 81 filed the application for reopening the case for recalling. The PW1 and 2 for seeking permission for cross-examination under IA number 32 and 33 said application have been opposed by the plaintiff by filing objection over this court. However, this court, with the intent to give an opportunity, allowed the said application and cost of rupees 5,000 on each application and directed the plaintiff to keep the PW1 and 2 present on 14/8/2024 and directions are to the defendant number 18 to cross-examine the witness on that day. Though on that day, both the PW1 and 2 were present, but the D81 sought an adjournment, not even paid the cost. We have paid the cost, Your Lordship. We paid the cost on same day itself. Cost imposed, but sought an adjournment as this court found the D81 made out no reasonable ground to grant an adjournment. Thus, by rejecting the adjournment cross of PW1 and 2 by the defendant number 81 was taken as nil. When such being the fact, fact that D81 came with
Yes,
the
sir.
above said application.
Issue notice to the respondent.
Today is posted for argument, Your Lordship.
Yes.
Today is posted for argument.
Yes, yes.
Allah, kindly have it on Monday, Your
No,
Lordship.
sir.
Allah, kindly have it on Monday.
No.
Allah, ಅದು ಏನಾಗ್ಬಿಡುತ್ತೆ judgment
No, no.
ಮಾಡ್ಬಿಡ್ತಾರೆ ಸ್ವಾಮಿ.
There's a direction coming from the Supreme Court, a date is
Allah,
given, nothing can be
Allah,
done.
today
No, no.
I'm served the copy.
No, sir, no, sir.
Allah, have it on Monday. I don't
No,
want
sir.
to stay, Your Lordship.
No. Yes.
Number 27. Sean was.
Your Lordship, the fair trial is a
No.
guaranteed.
When opportunity is given,
Your Lordship,
you should have taken it.
Allah,
You cannot do it.
one
Yes.
judgment.
No, sir. Next matter, please.
27.
Millards, I
Number
beg to
27.
appear. Millards, I beg to appear for petitioner, Millards.
Yes.
Millards, they're connected 4 more matters, Millards. WP 23610, Millards.
23610.
Please, Millards. 23610, 23117, Millards. 23285, Millards.
All of 2024.
Please, Millards. 23170. Last one, Millards. 4 more.
23170.
Please, Millards. Kindly be tagged along with all this and
These matters,
same arising of the same suit for ejection,
Allah,
Millards.
they've already come up for preliminary hearing?
No, Millards, no, they have not come up.
They have not come up.
They have not come up.
List. WP number 23610. Work on our number. Along with this matter for preliminary hearing.
Please.
On 2nd of September.
Please, Millards, I'm grateful.
Number 28.
Appear on the petition.
Samir Hassan.
My lord. Suit for recovery of amount. Money, my lord.
Yes.
Recovery of money of rupees 4 lakhs. So we are the defendants, my lord. We have filed a written statement denying all the contentions taken by the plaintiff.
Suit for?
Suit for recovery of money, 4 lakhs. So the contention is that towards the repayment, our father has issued a check of Federal Bank. So our father has issued a check of Federal Bank. So that is also one of the issues. That is the first issue is that. And not can come to page 37. That is the issue recasted. The issue number 1 is recasted as under.
Whether the plaintiff proves that the deceased Virupakshappa borrowed an amount of 4 lakhs from the plaintiff on 6/1/2022, and as such deceased Virupakshappa issued his check.
So that is one of the. Subsequently, my lord, the plaintiff has led his evidence. We have also led our evidence. Arguments of the plaintiff is heard, and we have also argued. Now, when the stage was set for the reply of the plaintiff, they come up with 3 applications. One for reopening their evidence, plaintiff's evidence, and for recalling PW1, and for production of additional documents. Those additional documents are income tax returns that is filed by them for 3 years. Other than produce Madi now prove Martin, that is their contention. We have opposed this at 3 applications, but these 3 applications are allowed. Not the contention, the very contention taken by the plaintiffs in their IA is because defendants ಅವರು IT returns ಹಾಕಿದ್ದಾರೆ ಅದಕ್ಕೆ ನಾವು ಹಾಕಬೇಕು ಅಂತ, that is their contention and ಅವರು ತಗೊಂಡಿರೋ contention. And in fact issue ಪ್ರಕಾರ they have to prove at page 71, my lord. Page 71. At page 71.
Which is the impugned order?
Impugned order, my lord, at page 40, sorry, it starts from 38, my lord. Para number 7 in the heard applications for both the sides. Para number 7, as the applications are.
It is only for producing the
document.
IT returns.
ಹೌದು
ಅಷ್ಟೇ.
ಹೌದು. Producing document now we have taken the contention.
What is the difficulty?
ಅಲ್ಲ, to fill up the lacuna in the document ಹಾಕ್ತಾರಂತ.
ಏನ್ lacuna?
ಅಲ್ಲ, the issue, my lord, is that they have to prove that we have issued a check. ಅದು ಮಾಡಿಲ್ಲ. I'll at page 71, my lord. Page 71 ಅಲ್ಲಿ ಇಲ್ಲಿ ತನಕ ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಇನ್ನೂ ಫೈಲ್ ಮಾಡಿಲ್ಲ. ಯಾವ್ದು ಬೇಕೋ ಅದು ಫೈಲ್ ಮಾಡ್ತಿಲ್ಲ, ಯಾವ್ದು ತಂದು ಸುಮ್ಮನೆ ಟ್ರ್ಯಾಕ್ ಮಾಡ್ತಾರೆ. That is my contention. Page 71. Page 71 ಅಲ್ಲಿ ಅವ್ರದ್ದು ಲೀಗಲ್ ನೋಟಿಸ್ ನಿಫಿ ಒಂದು ಲೀಗಲ್ ನೋಟಿಸ್ ನಿಫಿ 2 ರಿಪ್ಲೈ ನೋಟಿಸ್ ಒಂದು ಲಂಚ್ ಹಾಕೊಟ್ಟು ಪರ್ಸನಲ್ ಲೆಡ್ಜರ್ 3 ಬ್ಯಾಂಕ್ ಪಾಸ್ಗಳು. ಸೊ ಇಶ್ಯೂ 1 ಪ್ರಕಾರ ಚೆಕ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕು ಇನ್ನೂ ಮಾಡಿಲ್ಲ ಅವರು. ಅದು ಬಿಟ್ಟು ಬೇರೆ ಬೇರೆ ಏನನ್ನ ತಂದು ಫೈಲ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. That at the stage of reply. So ಏನೋ ಲ್ಯಾಕ್ಯೂನಾ ಇದ್ರೆ ಅದನ್ನ ಫಿಲ್ ಅಪ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಅಂತ.
ಏನು ಲ್ಯಾಕ್ಯೂನಾ ಸರ್?
ಲ್ಯಾಕ್ಯೂನಾ ಅದು ಬಿಕಾಸ್ the lacuna is that the non-protection check itself is a lacuna.
It still continues according to you.
It still continues.
Then
ಅಲ್ಲ ಅದನ್ನ ತಂದು ಹಾಕಿದ್ ಬಿಟ್ಟು ಬೇರೆ ಹಾಕ್ತಾರೆ, ಸುಮ್ಮನೆ ಡ್ರ್ಯಾಗ್ ಮಾಡ್ತಾರೆ. That is my content.
Issue notice to the respondent. Yes.
Serial number 29.
For the respondent number KVTML 6 2 days time filed objections.
Lord, matter arises out of Lord award passed in an arbitration.
Correct. Tomorrow filed objection.
Lord, what happened, Lord, is
For the KVTML.
I've served Lord a copy. My only grievance is this: there are 3 applications which the other side filed before the 34 court commercial.
Unable to come today, is it?
It's my name Arvind Niglor ಅಂತ ಹೇಳಿ ಅದು ರಾಂಗ್ ನೇಮ್ ಕೂಡ ರಾಂಗ್ ಇದೆ. NEG AL ಅಂತ ಆಗ್ಬಿಡ್ತದೆ. NEG LUR ಆಗ್ಬೋದು. ಹಾಗಾಗಿ ನಮಗೆ
ನೀವು ಅವ್ರ ಆಫೀಸ್ ಅವರೇ
ಪ್ಲೀಸ್
ಪ್ರಾಬ್ಲಮ್ ಏನ್ರಿ?
ಕೈಂಡ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡ್ತೀನಿ. ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್
ಏನಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್?
ಕೈಂಡ್ ಆಫ್ ಟುಮಾರೋ ಸೀನಿಯರ್
ಅದಕ್ಕೆ ಅವ್ರನ್ನ ಕೇಳಿ ಇದಾ ಇಲ್ವಾ ಇವತ್ತು ಬರಕ್ ಆಗ್ಲಿಲ್ವಾ? ಏನೋ ಹೇಳ್ತೀವಿ. ಎಷ್ಟು ತಪ್ಪಾಗಿ ತೋರಿಸಿದ್ದಾರೆ ಅದು ಇದು.
My only grievance, my lord, is Lord, they filed 3 applications. One application is for, there is a direction initially, my lord, that I should deposit 75 lakhs, which I have deposited. Amongst the 3 applications, one application was to permit them to withdraw that money. That order, that application IA number 3 is allowed. And that at page 168, my lord, there is, I have no objection.
This arises out of what proceedings, sir?
Lord, it's arises out of an award by an arbitral tribunal. Where, my lord,
you are the decree holder or
Lord, I'm the judgment debtor. What happened, my lord, is there was a joint development agreement. The piece of land belongs to them. There is litigation. Plus, my lord, it came in red zone. Therefore, it was conversion to residential purpose was not possible. So it went into a deadlock. The learned arbitrator holds that both of us are not responsible for the delay because of these reasons. But then the arbitrator says, because you did not terminate the contract and it had subsisted and they could not resolve the litigation with their brother and all this happened, you continue to pay 2 lakhs of rupees rent till the award. That is how liability has been fastened on me, whereas the lacuna in the title continues till today. Lord, I have challenged it under 34. My lord, trial court, my lord, has said deposit 75 lakhs. I have deposited. They want to withdraw. Lord, I have no objection for them withdrawing. But the order, my lord, does not provide any security for the amount being withdrawn. My only grievance is if they withdraw this, they are all private parties. And there is a litigation between them. Let them withdraw this by giving a bank guarantee. That's all is my grievance, my lord. But the order says that they can withdraw amount deposited on executing an indemnity. But that will not, my lord, safeguard my interests.
Court is saying that is sufficient, then it is sufficient.
Not that
the court is taking the responsibility by directing
ultimately
them to file a indemnity bond. Once they execute the indemnity bond, they will be bound by it.
Correct, my lord. If they don't comply with it, my lord, then it's a.
The court can compel them. They can be sent.
My lord, their solvency, my lord, is also an issue because they are all individuals. It's not even any entity. They are individuals. My only grievance is limited to that extent. Lord, let them withdraw by giving security.
No, you know what it takes to get a bank guarantee.
Or any other solvent security, my lord. They can provide some other property, my lord. They can create a charge on it. And so that, my lord, I can enforce that. But against these individuals, my lord, it becomes very difficult to enforce any of these.
Anyway, we will see. Learned counsel, Shri Arvind M. Neglur has entered appearance for
respondent number 1 to 5.
All respondents.
For all the respondents. ಇಲ್ಲ ಇವರು ನೀವು ಸೋಲ್
last it may be dispensed with, my lord.
10.
For response number 1 to 9, is it?
ಹೌದು.
What?
They were all claimants.
ಸಬ್ಮಿಷನ್ ಮೇಲೆ ನಂಬರ್ 3 ಅಮೌಂಟ್
I'm not passing any order, sir.
ಪ್ಲೀಸ್
Notice to respond number 1 is respond number 10 is dispensed with. Next para. At the request of learned counsel for the contesting respondents, release this matter on 2nd of September. Please come.
Lord, in the meanwhile, let them not withdraw the money, my lord. Let them not withdraw the money in the meanwhile till 2nd.
All right. Till the next date of hearing,
ಸಬ್ಮಿಷನ್ ಮೇಲೆ
the respondents are directed not to withdraw the money in terms of the impugned order.
Great.
Manivannan G.
Petitioner is the plaintiff before the trial court. An application for amendment which came to be rejected, my lord. The facts of the case is that the plaintiff, that is the petitioner, files a suit for declaration on the ground, declaration and for mandatory injunction, on the ground that the suit schedule A property was allotted to the share of her husband and revenue records were affected. And after his death, the property has been inherited by the petitioner and her son. And mutation has been affected. Now the first respondent, who happens to be the brother-in-law, that is the brother of my husband, attempted to put up construction by encroaching upon my property. Hence, I file a suit for declaration and for mandatory injunction. Respondent number 1, defendant enters appearance and files his written statement contending that these property and other properties are left behind by the father and there is no division in the family. And in fact, he goes to the extent of contending that a relief of declaration cannot be granted without the relief of partition. That is available at Annexure E written statement. Hence, I file an application for amendment with certain clarification and adding all the properties of the family and seek for an alternative relief of partition in the event that if the court comes to the conclusion that the suit for declaration filed by me is not maintainable in view of there is no partition, there could be an alternative relief of partition. That is the relief which I have sought for with certain clarification and adding certain properties. Court comes to the conclusion that it would change the whole nature of the suit from declaration to partition. And the other ground with the trial court comes to the conclusion is that when I have not made due diligence and evidence has already been created. What has happened is that, my lords, the counsel who was proceeding on with the matter, he filed his affidavit and then he expressed his inability to proceed on the matter, and then a new counsel entered. Then after going through the papers, he came to the conclusion that in the event if the court comes to the conclusion that there is no affecting of division amongst the family, then it would be multiplicity of proceedings. Parties would go to the end of the litigation with one suit itself. I'm not asking for the relief of partition as a whole, my lord, by deleting the relief of declaration, or I'm not asking for both the reliefs. What I'm asking is, in the alternative, if the court were to hold that there is no partition, give me a share in the properties. The court comes to the conclusion at Annexure A, my lords, at page 18. It starts, and para 18 it says that it is only, it would change the nature and character of the suit. And I have not exercised the duty. This is para 19, if your lordship would come.
None of you have cited any judgment?
My lords, in fact, I have cited a few citations, my lords.
ಯಾವ್ದು ಒಂದು ತೋರಿಸಿಲ್ಲ ಇದರಲ್ಲಿ.
ತೋರಿಸಿಲ್ಲ, ಯಾವುದು ತೋರಿಸಿಲ್ಲ, ಕೊಟ್ಟಿದ್ದೀನಿ.
All right, you please, if you have any judgment to cite it.
ಇಷ್ಟಿದೆ ನಾನು ತಂದಿಲ್ಲ. I thought notices could go and come.
ಮತ್ತೆ ಅದೇ ನೀವು ಅಲ್ಲಿ ಮಾಡಿದ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮತ್ತೆ ಇಲ್ಲಿ ಮಾಡೋದು ಏನ್ ಪ್ರಯೋಜನ?
ಆತರ ಇಲ್ಲ, ಏನಂದ ಅವರೇ ಹೇಳ್ತಾರೆ ಆಲ್ಟರ್ನೇಟಿವ್ ರಿಲೀಫ್ ಕೇಳಿಲ್ಲ ಅಂತಾನೆ. ಇಫ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ವುಡ್ ಕಮ್ ಟು Annexure D, my lords, ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ para 2, Annexure E, my lords.
Sir, you should be able to convince the court by saying, admittedly, relationship is not denied between the parties. So therefore, the nature of the dispute brought before the court is such that initially a suit for declaration was sought, And now, if it is converted into a suit for partition and separate possession,
Please,
when the relationship is admitted,
please,
it will not change the nature of the dispute.
yes.
It will remain between the family members, and
Please,
therefore
yes,
this application has been filed,
yes.
and it is permissible to convert a suit for declaration into a suit for partition. ಯಾವ್ದಾರು one judgment cite ಮಾಡಿರಾಗಿರೋದಾ?
ಮಾಡಿದ್ರು ಇಲ್ಲಿ ನಾನು I thought.
And I'm asking you, if you have any such judgment, you please cite it. And you're saying no.
ಇದ್ರ ಬಗ್ಗೆ ನಾನು ಕೊಡ್ತೀನಿ. Your lordship may have it.
All right. At the request of learned counsel for petitioners, release this matter on 3rd of September for preliminary hearing. 4th for preliminary hearing.
Please, I shall place it.
Yes.
List number 3. Preliminary hearing, serial number 1. Vinod Reddy, V.
I appeal for the petitioners counsel. But petitioners are the plaintiffs. Suit is for partition. First plaintiff is the widow of a deceased co-partner. Plaintiff 2 and 3 are the daughters of the first plaintiff. Lord, the petitioners have filed an IA under Order 6 Rule 17 for amendment of the plaint to include one item of landed property.
2002 suit.
Yes, my lord. 2012, my lord.
Huh? 2002, sir. 2002.
To include one item of
22 years have passed by.
Landed property.
And you are asking for an amendment now.
Amendment to include one item of landed property, it's an ancestral property, as item number 18 of C schedule properties. As item number 18 of C schedule properties. Another amendment is to declare that 13 sale deeds relating to item number 1 are not binding on the plaintiffs. For us, 9 sale transactions had taken place that were disclosed, but in the prayer already it has been mentioned in the prayer column to declare that 9 sale transactions relating to suit item number 9 are not binding. These 13 sale transaction proposed amendment is also relating to suit item number 1.
So you have stated along with your application in the affidavit that you are not aware of these facts earlier.
Yes.
It has come to my knowledge
Yes,
only recently, and therefore I am making this.
That one item of ancestral property I was not aware. I came to know only when there was a discussion of compromise during the April 2022 between the plaintiffs and the defendants 1 to 9.
Where have you stated? Where is the application affidavit?
Annexure C is the application.
Yes.
Paragraph 5 of the affidavit.
Page?
Page 85. Page 85 is annexure C.
Application.
Paragraph 3 of the.
Yes.
I state that I am an illiterate lady, know only to sign English language. I state that I came to know that the defendant 1 during her lifetime has executed 22 sale deeds in respect of item number 1 of A schedule property. However, the plaintiffs had
Not for only 9.
9 out of 22 sale deeds as not binding on us. I state that we, the plaintiffs, had sought for only 9 out of 22 sale deeds executed by the defendant 1 during her lifetime in respect of item number 1 of A schedule property in favor of the defendant number 20.
Para 5.
Para 5. I state that I am an illiterate lady and I came to know about the remaining 13 sale deeds only on 15/12/2023.
5/12/2023.
When my present counsel had inquired from me about remaining 13 sale deeds as stated by DW1 in his deposition dated 7/2/2018 while preparing himself for arguments. Since I did not have details about the same, I could not file the present IA earlier.
So 7/2/2018,
Yes,
during the recording of evidence,
DW1 had,
information was brought on record.
yes, my lord.
Huh?
Yes, my lord.
But how can you say that I was not aware then?
Lord, DW1 had disclosed it during
Correct.
his evidence.
Yes.
But at that time, advocate were aware of it. He had not scrutinized all the documents produced by DW1. Only at the time of the arguments, for preparation for arguments, then he discussed with the plaintiff number 1. And then only he came to know that 13 sale deeds were left out. Only 9 sale deeds were included. 13 sale deeds were left out. But further, para number 7,
Yes.
I state that as far as item number 18 of C schedule property is concerned, I have come to know that the said property bearing 146 for 1 measuring 20 guntas, situated at Kodihalli village, Vartur Hobli, Bangalore, South Taluk, is also ancestral property of the propositors, that is Bobanna Reddy. I came to know about the said property only when discussions were being conducted between me and other legal heirs of Bobanna Reddy for entering into a compromise when one of the defendants had accidentally mentioned about the said property. This compromise talks regarding compromise was held in April 2022. Lord, compromise was.
What has the court said about this aspect in the impugned order?
Lord, in the impugned order, the trial court says that plaintiffs are not diligent and there is a delay.
On this aspect of the matter, that you are not aware of this property.
Yes, my lord.
What has the court said? Have they raised an objection saying that they have taken a stand in the written statement or something like that?
In the written statement, it was not disclosed.
It was not disclosed.
It is not.
Not even during the evidence.
No.
So what has the court said about this aspect of the matter?
Lord, what they say, the court says regarding the sale transactions only, not regarding this property.
Nothing regarding this property. Huh?
Yes.
Is it correct?
Yes, my lord, there is nothing stated, but my lord, my submission to this is, these properties have been sold in the year 99, 2000. One is that. Apart from that, my lord, in the written statement, of course, this was not a property which was subject matter of the petition at all. They have now sought to implead or include that property as a partition.
Yavado?
E property na.
Paragraph number 7.
Howdo. That particular property, they are now seeking to include it as a property.
Now we'll come to this one.
Before that, they have entered into a compromise.
In respect of the other sale deeds, they were all sold in bits and pieces, is it?
99, 2000, one stretch al marirodella.
Or as the sites?
Howdo. Howdo. 99, 2000 al marar. In the written statement, my lord, may be pleased to have a look at my written statement.
The claim will be in respect of the larger property.
Yes, my lord.
Yes, my lord. 4 acres.
Out of which they have already raised a challenge in respect of 9 sale deeds.
They have
saying that it is not binding on us, declare that it is not binding on us.
Yes, yes, they have. They have.
What should happen if the other sale deeds are not taken into consideration?
Well, because these are sites that has been sold.
Therefore,
one is that, my lord. Second thing is, in the written statement which was filed in the year 2012, at paragraph D, I say that this property has been sold to various people under various sale deeds, which I bring it to their knowledge in the year 2012 itself.
Not the details.
Not the details. Even here, the details also,
So
in the year 2018 itself, I bring.
The details have come in
the
while
year
recording the
2018
evidence
itself.
on 7/2/2018.
18. They filed this application in the year 2024.
Yes.
Even there, the issue of limitation, my lord, under Article 58, within 3 years. Because the issue of limitation has to be looked into. Supreme Court is very clear on that. If the issue of limitation is an issue that has to be considered while considering an application for amendment, such an application shall not be allowed. They admit that and they have concluded their cross-examination also in full. After I filed my evidence affidavit, they conclude their cross-examination. The matter is now set for final arguments. The proviso to orders Rule 17 will also come in their way.
You are the persons who have sold the property.
Purchase the property.
Huh?
We are the people who have purchased the property. We are
Purchase
purchasers.
the property. now.
Yes, my lord. Defendant
Defendants 15 to 20 are
15 to-
the,
Huh?
defendants 15 to 20 are the aliens.
we are the purchasers of the properties. So the benefit of that, the accrual of right in my favor because of their
No.
delay.
You were impleaded.
I was a party much in the suit itself.
Initially.
Suit itself.
Huh?
Yes, yes.
So it has come to their knowledge that you have also purchased other
Also
properties.
purchased, yes.
That information was not available with them.
Otherwise, why would they make me a party, my lord? They were aware that I was have purchased.
You have purchased. ಅವ್ರಿಗೆ ಗೊತ್ತಿರೋಷ್ಟನ್ನ ಮಾಡಿದ್ದಾರೆ. 9 sale deeds were attacked.
Yes. Lord.
Oh, thereafter it was found that you have also purchased other properties.
My lord, an encumbrance
not
certificate
aware.
would have revealed every document.
If they were aware, they would have challenged it in the initial stages
My
itself.
lord, that is not the issue, my lord. I will tell the real issue, my lord.
Yes.
What is it? What they do is, in the year 2022, they enter into a compromise with respect to other properties. With defend number 2A, that compromise is also recorded, accepted by the court. After that compromise is recorded, they bring one more property. Apart from this, my lord, they had carried out amendments, brought in new properties in the year 2004 once, 2014 once. This is the third application for amendment. ಎರಡು ಸಲ amendment ಆಗ್ಲೇ carry out ಮಾಡಿದ್ದಾರೆ ಅವರು. That is the observation made by the learned trial judge while
Suit itself was compromised.
Lord,
a portion of the properties were
respect of the
compromised.
properties which are not sold, my lord.
ಯಾವ ಪ್ರಾಪರ್ಟಿ
compromise
ಅಲ್ಲಿ ಸೂಟ್ ಅಲ್ಲಿ ಇತ್ತು
into-
ಅದ್ರಲ್ಲಿ ಎಲ್ಲ ಸುಮಾರು
That
ಪ್ರಾಪರ್ಟಿಗಳನ್ನೆಲ್ಲ
was-
ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೋತಾರೆ.
Compromise.
ಮಾಡ್ಕೊಂಡು after the compromise is carried out, they bring in one more property. They bring in some more contents. And apart from this, my lord, as they have admitted in their application itself, 2018 they get to know. I have filed my evidence affidavit. And your lordship may be pleased to see evidence affidavit ಅಲ್ಲಿ the details that I have furnished is full, correct. Sale deed, no registration number, ಎಲ್ಲ ಹಾಕ್ತೀನಿ. In spite of that, they come and file this application in 2024. 6 years. Article 58 says 3 years for declaration.
Yes, sir. If it is,
Lord, compromise.
if the relief is hit by the Limitation Act,
My respect to
it is not
submission.
possible for the court to allow such an application.
Lord, my respect to submission. I have not sought for setting aside or cancellation of the sale deeds or to declare the sale deeds as null and void. It is only, I am not a party to the sale transaction.
Yes.
Lord,
What are you seeking then?
only to
Not
declare
binding on
that
Vinted.
the sale transactions in respect of item number 1 are not binding on the plaintiff's share. Therefore, Article 58 is not applicable. If I ask for setting aside or cancellation or to declare that it is null and void, then only Article 58 will attract.
Yes.
But the division bench of this honorable court, para 1819, my lord. Para 19. The second, may read, my lord. Para 18, 19, 19.
Yes.
The second contention that the suit should have failed for lack of specific relief in regard to the setting aside of the sales is also devoid of merit. It is now well settled that in a suit for partition by Hindu co-partner, it is not necessary for him to seek the setting aside of the sale. It is sufficient if he asks for his share in the joint family properties and he be put in possession thereof, and for a declaration that he is not bound by any alienation or interest of other created in such properties which fall to his share. This is all what I have sought for. Not for setting aside or for cancellation or to declare that sale deed is null and void.
It is a suit for partition.
It is a suit for partition.
Yes.
Well, they don't have to seek the sale deed to cancel a sale deed, but that doesn't mean Article 58 doesn't apply. Not Article 58 suits relating declaration. Article 58 says to obtain any other declaration, 3 years. When the right to sue first accrues. Now, my lord, the right to sue, even according to them, if it accrues from 2018, 3 years.
If you're going by that argument, many of the partition suits will fail. That is not so.
Allah, hangalla. It is not the question of partition suit. Here is a question, my lord.
For partition,
My lord, I would like to rely on the judgment of
One
the
of the-
Honorable Apex Court.
one of the co-partners may not be aware of the fact that a portion of the property or some property has been sold by another co-partner.
Yes, my lord, they might not be aware, I understand.
So
But
therefore,
here is the
there
case, I
there
make it known.
Even if they come to know, there is no need for them to ask for
Yes.
cancellation of the
Yes.
sale deed.
Yes, I am not saying that they should have asked for cancellation of sale deed. I am not saying that. What I am saying is, from the date of knowledge, according to them, 7/2/2018 is a date when I file my affidavit in lieu of evidence. In that affidavit in lieu of evidence, my lord, I would like to share a copy of that affidavit in lieu of evidence also, along with 2 citations that I would like to rely upon.
Yes. ಇದ್ಯಾವ್ದು ಇನ್ನೊಂದು Supreme Court
In that also, my lord, I rely upon paragraphs 55, 57, 58 and 59, 2009, 10 SEC, page 84.
Para 57.
Para 55, my lord. Lord, 55. In Haridas Alidas Tuduru versus Godrej Rustam Khairman, this court said, it is well settled that the court should extremely liberal in granting prayer for amendment of pleadings unless serious injustice or irreparable loss is caused to the other side. It is also clear that a revisional court ought not to lightly interfere with the discretion exercised in allowing amendment in absence of cogent reasons or compelling circumstances. Paragraph 57. In Suraj Prakash Bhusin versus Rajrani Bhusin, this court held that liberal principles which guide the exercise of discretion in allowing amendment,
ಅವೆಲ್ಲ
multiplicity of the procedure.
judgments of prior to amendment.
Yes.
So let us not read them. This judgment itself is of the year 2009.
9 months.
So you can go to the
Even limitation,
portion where the law has been declared.
even limitation also, it is a limitation relating to, it's a mixed question of law and facts. It's a matter of argument. Lord, at the time of argument, he can.
So anything more in this judgment?
58 and 59. It is also the first condition that which must be satisfied before the amendment can be allowed by the court is whether such amendment is necessary for the determination of real question in controversy. If the condition is not satisfied, amendment cannot be allowed. This is the basic test which should govern, because one item of the giant family, it is a part of the giant estate which was not known. Later on, after coming to know, I have sought for inclusion. Not the 59. The other important condition which should govern the discretion of the court is potentiality of prejudice or injustice which is likely to be caused to the other side. Ordinarily, if the other side is compensated by cause, then there is no injustice, but in practice, hardly any court grants actual cause to the opposite party. The courts have very wide discretion in the matter of amendment of pleadings, but court's power must be exercised judicially and with great care. Another judgment, my lord, of this honorable court.
Copy of the judgment, sir.
Yes, yes. Thank you.
ಕೊಡ್ಬೇಕು ಸರ್ ಇಲ್ಲಿ ನೀವು ಜೆರಾಕ್ಸ್ ಮಾಡಿಸ್ಬೇಕು ಅಂದ್ರೆ ಅಲ್ಲ ಫಸ್ಟ್ ಕ್ಲೋಸ್ ಮಾಡಿ ಇದೆಲ್ಲ ಜೆರಾಕ್ಸ್ ಪೇಪರ್ ಇದೆ. No, the first one what is just read.
In page number 3 of this judgment, my lord. Copy. Copy.
In paragraph number 63A,
Yes, my lord.
the court has given the guidelines.
Yes, my lord.
But the last one in that is, as a general rule, the court should decline amendments if a fresh suit on the amended claims would be barred by limitation
On the date of.
on the date of application. This is one of the guidelines issued in the judgment. Paragraph number 63 nodi.
63. But in this case, my lord, the limitation.
ಅಲ್ಲ ನೀವು ಸೈಟ್ ಮಾಡೋ ಜಡ್ಜ್ಮೆಂಟ್
Yes, in this case.
ರೇವಜಿತು ಅಲ್ಲಿ
Revjitu case.
ಹಾ
In this case,
ಹಾ
everything has been summarized in para 63.
correct.
Correct.
So
In that,
therefore, one of the
one of
directions
the-
is that it is a new suit is filed and it will be barred by limitation.
Yes,
Such application should not be allowed.
yes. Now I cannot file any new suit.
So therefore, sir,
Therefore,
if you are required to file a new suit and that relief cannot be claimed because it will be barred by limitation.
correct, my lord. Here,
Ah.
I am not asking for setting aside a document.
So therefore, sir, what you cited in this judgment, the judgment of our court, that would be applicable to the facts of the present case.
Yes, my lord.
Here, as a general rule, this
General-
direction has been issued.
Yes, general
But will
rule
the
is-
court have to keep in mind this directions issued by the Supreme Court? Even otherwise, you also know that if while considering an application for amendment, court has to consider whether such application can be allowed permitting amendment, and the court has to consider whether the claim would be barred by limitation. It's a general rule.
True, my lord. True, my lord.
Therefore, you are saying in a suit for partition, that may not be necessary because you are not going to ask for the relief of setting aside or cancelling of the documents. So this judgment will hold good. Yes, sir.
My lord, whether they seek for setting aside or cancelling a document.
In a suit for partition.
Yes, yes,
This is what the division bench has held.
yes.
If you have any other judgment, you please
My
cite.
lord, I have shared the judgment 2024. In my compilation, my lord, the first one is the same thing which even I am relying upon, what they are relied.
Yes.
As your lordship rightly pointed out, para 63 clearly says, as a general rule, if it is barred by limitation,
Yes.
then such an amendment cannot be accepted.
Yes.
Following that judgment, my lord, and in that judgment itself, my lord, I would like to take your lordship to paragraph 27, my lord. Paragraph 29, my lord, the one I have shared, because Manupatradalli ಸ್ವಲ್ಪ page para numbers difference ಇದೆ ಅದಕ್ಕೆ. Para 29 might be looked into in the compilation that I have given.
ಹೆಂಗ್ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ ಅದು?
Page 6 ಅಲ್ಲಿ, my lord.
ಹೆಂಗ್ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ paragraph?
In our considered view, Order 6, Rule 17 is one of the important provisions
Yes.
of CPC. But we have no hesitation in also observing that this is one of the most misused provision of the court for dragging the proceedings indefinitely, particularly in Indian courts, which are otherwise heavily overburdened with the pending cases. All civil courts ordinarily have a long list of cases. Therefore, the courts are compelled to grant long dates, which cause delays in disposal of the cases. The application for amendment lead to further delay in disposal of
General ಎಲ್ಲ
cases.
ಓದ್ಬೇಡಿ. Now it is more specific.
Yes,
In a
ma'am.
suit for partition,
Yes, ma'am.
plaintiff is not required to seek cancellation of sale deeds.
Yes.
Executed by one of the.
Yes, he need not seek cancellation of sale deeds, it is executed by some other person. He can only say that this is not binding on me.
Yes.
Even to seek a relief of declaration that this document is not binding on me, Article 58 would apply, my lord.
No, sir.
Then,
Not in a suit for partition. No.
my lord, from the date of knowledge that such a document has been executed, at least from that date, he should, Article 58 would apply, my lord.
No, no. Sir.
My lord,
A
in
suit-
that case,
suit
my
for
lord,
partition would not apply.
my lord, no, my lord, I would like to share the next judgment.
The judgment of the division bench. And I'm sure there will be any number of judgments of the Supreme Court also.
My lord, the next judgment that I have cited in the compilation, my lord, paragraph 12, my lord. which is at page 21.
Yes.
My lord, paragraph 12, it says, after even following the judgment in Ravajitu's case, if the amendment is allowed in the case on hand, certainly prejudice will be caused to the appellant. This is one of the important factors to be seen at the time of consideration of any application. One second, my lord, why? Because the aspect of limitation is looked into here.
Pertains to.
In a
suit for-
partition suit, an aspect of limitation is looked into here, my lord. This is also a partition suit.
Yes.
This is one of the important factors to be seen at the time of consideration of any application for amendment of pleading. Any right accrued to the opposite party cannot be taken away on account of delay in filing the application. In the case on hand, the compromise decree was passed on 14/10/2004, in which the plaintiffs were party. The application for amendment of plaint was filed on 8/2/2010, that is 5 years and 3 months after passing of the compromise decree, which is sought to be challenged by way of amendment. The limitation for challenging any decree is 3 years. Reference can be made to Article 59. A fresh suit to challenge the same may not be maintainable, meaning thereby the relief sought by way of amendment was time barred, as was the passage of time. The right had accrued in favor of the appellant. Here, my lord, due to passage of time, the very relief that they could have asked, that this particular documents are not binding on me, has time barred, and that particular benefit has accrued on me at least from 2018, though not from 2012 when I have said in my written statement, though not from the sale deed which has been executed in 99/2000, but that right has accrued in my favor at least from 2018. So now, my lord, when they were aware that these sale deeds specifically, my lord, may be pleased to look at the affidavit evidence that I had filed, which I have submitted along with this, my lord.
Barkale. Learned Counsel Sri Chandan K has entered appearance for response number 60/21.
No, my lord, 16 and 21.
16 and 21. 16 and 21. Where are notice hobeku?
15 is also Eleni, my lord, purchaser. He also filed objections there.
15 I am already on the call.
15 to 20, they also filed objections.
You have filed caveat only for 16 and 21.
Yes, my lord. Adenagide namak kottiro copy nalli the same respondent is shown as 15. ಅದರಲ್ಲಿ ನಿಮ್ಮ ಕೋರ್ಟ್ ಕಾಪಿನಲ್ಲಿ 16 ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ, ನಮಗೆ 15 ಅಂತ ತೋರಿಸ್ತಾ ಇದಾಗಿದೆ. There is some difference in numbering.
What is the name of your party?
P Satish Pai, my lord. P Satish Pai.
16.
Yeah, ನಮಗೆ 15 ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ. ಇನ್ನೊಂದು my lord, Medical Relief Society.
That is 21.
Yes, my lord. For us it is shown as 20. I would also take notice for 17, my lord, Mr. P Dayanand Pai.
Learned Counsel Sri Chandan K has entered appearance for response number 16 and 21.
16 and 21.
16 and 21. However, Learned Counsel would also undertake to appear for response number 17.
Yes.
Bere yaru notice hobeku?
Respondent number 2.
Please file a memo. Learned Counsel on record. You please file a memo.
Yes, ma'am.
Seeking dispensation. I will accordingly notice. Issue notice to all the other respondents.
Lord, interim
The
statement.
petitioners are also permitted to serve copies of the petition along with the annexures on the Learned Counsel representing the respondents before the trial. Full stop. Next para. Learned Senior Counsel Sri Papi Reddy appearing for the petitioners places reliance on a judgment of a division bench of this court in the case of Ganapati Shantaram Bhosle versus Ramachandra Subbarao Kulkarni. Reported in
ILR 1985.
1985, Karnataka.
Page 1115.
1115. Wherein it has been held that in a suit for partition by Hindu co-partner, it is not necessary for him to seek the setting aside of the sale. Full stop. It is sufficient if he asks for his share in the joint family properties and he be put in possession thereof, and for a declaration that he is not bound by any alienations or interest of others created in such properties which fall to his share. Full stop. In that view of the matter, learned senior counsel submits that even if it is admitted that the petitioners came to know of the sale transactions
on 7/2/2018, page number 89, paragraph 5, page number 89.
during the recording of the evidence of DW1 on 7/2/2018, in respect of the 13 sale deeds the application for amendment could not have been rejected on the ground that the plaintiffs claim in that regard would be barred by limitation. Full stop. Insofar as the other item of the suit schedule property, namely item number 18, is concerned, learned senior counsel submits that it has been stated in the application and the affidavit filed along with the application that the plaintiffs have come to know of the immovable property belonging to the joint family just before the filing of the application, and therefore nothing has been said in that regard in the impugned order. Full stop. Next para. For contra, learned counsel for the contesting respondents seeks to submit that when admittedly the petitioners came to know of the 13 sale deeds on 7/2/2018, when the evidence of DW1 was recorded, time started ticking for them from that date, and such claim, if allowed to be made in the prayer, would be permitting the plaintiffs to make a prayer on a time-barred claim. Full stop. Next para. This court is of the considered opinion that a prima facie case has been made out by the learned senior counsel appearing for the petitioners. Full stop. Accordingly, there shall be an interim order of stay of the impugned order.
Not impugned order. Further proceedings may. Further proceedings in the suit, pending suit may kindly be.
Dated 22/7/2024, and all further proceedings in OS number 4235 of 2002 till the next date of hearing. Yes.
Passed over matter. Number 10, Sunil S. Narayan.
Petition. Defendant's petition.
Yes.
Defendant's petitions. The respondents 1 to 3 hearing filed a suit for declaration and permanent injunction.
OS number 65/22 on 15/2/22. Along with that, they filed the IA also 1302, which came after my appearance. I filed my written statement. Suit for declaration and permanent injunction. Filed by respondents 1 to 3. Along with the suit, they filed the order 1302 application also. I tendered my appearance. I had contesting defendants. I filed my written statement. Thereafter, IA came to be allowed. I preferred MA. I am agreed by MA also, agreed by both the orders. I am before this. The brief facts is that
Notice to the respondents.
position non position status container.
Yes. Yes.
See, once more passer lordship, senior held up in trial court, your lordship, is on the way. At the end of the list.
Release this matter for preview hearing on 4th of September.
Great lordship.
Yes.
List number 2, preliminary serial number 1. Chandra Tariga. Okay.
This has become infructuous, my lord. Suit has been disposed. Maybe dismissed as
Counsel for the petitioner submits Takondo, OS number 278 of 2019. Disposed of on 29/1/2024.
Please.
Serial number 2, B.B. Ravishankar.
Mr. Ravishankar, FDP 1 of 2019 is disposed of on 28/10/2021. One nimsham. Hmm. 28/10/2021.
Serial number 3, order passed. Serial number 4. Ravishankar K.
But I filed a memo on 29/3/2023. Infectious, madam.
You have filed a memo.
Yes, madam.
OS number 58 of 2013.
Yes, madam.
Is decreed.
Yes.
On 9/1/2023.
23.
You are for petitioner.
Respond number 23.
Respondent.
3.
Yes.
Serial number 5, A.V. Narasimhan.
Matter got disposed, my lord.
Submission of petitioner. Learned counsel for petitioner. OS 84 of 2014.
Yes.
Dismissed as not pressed.
Yes, my lord.
On 19/1/2023.
In view of the compromise, my lord.
In view of
Compromise, my lord.
compromise.
Yes, my lord.
Compromise entered into between the parties.
Yes, my lord.
Serial number 6, Varun Papireddy.
Appearing for petitioner, my lord. I already receipt is counter submit ಮಾಡಿದ್ದೀನಿ.
OS 385 of 2012. Dismissed on 2/12/2021.
Yes, madam. Yes, madam.
Yes.
7, Jagdish Undargi.
Petitioner. Suit is now disposed of. Petition has
You are
become.
for the petitioner. For the petitioner. OS 30 of 2018.
Yes, please.
Settled before Lokadalata on 30/3/2022.
Yes, right. Oblige.
Serial number 8, Samir SN.
OS 168 of 2010. Decreed on 31/10/2023.
Serial number 9, Prasanna Kumar P.
The petitioner, my lord, memo for withdrawal is filed. The objection is that the memo is not signed, my lord.
Submission of the learned counsel and Tanakali. OS 225 of 2021 was disposed of on 21/12/2023. Isn't it? Yes.
Serial number 10, D.K. Manjunath.
Responding to the original suit is pending, was pending and
Learned counsel for the respondent.
Kindly quote me.
OS 135 of 2015, settled in Lok Adalat on 12/11/2022. Yes.
Kindly quote me dismiss the petition.
11 order passed, serial number 12. Prakash, MH.
OS 39 of 1994. OS. Miscellaneous petition already. Miscellaneous petition. Miscellaneous petition 2 of 1996. Check marks. Release this matter on 4th of September.
11 order passed.
13 करेगी.
Serial number 13. 13.
Hearing for the petitioners, my lord.
Hmm.
Matter has been disposed in the small causes court. And the petition has taken the possession of the property also.
SC 249 of 2016 is decreed on 24/12/2021.
My lord.
Huh? Memo filed by Learned Counsel for petitioner.
Yeah.
Serial number 14. Manjunath H.
Correspondent 6 and 7, my lord. Already the matter is disposed in the trial court, my lord, 18/6/2022.
You are the respondent.
Yes, my lord, 6 and 7.
OS 3445 of 2020 is dismissed on 18/6/2022.
Yes, my lord.
Yes.
Serial number 15. Vasanta Lakshmi HV.
OS 170 of 2015 is decreed on 30/3/2024.
Serial number 16. Jaykumar PP.
Appearing for petition, lordship. Lordship, the respondent agreed for settlement, the matter settling outside the court, requesting to kindly grant a short date.
Huh?
Short date ಕೊಡಿ ಸ್ವಾಮಿ, matter settle ಆಗುತ್ತದೆ.
Settle ಆಗೋಗಿದೆ ರೀ. RA 24 of 2019 has been settled before the Lok Adalat on 6/7/2023. Disposed of. Yes.
Serial number 17. Vijaya MN.
For the petitioner, my lord. The suit is already dismissed, my lord. It doesn't survive for consideration.
OS 31 of 2016 dismissed on 31/10/2023. Huh?
Yes.
Serial number 18, 19 order passed. Serial number 20. Venkata Ramana Reddy L.
For the respondent, my lord. Petition has become infructuous. The original suit has been dismissed as withdrawn.
OS 1508 of 2019 is dismissed as withdrawn on 26/6/2024.
List number 1. For orders. For withdrawal. Serial number 32. SV Prakash.
My lord, serial number second list, serial number 16.
Serial number 1. List number 1. Serial number 32.
I am for the petitioner, my lord. I filed a memo, my lord, on 8/7/2024. The petitioner has
Learned
become
counsel for
infectious.
petitioner has filed a memo dated 8/7/2024.
OS number 84 of 280 was decreed.
Stating that the original suit from out of which the present petition arises, namely OS 84 of 2018, has been decreed on 27/4/2024.
Yes.
Yes, dispose.
Order serial number 33. MR Hirematad,
Bring for petitioner, my lordship.
PF proposed R16A to D.
My lordship, 16A to D ಮಾತ್ರ ನಾವು bringing LRS application ಹಾಕಿದ್ವಿ. 12A and B ಅಂತ ತೋರಿಸಿದ್ರು my lordship. ನಾವು ಹಾಕಿಲ್ಲ. NOC ಬಂದ್ರದ್ my lordship ಅದು. NOC ಬಂದ್ರದ್ my lordship. 12A B ಗೆ ನಾವು ಹಾಕಿಲ್ಲ.
12?
Sorry my lordship.
You know?
16A to D.
For the petitioners.
Yes my lordship.
You have to
16
take steps for service of notice on respond number 16A to D.
A to D my lordship. 12A B ಗೆ ನಾವು ಹಾಕಿಲ್ಲ my lordship. ಅದು ಡೆತ್ ಆಗಿಲ್ಲ my lordship ಅವರು. 12A B ಗೆ.
12?
A B.
ಎಲ್ಲಿದ್ದಾರೆ 12AB?
ಇದೆ my lordship. ಕಾಲ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ತೋರಿಸಿದೆ.
Note check ಮಾಡ್ರಿ then. Week's time is granted at the request of learned counsel for petitioner to take steps for service of notice on respond number 16A to D.
Please.
ಅಲ್ಲಿ ಚೆಕ್ ಮಾಡಿ ನೋಡಿ 12A and B ಇದ್ರೆ ಅದನ್ನು ತಗೋಬೇಕಾಗುತ್ತೆ. Yes.
Please my lordship.
List ಕೊಡಿ.
Serial number 34. By Rajendra Prasad.
I'm for the petition. I paid needful done my.
PF
Learned counsel submits that the needful has been done.
Interim,
Is to verify and issue notice.
interim order may be.
Order granted earlier stands extended to the next date.
Much.
35. Asmat. No sir. Certification.
Matter, my lord, copies is personally served yesterday, my lord, and earlier taken notice also is acknowledgement is written, not.
Received a copy of the IA.
Yes, sir. Yes, my lords. Only yesterday we received the copy of the IA.
Learned counsel for the petitioner submits that she has received copy of IA number 2 of 2024.
Yes, ma'am.
Lot of.
My lord, a suit for injunction filed by the petitioner.
This matter at the request of learned counsel for the petitioner release this matter on 4th of September.
My lord, extension of the interim.
Interim order stands extended.
Thank you.
36. Serve the
Much
copy, my
obliged.
lord. Petition copy. Copies is not served.
ಹೆಂಗ್ರಿ ಅಪ್ಲಿಕೇಶನ್ ಆಗ್ತದೆ ವೆಕೇಟಿಂಗ್?
Yes, sir, come to my knowledge, I filed this wakalat.
How did you file the application for vacating
Clear file wakalat.
without having a copy of the writ petition?
Trial court issue emergent notice, my lord. Meanwhile, this emergent notice has been challenged before this court. This court has been granted status order. Is mentioned written in number in my property. I come to my knowledge, I file wakalat.
ಅಷ್ಟು ಸಾಕು ವೆಕೇಟಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಕ್ಕೆ.
After that,
You don't even have to look into the.
I secured the only for writ petition copy. I am not received entire documents.
Learned counsel for the petitioner is requested to serve a copy of the writ petition along with annexures on learned counsel for response number 1 and 2. Yes.
Serial number 36.
Much obliged.
DK Gowda awaiting.
List this matter after service of notice on response number 1 and 2. Interim order in Indian notary. Illa. Yes.
37. Manjunath KV.
37, I pay for the respondent, my lord. Notice to respond number 2 may be dispensed because he is the director, my lord. Petitioner is the director of respondent number 2, my lord. And this IA has to be heard. Right? He is questioning the order, my lord, of attachment, my lord.
Learned counsel for respond number 1 submits that the petitioner is the director.
He is the managing director of respondent.
Managing director of respond number 2.
Yes.
And therefore, notice to respond number 2 may be dispensed with.
Yes.
Full stop.
IA should be heard.
Accordingly,
My lord,
Notice to respond number 2 is dispensed with.
respondent number 2 is a company, my lord. Respondent number 2 dispense. I have no objection. I'll dispense it. That's fine.
Now, your lordship may kindly take up the IA for vacating, my lord. My lord, your lordship may kindly see the order also, my lord, passed by this honorable court, my lord. Now, personal properties of the petitioner have been attached, my lord. That is questioned in this writ petition. My lord. The respondent is the decree holder. Respondent number 1 is the decree holder, and an amount of rupees 42 lakhs and 34,000 is due to the decree holder, my lord. Now, my lord, at the time of notice, not this honorable court has held, my lord, respondent number 1 is the decree holder, and in executing the decree, he has sought to attach the personal property belonging to the petitioner, and the trial court, the personal properties of any director can be brought to sale, not if it is shown not that not the company and its officers have committed fraud on the creditors. I am relying on a decision of the Honorable Supreme Court, not in 1996, 4 SEC, page 622.
What of, sir?
So in this case, my lord, the petitioners, my lord, have taken, my lord, the supplies of lamination, my lord, given by the respondent number 1, my lord, and have used it in manufacture of the goods, and they have sold the product, but they are not paying the amount, my lord, for the supply of goods, my lord. Now, my lord, your lordship may kindly, my lord, take the judgment, my lord, 1996, 4 SEC, my lord, head note E first, my lord.
Please don't read from the head notes.
No, then the para 30,
Para 24.
24, para 24. The concept of piercing the wheel.
The principle
Yes.
of lifting the corporate veil.
Yes, ma'am.
Paragraph number 24.
24, yes, ma'am. Not the marked portion on the right hand side, ma'am.
ಯಾವ್ದು ಓದ್ತಾ ಇದ್ದೀರಾ ನೀವು? State of Rajasthan.
No, not the state of first judgment, ma'am. That is 1996.
Development.
Yes, ma'am. Delhi Development Authority versus Skipper Construction, ma'am. The
Concept of corporate entity.
Yes, ma'am. The concept of piercing the wheel in the so-and-so is much more developed than in the UK. When the notion of legal entity is used to defeat public convenience, justify wrong, protect fraud, or defend crime.
ಯಾವ paragraph ಓದ್ತಾ ಇದ್ದೀರಾ ನೀವು?
Para 24 ಅಲ್ಲಿ marked portion.
24.
Para 24.
Yes.
On the right hand side, para piercing the wheel of corporate entity. When the notion of legal entity is used to defeat public convenience, justify wrong, protect fraud, or defend crime, law will regard the corporation as an association of persons. Therefore, not if they are considered as association of persons, not their personal properties are liable to be brought to sale.
You have filed an execution case.
Yes, I have filed and I have obtained an order attachment of a Mercedes car also, Lord, which is Lord, under attachment, Lord. And now, Lord, they have filed this, Lord. They filed an IA for vacating that order, Lord, that was rejected. Against that, this writ petition is filed.
Yes.
And your lordship may kindly see, Lord, the order of Lord, the court below, Lord, which is the last portion. Application filed on behalf of judgment debtor company as IN number 2 is hereby rejected. This IN number 2 was filed for recalling the order of attachment of mobiles.
Yes, sir.
My lord. My lord, I am the director of the company, my lord.
Yes.
I'm not disputing that, my lord. The company that decree is against the company.
Yes.
Not against the individual.
Yes.
They are trying to execute the order against the individual, my personal assets, not the company's, my lord. And what he is saying about fraud and other things, my lord, let him show one word in his execution petition or the application before the arbitrator alleging fraud against them. My lord, what he has to do, my lord, is he has to either go before the company.
Although there is a decree against you.
Not against me, against the company. Second respondent.
Who is the company, sir?
My lord, I am not the company. I am the director of the company.
You are the managing director of the company.
I am the managing director. My lord, I am not disputing it, my lord. Company is different, individual assets are different, my lord.
Ah,
My lord, for that, my lord, I rely on this one.
yes.
Mark ಮಾಡ್ರ?
ಏನ್ ಜಿ?
ಒಂದ್ ನಿಮಿಷ ಕೊಡ್ತೀನಿ ನಾನು.
Orissa.
Orissa, division bench. ಅಲ್ಲ, ಇದೆ ಅದೇನು ಎರಡು ಮೂರು ಇದೆ. ಅಲ್ಲ, it's an, ಅಲ್ಲ, my lord, what has happened is, very two different.
Standard Chartered Bank.
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ
Supreme
correct.
Court judgment. You please read.
I will, my lord. My lord, two,
It's a legal entity.
correct.
It has got, it cannot be sent to prison.
Correct.
Company cannot be sent to prison.
Yes, my lord.
For disobedience or non-compliance of a decree passed by a competent court.
My lord,
So therefore, Supreme Court has held the concept of lifting of bail should be made applicable under these circumstances. The persons manning the company alone will be liable for the
No, no, no.
decree.
My lord,
You can't escape the decree, sir.
no,
If you want to pay the, or if you give a list of assets belonging to the company, you please give it. You are the managing director.
ಅಲ್ಲ, I agree.
Please give the list of assets of the company. We will, we'll direct them to sell the assets. Please give.
My lord, kindly have it after 2 weeks, I will do it, my lord.
No.
My lord, and I'll go through the judgment, my lord.
Next week.
Whatever lordship has said.
Court, my lord.
ಇಲ್ಲ, ಇಲ್ಲ. Samadhan.
ಇದು ಇದೆ ನೋಡಿ Supreme Court judgment.
I will, my lord, whatever lordship has said, I'll go through that and come back. But my lord,
You please give a list of the citations.
Yes.
ಎಲ್ಲ Supreme Court judgment.
ಅಲ್ಲ, ಅಲ್ಲ, so, my lord, what I am relying on also, my lord, is the basic principle is,
Sir, please put yourself in the shoes of the
ಅಲ್ಲ,
decree holder.
my lord, what had happened was,
What should he do?
my lord, whatever,
Obtaining a decree
My lord.
against the company,
ಅಲ್ಲ, ಏನ್ ಮಾಡಿದ್ದಾರೆ?
he is not able to recover the money. What he should do?
My lord, the company was wound up not because of almost company shut down,
Ah.
not because of my reason, my lord. It is because of various losses suffered by the company, my lord. We have spoken to him. He had agreed for a sum of amount also. Then ಇದೆಲ್ಲ interest ಎಲ್ಲ ಸೇರಿಸ್ಕೊಂಡು ಹಿಂಗ್ ಬಂದಿರೋದು. The amount is not so much.
You could have settled the matter.
My lord, we
It
had
was not
settled.
difficult.
He had agreed, my lord. He had
Even
said-
now you do it. You please go sit across the table
No,
and sort out the issue. But you cannot contest. You cannot contend that this is my separate property. You cannot come against my property in ಹೇಳಕ್ ಬರೋದಿಲ್ಲ. So long as you are the managing director or a director of the company, you
But
are bound to
ಇಲ್ಲ. I will,
satisfy
my lord, I'll
the
satisfy
decree
this
passed
court.
by the court.
No, my lord, I'll satisfy this report, man. Kindly have it of 2 weeks, my lord. I'll
No, next
go
week,
through the judgment
not
and.
2 weeks, next week,
Yeah, against
next
the-
week.
I will go through the judgment and. I shall, my lord.
Mention the judgment in the.
ಇಲ್ಲ, one more, my lord, one more.
IFO vacating ಎಲ್ಲ ಹೇಳಿದೆ.
ಅದಕ್ಕೆ ಅಪ್ಲೈ ಆಗಲ್ಲ ಬಿಡಿ, ನೀವು ಯಾಕೆ ಅಂತ.
I have said that.
ಅಪ್ಲೈ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಸುಮ್ಮನೆ ಹೇಳ್ಕೊಂಡಿದ್ರು.
Learned counsel for the respondent presses for an order on the application for vacating the interim order granted by this court. Learned counsel seeks to place reliance on the judgments of the Honorable Supreme Court in the case of Delhi Development Authority versus Skipper Construction Co. Private Limited, bracket Delhi 1996, close 4 SCC 622.
And one more, that is 2000.
And State of Rajasthan and others versus Gotham Limestone Khanij Udyog Private Limited, bracket 2016, 4 SCC 469. Standard Chartered also is another judgment.
Yes, I'll stand it, I'll get that.
Wherein the Supreme Court has held that
My lord, those are cases of fraud, my lord. My lord, I shall differentiate.
fraud
ಅಲ್ಲ, ಹೌದು my lord. I shall differentiate, my lord.
for satisfaction of a decree
ಇಲ್ಲ, I shall, my lord.
passed
ಇಲ್ಲ,
against a company.
No, my lord. ಅದ್ರಲ್ಲಿ ಎಲ್ಲದರಲ್ಲೂ fraud, my lord. Where they want to lift the corporate veil, my lord.
Fraud-
If
fraud
there's an
must
allegation of fraud, my lord, that's when it comes in, my lord. Very clearly it states, my lord.
A decree of a competent court has to be satisfied in a manner known
Correct,
to law, sir.
correct, my lord, but wherein
Therefore,
I have
if you
deliberately.
are saying
Yes, my lord.
there are assets of the company, you please give it.
My lord, very well, I am
If
not.
you give the list of the assets of the company, they will proceed against that.
Then the second respondent is necessary, my lord.
Huh?
Second respondent, complete.
Managing director.
Our in complete.
Managing director.
I am a representative.
Notice ಯಾರ್ ತಗೋತಾರ್ರಿ ಮತ್ತೆ?
Our
ಆ
company.
ಕಂಪನಿ ಬೇರೆ ನೀವು ಬೇರೆನಾ?
ಅಲ್ಲ company ಅವರು appear ಆಗ್ತದೆ.
ಯಾರು?
Let them appear.
Who?
Whoever appears, I'll take out notice, my lord. I will pay the process, my lord.
No. You are the managing director. If you have a list of the assets of the company, you please give it.
My lord, very well, my lord. Then I will, my lord, your lordship has said one more statement also, my lord. I shall verify those.
Yes.
Allah, either,
Yes.
my lord, I am very sure, my lord, that.
All right, I am adjourning the matter.
Yes, my lord. Allah, this is where fraud, my lord. Fraud is alleged. They have taken, the Supreme Court has said they can lift the corporate veil.
ಯಾರ್ fraud ಮಾಡಿರೋದು?
Allah, company, wherever the company indulges in fraud, then this applies, my lord.
I will also show that you have committed fraud.
What?
You have
Diverted
to
the
make,
money.
my lord, I can't
What-
come and say
what-
he is made
What is
fraud.
the manner in which a decree passed against the company can be satisfied?
My lord, there are, my lord, I shall.
Please tell us, sir, how
My lord, there's
how to
company-
how
my
to
lord,
satisfy the
My lord,
decree?
there is a company law, my lord. He has to go approach the NCLT, my lord.
Right.
He has to file a binding up petition against the company, my lord.
No,
How so?
Not necessary,
no,
sir.
not.
My lord, he has to stand in the queue, my lord.
Every person
No.
alleges that money is due from the company and therefore files a suit for recovery of money.
My lord, company.
Everyone need not go file an application for winding up the company. Not necessary.
No, that is the law, my lord, the NCLT, that Company Act and the Insolvency Act, my lord, new act.
They want to invoke the provision,
My
then
lord,
they will they'll have to go before the NCLT.
they will have to, my lord, because winding up of the company assets, allinda barutte Swami, then it goes down.
Then there should be a bar.
There is a bar, my lord.
Yeah, Tursi.
Section 435. ಇದೆ ಸ್ವಾಮಿ, ಬಾರ್ ಇದೆ.
There are no.
ಎರಡರಲ್ಲೂ ಬಾರ್ ಇದೆ. I shall, my.
Wherein
There is, my lord. 430 ಇರ್ಬೇಕು ಸ್ವಾಮಿ. Of the Companies Act. And
that there are various classes of cases
My lord.
where the concept of corporate entity could be ignored and the veil drawn aside.
Lord, section 430.
Where the device of incorporation is used for some illegal or improper purposes.
That is the whole thing.
So, learned counsel submits that the first respondent is a decree holder
Decree holder.
against the second respondent company.
Yes.
And it is for the directors of the company to satisfy the decree passed by the competent civil court. Full stop. Next para. Learned counsel for the petitioner, however, seeks for a short accommodation to go through the judgments and make his submission.
That is the Supreme Court judgment that says there's a bar. And this is Delhi High Court.
Sir, this is regarding transfer of shares.
So section 430, my lord.
There cannot be a bar, sir. For recovery of money, how can there be a bar?
I think I call it on 4th of September.
2 weeks.
Of September.
4th.
Release this matter on 4th of September.
Next week.
38.
No.
38.
I appear for petitioner, my lords. ಇದರಲ್ಲಿ ಪದ್ಮ ಮತ್ತೆ ನಾಗರತ್ನ ಅಂತ ಹೇಳಿ ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹಾಕಿರ್ತೀವಿ ಪದ್ಮ ಅಂತ. ಬಟ್ ವೈಲ್ ಕಮಿಂಗ್ ಅಂಡರ್ ಮಿಸ್ ಅಪ್ಲಿಕೇಶನ್ 9 Rule 13 ಅಲ್ಲಿ ಅವ್ರು ನಾಗರತ್ನ ಅಂತ ಬರ್ತಾರೆ ಅಷ್ಟೇ. ಬೋತ್ ಪದ್ಮ ಅಂಡ್ ನಾಗರತ್ನ ಆರ್ ದ ಒನ್ ಅಂಡ್ ದ ಸೇಮ್.
The office objections are overruled. List this matter for preliminary hearing on 4th of September.
Much obliged, my lords.
39.
My lord, previous matter, interim order.
Interim order granted earlier stands extended.
Previous one.
My lords, in this case, I am
39.
presenting.
Sidramaya.
Respondent number 1, 2, and 3.
Awaiting.
I will undertake respondent number 1, 2, and
Council Sri
Balu Mahendra, my lords.
Balu Mahendra.
Yes, my lords.
Undertakes to appear for all the
Respondent.
respondents.
Yeah, no, my lords. Respondent 1, 2, and 3.
Response number 1, 2, and
2 and
3.
3. I will undertake to file wakalat, my lords, and kindly direct the petitioner to
Office is
provide the
directed to-
copies of
A week's time is granted to the learned counsel to file wakalat.
please, my lords.
Learned counsel, petitioner is directed to serve a copy of the petition along with annexures on the learned counsel. Yes.
Serial number
Is
40.
this matter after service of notice on respond number 2 and 4?
4, 5, 6, madam.
4, 5, 6, my lords. I am for 1, 2, 3.
3.
4, 5, 6.
Yes, my lords.
All right.
Serial number 40.
Complain, my lord, 2 weeks time may begin. Office objections complain madidini. I don't know, my lords. I think some other objections are
A
there.
week's time is granted at the request of learned counsel for petitioner for complaints of
Interim order may kindly be extended.
interim order agidi agla.
Agide.
Interim order granted earlier, stands extended till next date of hearing.
That's okay.
Serial number 41. Ramesh. Okay, non-compliance.
Madam, in this
R
case,
126, first time.
this case, preliminary hearing anta bandittu last time, wherein I am seeking interim order, time of admission. But now preliminary hearing anta bandittu last time. Now it is posted for orders because preliminary is the other.
Notice has been ordered, you have not taken steps. Pay the process fee, sir.
I'll pay the process even tomorrow also, but my lord, ivattu kone final chance anta kotre arguments, otherwise my reputation become infectious. Therefore, I am seeking interim order also.
Matters come up for preliminary hearing, only notice has been ordered,
Lord,
cannot be taken up for reconsideration.
my lord, last time,
A week's time is granted at the request of learned counsel for petitioner to take steps for service of
no,
notice.
I may be permitted to serve the summons on the
ಆಗಿರ್ಬೇಕು ಕೊಡಿ.
counsel for the other side before the trial.
ಇದ್ಯಾವುದು? The petitioner is also permitted to serve copies of the writ petition along with annexures and the learned counsel representing the respondent before the
Trial.
trial court.
And the date may be fixed for tomorrow only. I will see that it is served. My lord, today it was settled for final arguments because Allah
42.
last chance anta kotre arguments adu ಏನಾಗಿದೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ.
ಎರಡೆರಡು ಸರಿ we can't hear you on preliminary hearing, sir. Not
42, Ravi, HK.
My lords, I appear
Awaiting
for the,
service.
I appear for the petitioner in this
HK.
matter.
list.
My lord, I appear for the petitioner in this matter.
Learned counsel for the petitioner has filed a memo dated 7/8/2024 seeking dispensation of notice to response number 2 and 3 on the ground that no relief is sought against them in the writ petition. Full stop. Next para, at the risk of the petitioner, notice to response number 2 and 3 is dispensed with.
44.
My lord, serial number 42 interim order has to be extended.
Serial number 44 for the petitioner, my lord.
44, Girija is FPF.
My lord, the response number 2 to 15, the notice may be dispensed, my lord. They have placed ex parte in the trial court. Response number 2 to 15, my lord. The notice may be dispensed, my lord, because they always placed ex parte in the trial court.
Please
My
file
lord.
a memo, sir.
Sure, my lord.
Please
A week's
file
time may be given.
A week's time is granted at the request of learned counsel for petitioners.
Grateful.
File necessary memo for seeking dispensation of notice to response number 2 to 15.
Grateful.
Yes.
Serial number 45. Manjunath RS, awaiting service.
List this matter after service of
May I
notice on
submit?
respond
Your
number 1 and
lordship said permitted the petitioners to serve on the respondents. They are served.
serve on the learned counsels.
Yes. Now, the
That
urgency.
is not service of notice, sir.
But your lordship said they permitted us to serve.
Permit you at your request, so that our tagondu bandre santosha barli anta. If you don't want this court to serve notice on the learned counsels, I will do it.
Not like that, my submission is this.
That cannot be taken as service.
Yes,
of- Not
but
The respond number 3, my lord.
He's appearing for respondent number 3.
You are the contesting respondent?
No, the other 2 respondents. May I make one submission?
Yes.
There is an attachment order that is made, where you, the movables belongs to me. The screens and the projector, they belong to the petitioner, and he is not a party to the decree at all. Respondent number 1, he files a suit against respondent number 2, and there is a decree served by respondent number 2, and petitioner is not a party at all. His movables, I mean, he is only a person who supplies the screens and projectors to the theaters. He has supplied the screens and projectors to the theater. And my movables, the screen and the projectors, they are lying in the
I
theater.
can't hear you once again for preliminary,
No, I am only seeking,
for interim prayer.
man, about 10 days may be granted, I will take for this.
Huh?
10 days, my interest may be protected, so that I will take further steps. 10 days, the order may be, my interest may be protected. Thereafter, I will see the dematerialization. 10 days, my lord. Because you will not kindly see the approach of the court, paragraph, ink page 105. Ink page 105.
Sir, sorry, sir, matter is listed for orders, and it is for awaiting service of notice on the respondent.
May I just kindly see,
I can't do this, sir.
kindly see page 105.
Yes.
Wherein he says,
Yes.
Cruise petitioner may, on compliance time may be given to comply officer.
A week's time is granted at the request of learned counsel for petitioners for complaints of office objects.
47,
For the petitioner.
Bhargav, D. What, awaiting.
List this matter after service of notice on response number 1 to 4.
Interim order may be extended.
Interim order stands extended.
48, Jeevan
Thus,
Kumar.
I appear
PS.
for the petitioner. The only office objection is court commissioner who has been appointed and report has been rejected is not made party to this proceedings.
Court commissioner.
Court commissioner. Commissioner report I have challenged, my lords, rejection of commissioner report has been challenged before this honorable court.
Office objections overruled.
Preliminary.
This matter for preliminary hearing on 3rd of September.
Much.
Serial number 49. Sangamesh B.
A week's time is granted for.
Petitioner,
complaint
my
of
lord,
officer.
compliance, ma'am. Only
Week's time.
1 week.
Yes.
Serial number 50, order pass. 51, hearing interlocutory. Gurraj R.
R3 is no more, my lord. We have filed LR application notices to.
Issue notice on IAS number 123 of 2022. ಅಷ್ಟೇ ತಾನೆ?
My lord, interim order may kindly be extended.
Interim order stands extended
In connected matter also. Published.
in both writ petitions. Yes.
52, order passed. 53, Keshav Bhatia. Early hearing.
Petition is 74 years old lady, my lord. FDP proceedings are stayed, my lord. Hence I filed IA for early hearing.
We release this matter. A matter is called out. There is no representation for the respondents. Release this matter on 4th of September.
Please, my lord. Interim order may kindly be extended.
Interim order granted earlier stands extended to the next date of court. IA number 2 of 2024 is accordingly disposed of.
54, T.N. Vishwanath.
Huh?
Matter. 53, Agartha case. Early hearing.
ಅದೇ ಇವಾಗ ನಾವು ಮಾಡಿದ್ದು.
Sorry, there.
ನೀವು ಬಂದಿಲ್ಲ ಅನ್ಬಿಟ್ಟು ಅರ್ಜೆಂಟ್.
Sorry, sir.
ಎಸ್.
ನಾನು ಬಂದಿಲ್ಲ ಅಂತ ರೆಕಾರ್ಡ್ ಆಗುತ್ತೆ. But I am not present ಅಂತ ಬಂದಿಲ್ಲ.
They have filed an application for early hearing. Yes.
54, T.N. Vishwanatha.
My lord, 54, I am appearing for the petitioner.
Yes.
But this is an IA that has been filed by the respondent.
Matter is called out. There is no representation for the respondents. Release this matter on 4th of September.
My lord, may I request for the 9th?
55.
The 9th, if it is convenient, my lord.
I appear for the petitioner.
All right, 9th of September.
Interim order may be extended.
Interim order stands extended.
I'm grateful.
55, Ravindra B.S.
You have filed application.
Yes, my lord, seeking vacating the interim order. My lord,
The petitioner has obtained an interim order, my lord, suppressing, making a misrepresentation to the court. My lord, the acceptance of the compromise petition has been assailed in the present petition. My lord, the relationship is not in dispute, my lord. Suit for partition was filed. My lord, that was decreed. Then it was again challenged. Then against which, my lord, RSA is filed by our father. RSA has been abated. My lord, making a misrepresentation saying during pendency of the RSA, the petition, FDP proceedings has been entertained, in which the compromise petition was accepted by the trial court, my lord. That order has been assailed before in the present writ petition, saying that since the RSA is pending, this order is incorrect.
No, that is not the ground. My lord, the suit for partition was filed. Suit came to be decreed, my lord. Against that, appeal was filed. Appeal was dismissed. Against that, a second appeal was filed. Pendency of the appeal, my lord, FDP was initiated. The appellant, the respondent number 1 and 2 enters into compromise petition. Respondent number 1 relinquishes a right in favor of the respondent 2 in a partition suit, my lord. I objected, saying in a partition suit there cannot be a compromise petition unless all the members of the family enters into compromise. I request, my lord, to take the impugned order. The court
Which is the compromise decree, sir?
compromise decree, my lord, page number 25, my lord. The orders that is being passed, dated 6/6/2024, my lord, 2023, case called out, page number 25, in page number 25. Case called out, TSP for the LRs of R2 seeks time for objection to the compromise petition. On perusal of the compromise petition, the petitioners and LRs of the R1 have entered into compromise and filed a compromise petition, and both the parties have not claimed any right pertaining to LRs of the R2. Further, the counsel for LRs of R2 has already submitted no objection to the commissioner's report. So, under these circumstances, providing one more opportunity to the LRs of R2 does not survive any purpose. Thus, a prayer is rejected. The compromise petition filed by the petitioner and LRs of R1 is hereby accepted. However, my lord, court grants the liberty for LRs of R2 to challenge a compromise petition if the rights will be infringed, my lord.
How can that be done?
No, my lord.
Huh?
The admitted
To accept a compromise petition and grant liberty one of the parties to challenge it.
My lord, you see, my lord, in the final decree proceeding, the relationship are not in dispute.
Yes.
2 brothers, 1 sister. Sister filed a suit. Suit decreed. That was challenged in a regular appeal. Regular appeal also came to be dismissed. Lord, that was challenged in a regular second appeal, which abated due to death of the opponent, my lord. These facts are not in dispute. Then final decree was filed for the meets and bounds, the 1/3 share has to be demarcated.
Yes.
During pendency of that, my lord, final decree proceedings, the legal representative of a daughter who was a plaintiff, yes, released her share by taking 25 lakhs rupees in favor of second respondent hearing. That, my lord, that compromise was recorded by the court below. My lord, in that final decree proceedings, the commissioner was appointed, the property was already demarcated, report was submitted, for which the opponent have not filed any objection to the commissioner report. At that stage, my lord, that party, the daughter, who accepts, receives the consideration amount, released her right, her share in favor of our party. That is the position. But she has got an absolute wisdom of right to either release in favor of anybody. She has taken her money for her share, now released in our favor. Now the proceedings is for the acceptance of the commissioner report. They have not filed any objection. If the commissioner report is accepted, then not final decree will be drawn. That is only the, but what they have right to challenge it.
The final decree is not drawn up.
Not yet drawn, my lord. But what is, they have right, my lord. She has got declared by the court of law that she has got 1/3 share. She has released in our favor.
That will be finally decided now.
Yes, my lord.
My lord, compromise between.
I was under the impression that the FDP proceedings itself is closed.
No, not yet.
Based on the compromise petition, it is not so.
My lord.
If one of the brothers.
Yes, my lord. receives the.
wants to release his share.
Not daughter, not we are brothers. Daughter has released her share by taking the 25 lakh.
Sister.
Sister, yes, my lord.
Legal
Sister,
representative.
My lord, that is
yes,
what.
in
that
our
is the-
favor.
Wants to release her share in favor of one of the brothers.
Yes, my lord.
Lord.
It is permissible.
It's not permissible in a partition suit, my lord, unless it is, there is a meets and bounds between the parties.
Huh?
There's this 20 guntas are,
Sir, it is still open,
it's not open, my lord.
not closed.
My lord, if A enters into compromise with the B, yeah, then there will be a hurdle for me to enter into my property.
Why?
Because unless there is a meets and bounds by the division, by the
That will be decided now. The matter is not closed.
compromise, commissioner's report has been submitted, my
Oh,
lord.
no, Lord, under the Partition Act, there is a provision.
Where is the commissioner's report?
My lord, I have not submitted. Next date I will submit it, my lord. That is the issue, my lord. In a partition suit, my lord, all the parties should be enter into compromise. You cannot pick
No,
and
no.
choose a one second, sir.
It is
You can,
still permissible for one of the brothers or sisters to give up her share in favor of one of the other brothers or sisters.
unless,
What is wrong in that?
unless there is a division of the property.
Not necessary. A share is given. Ultimately, the division by meets and bounds is still to take place. It will take place.
But division already made, my lord, by the commissioner. That should be accepted by the court.
Correct, sir.
As per the Partition Act.
Whether the court accepts that report
Yes.
or whether it would accept your objection and reject the commissioner's report with the direction to redo it, it's all left to the court. It will still have to take your objections into consideration.
Please, my lord. That is what my submission. my lord.
For that one only, the matter is kept pending. And in the meanwhile, you come and use
Yes, my
seek
lord.
for a stay.
Obtain the stay order, therefore the matter without progress, it is laying in the trial court.
I'll dispose of the writ petition with these observations. The matter is still to be considered for drawing up the final decree pursuant to the report submitted by the court commissioner,
Please, my lord.
along with your objections.
Please.
It will be kept open.
Yes, my
Apply.
lord.
The petitioner, one of the
Respondent, my lord.
new,
Now, one of the respondent before the trial court.
being one of the respondent before the trial court in a suit for partition, is aggrieved of the impugned order passed by the principal civil judge and JMFC, Chandrai Patna during the final decree proceedings. Full stop. During the course of the final decree proceedings, a compromise petition was filed on behalf of
Lord, in between first respondent and respondent 2 to 4.
between the respondents herein. Correct?
Respondent number 1 and my lord, respondent 2 to 4 in between. Respondent number 1 herein and respondent number 2 to 4 herein.
Between respondent number 1 on the one hand and respondents number 3 and 4 on the
2
other.
to 2 to 4.
2 and 4 on
Yes.
the other.
Yes.
Full stop. It is the contention of the petitioners that although objections were raised on their behalf, that they have not entered into a compromise with the other parties, nevertheless, the court has proceeded to accept the compromise petition insofar as the respondents herein are concerned. Full stop. Next para. Learned counsel for the respondents would submit that it is legally permissible for some of the parties in a suit for partition to enter into a compromise
and release their share
and release the share of one of the parties in favor of the other. Full stop. That by itself cannot be objected by the other parties to the proceedings. Full stop. Next para. There is substance in the submission of the learned counsel for the respondents. Full stop. After going through the impugned order, this court finds that the court, considering the final degree proceedings, has accepted the compromise petition filed as between the petitioners herein.
Respondents.
Respondents herein. However, the matter is listed for further arguments on merits. Full stop. This would mean that the objections filed by the petitioner to the compromise petition or the acceptance of the report of the commissioner will be kept open for consideration. Full stop. The court will have to consider the objections that could be raised at the hands of the petitioner and thereafter proceed to draw the final degree proceedings. Full stop. Next para. Consequently, the writ petition is accordingly disposed of while directing the learned principal civil judge and JMFC, Chandrayapatna to consider the submissions that would be made on behalf of the petitioner herein before drawing up of the final decree. Ordered accordingly.
Grateful.
56.
Lordships, I appeal for the petitioner in the matter. The respondents have filed vacating stay, your lordships. There are 4 connecting matters in the matter, your lordships. They have to be heard together. And interim order has been granted after hearing the caveat respondents, your lordships.
What do you mean? How the numbers, sir?
See, my colleague is in the court. She will provide it, your lordships. There are 4 numbers. They have also filed 2 writ petitions, your lordships. I have also filed the writ petition. The interim order is granted after hearing the caveat respondent, your lordships.
So and so on 4th of September. Interim order, wherever granted earlier, stands extended till the next date of hearing.
Your lordships, interim order is still until further orders, your lordships.
It is still further orders.
Until further orders. After hearing, your lordships, they have granted.
Yes.
Lordships could see the order, previous order, your lordships would come to know. The order is very clear. They've suppressed the fact.
All right, madam. You are yourself saying there are other matters to be heard together.
Yes, your lordships.
Yes.
But interim order is until further orders, your lordships.
So I've said no need to extend the interim order. It's not a conditional order. That is what you're saying.
Yes, your lordships. It's
All
not
right.
a conditional
Yes.
order.
57. Sumana
Much obliged.
Sumangala Swami.
Next week. Speak.
At the request of learned counsel for the petitioner, release this matter on 4th of September.
P8. Kevin Narasimhan. Early hearing.
This matter was heard by my lord for some.
Monday in this matter.
Huh?
Early hearing application may be allowed, my lords. May request my lordship to have this matter on Monday. My lords.
This matter was heard by my lord.
Huh?
They said that they would file a memo of calculation stating the rents that they have paid. My lord, I had filed an application seeking striking of the defense in view of the fact that in spite of the order of this honorable court, they defaulted in payment of the rents.
So this is that
Please, my lord, in view of the
suit for ejectment.
Yes, my lord, please.
But arising out of the Transfer of Property Act.
No, my lord, what happens is, yes, ejectment suit was filed. There is an order, my lord, to pay the rents, which, my lord, have been confirmed by this honorable court with a modification. Thereafter, my lord, they undertook to pay, but never paid it. My lord, and hence I filed an application, my lord, seeking striking of the defense on the ground that there is a willful default. My lord, that application came to be rejected. On the previous occasion, my lord, they said that they will file a memo of calculation as to the rents that they have paid, which, my lord, have not been paid to me, according to me. That's where, my lord, the matter got it.
Certain amount has been paid, my lords. That is what, as per my information, and even property taxes are paid by them. That's what they have informed, my lords. The documents they're going to furnish, my lords. May request my lordship to have this matter on Monday, my lords.
See, if you have failed in your challenge raised to the order directing you to deposit the arrears of rent.
Like 50% of the amount.
You will
was
have to
deposited.
comply.
That order was subsequently modified and 50% of the amount was deposited. And subsequently, how much payment was made, I'll seek instructions and some.
That's the request that was made on 5th of August. It was on that premise, my lord, that the adjournment was sought. Of course, that is not recorded.
In page number 41, there is reference to the 50% deposit which they have paid.
Learned counsel for the petitioner submits that even on the previous occasion, this court adjourned the matter at the instance of the learned counsel for the respondent, who undertook to file a memo of calculation regarding the arrears of rents payable by the respondent to the petitioner. Please. Full stop. Next para. Release this matter on 4th of September. Full stop. If memo of calculation is not filed at the hands of the respondent, this court will proceed to consider the matter on merits. Wait. Yes.
59. Rakesh Kini.
I appear for petitioner. Filed the application for vacating the interim order, my lord. The suit is one for framing of the.
You are ready?
I'm ready.
Huh?
Ready.
Yes.
My lord, yes. Application under Order 1, Rule 10 for impleading was filed, my lord. That has by me. That has been rejected.
Suit for?
In an execution petition, well. Suit in an execution petition, this application was filed.
Suit for?
Suit.
What was the suit for?
Framing of the scheme. Framing of scheme.
Respect of the temple.
Yes, respond number 2 to 6 is a temple. Respond number 2 to 6 herein is a temple. To frame the scheme of that temple, a suit was filed. Suit was decreed. Subsequently, RFA was filed. Order of the RFA, operative portion, is at page number 179. Roman number 3 is important for this matter. Operative portion starts from 178.
Hmm.
179, Roman number 3 is important. The board of the trustees of defend number 1, respond number 3 temple shall recognize the right of the family of the appellant defend number 38 and 196 to perform the duty of Tantriship, Purohit and Purana Vachaka in accordance with law. Why I stressed family is because, my lord, for the family right was given. This right was given as per the order dated 1/1/1994, which my lords will find at page number 20. Last 5 lines. Page number 20, last 5 lines. It is stated that right of Sri Venkatramana temple was confirmed on the family as per the order passed by the Commissioner of the Religious and Charitable Endowment Karnataka in so and so number on 1/1/1994. On 1/1/1994 itself, on our entire family, right was confirmed. That same was confirmed by this honorable court. Against which respond number 1 herein filed execution. Now execution is at page number 180, execution petition. Their prayer is at page number 183. Point number 10. To direct the judgment debtor to recognize the right of the family of the decree.
One minute.
Yes.
The directions issued by this court
Yes, page number one.
was that defendants number 10 and 11
Yes,
are the present trustees in office
yes,
of defendant number 1, record number 3 Temple are directed to take necessary steps to prepare and finalize the electoral roll of the temple in terms of the new scheme on or before 30/11/2021 and hold election for the post of trustees and complete the process of handing over the charge of the management of defendant number 1 temple to the new board of trustees on or before 28/2/2022.
this was conducted in accordance with law. There is absolutely no dispute about this. Now, the
Next.
dispute is the next point.
Ah,
The board of the trustees of defendant number 1, respond number 3, temple shall recognize the right of the family of the appellant of defendant number 38 and 196 to perform the duties of Tantraship, Purohit and Purana Vachaka in accordance with law. Now, family of the defendant number 38 is very important. I say I am also a family member. As per one order which I showed my lord 1/1/1994, from that time I have been performing this Purana Vachaka without any dispute. Now what respondent number 1 is trying to do is execute this order without my presence. Now after decree has been passed, what they are trying to do is canvassing, saying that only I have right.
without your presence means
Without my presence means without impleading me as a party in this.
who is defendant number 38?
Defendant number 38 is Bhadra Narasimha Devar. If my lord sees page number 180, execution petition.
Huh?
Bhadra Narasimha Devar.
Defendant number 38, sir.
180. Defendant number 38 is.
Sri G. Venkataramana Bhatt.
Alla.
ಹೌದು ವೆಂಕಟರಮಣ ಭಟ್ ಡಿಫೆಂಡ್ ನಂಬರ್ 38 ವೆಂಕಟರಮಣ ಭಟ್.
Defendant number 38, page number 39.
Huh?
Page number 39 of ink page number 39. Bhadra Narasimha.
Bhadra Narasimha Devaru.
Correct. Our family, even I belong to. That is my case. Without my presence, execution cannot be proceeded at all. What happens is, my lord, even
Appellants. Defendants number 38 to 196.
38 and 196.
38
And 196.
196. 38.
Is Bhadra Narasimha.
Bhadra Narasimha Devaru,
How?
represented by its present Paryaya
Dara. He was,
Jayanta Acharya.
he was the president
Cannot
Paryaya
take-
Dara.
Myself.
He was made as a party there. He represented as for Bhadra Narasimha Devar. Even I am also a family member of Bhadra Narasimha Devar. That is undisputed. Now what they are trying to do is only this Jayant Acharya who filed as a Paryayadar is trying to execute the order without making me a party. I am saying even I have right that executing court has to decide. Temple, my lord, which my learned friend Mr. Sriraj Gowda is appearing, is coming before the trial court and saying we are recognizing right of family. Family, even petitioner hearing is also a member of this family. What happens is, my lord?
He is representing the family, sir.
Yes.
Exactly.
Not for himself.
Exactly.
Who, my lord?
This Jayanta Acharya.
Yeah, he's also representing family.
Representing the
Yeah.
family.
Even I am a family member.
Correct.
Correct.
Where is the need to hear you?
Because
I am the senior
what
most
happens?
member of the family.
What happens is, my lord,
Whatever rights and privileges will be conferred on the Sri Bhadra Narasimha Devaru
Huh.
will inure to all the family members.
all the family members.
Then
ಆದ್ರೆ ಎಕ್ಸಿಕ್ಯೂಟಿಂಗ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂದ್ರೆ ರೋಮ್ ನಂಬರ್ 10
whatever submissions he'll make will be in respect of the entire family.
that's all
Cannot be done in individual manner.
ಇಂಡಿವಿಜುವಲ್ ಮ್ಯಾನರ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ಅಷ್ಟೇ.
ಇಲ್ಲ, ಹೌದು.
ಅದೇ ಮಾಡ್ಲಿಕ್ಕೆ ಟ್ರೈ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಅದೇ ಮಾಡ್ಲಿಕ್ಕೆ ಟ್ರೈ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
38 and 196.
Yes.
Yes.
ಅದೇ ಟ್ರೈ ಮಾಡ್ತಾ ಇದ್ದಾರೆ is our submission madam.
ಏನ?
ಅದೇ ಮಾಡ್ಲಿಕ್ಕೆ ಟ್ರೈ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಹೇಳಿ.
ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಟ್ರೈ ಮಾಡ್ತಿದ್ದಾರೆ?
They are canvassing before temple saying that only they have right. Only Jayant Acharya has right.
My lord, it was a representative suit.
I have filed affidavit.
Public notice was issued and this person kept quiet in the suit as well as in the appeal.
My lords may see the submission.
Now, my lord, in the execution proceedings.
This page number 180 is the execution petition.
Yes, execution
Isn't
petition.
it?
Yes, ma'am.
Yes.
What is the prayer?
Prayer is at page number 183. Number 10.
Yes.
To direct the judgment debtor to recognize the right of family of the decree holders. Here.
Family of the
How
decree.
family of the decree
Yes.
holder? I am also family. I have to be heard.
Everyone need not be heard, sir.
No, what they are doing is, my lord, my affidavit may kindly be seen. My affidavit.
Unnecessarily, you are creating a ghost by yourself.
My affidavit may kindly be seen. My affidavit may kindly be seen once.
Sir, the prayer in the petition is very clear. It is in terms of the decree passed.
My lord, maximum who can file
Yes.
objection is the temple.
To direct the judgment debtors to recognize the rights of the family of the decree holder.
My lord, their intention to file objection to this application only can be seen, my lord.
Not necessary.
Milords, I appeared for respondent number 2 to 6 minutes. Milords, two
My
Oh,
courts,
lord,
milords.
their intention is to
38
see-
and 196.
Yes, my lord, their intention is to see that
Yes.
the decree is defeated, my lord. I am aged about 86 years. In
You are representing whom?
I am appearing for the Jayantachar, senior most family member for whom he is
Jayantachar, no?
objecting. No, my lord, it was a representative suit. There was a paper publication. About 147 members have joined by seeing the paper publication. This man kept quiet. And in the appeal also, he kept quiet.
Why I kept quiet?
After filing the execution petition, my lord, these 6 trustees for whom my learned friend is appearing, he sets up this person and filed an application to delay the execution proceedings. Absolutely, he has no right at all. If execution, in the execuction, my lord,
You can't say he has no right, sir.
Yes.
my lord, he may have the right.
Decree is in favor of the family,
I am
not you.
Yes, I am representing the family.
The decree will have to be executed
Yes.
only in terms of the decree passed by the court,
Exactly.
not in your individual
No,
favor.
I am not.
That is
clear.
what they're
make-
trying
I
to
will
do.
make-
That is what they're
Yes.
trying to do, my lord.
Yes.
Milords, one submission.
No.
Milord.
Not be done.
That is what they're trying to do, my lord. My affidavit may kindly be seen. Only my affidavit may kindly be seen. At page number 190. Para 190. I say that number 3, page number 190. Number 3, I say that recently it is come to my knowledge that first respondent herein, who is the respondent herein, has been canvassing that except them, no other family members are performing the Purohit and Puran Vachaka. So if this application is not allowed, I will not be allowed to do what I was doing from 1994, my lord. Their objection to this itself can be seen, my lord.
My lord, in page number 27, you are kindly see, my lord. The trial court has said 27, my lord, in page number 27 of the order.
Maximum, if someone can file objection to this is temple, my lord.
27, my lord.
Respondent number 1
Starting
here
from-
cannot file any objection to this.
Starting from paragraph number 12, my lord. 26, the defendant number 38, 196 agreed by the finding of the court in para number 37 of the judgment preferred RFA number 148 and 2021. Before this honorable court, the RFA came to be allowed and upheld the scheme framed by this court in judgment dated so and so, so and so. Further, the defendant number 10 and 11 are present trustees of the temple are directed take necessary steps to prepare the finalize the electoral roll of the temple in terms of the scheme on or before so and so, so and so, and hold election for the post of trustees and complete the process of handing over the charge of the management defendant number temple to the now the board of trustees before 28/2/2022. The Honorable High Court of Karnataka, Bangalore also ordered the board of trustees of the defendant number respondent number 3 temple shall recognize the rights of the family of the appellant defendant. It is a family, not I am not claiming a right on my own. Therefore, my lord, I have filed the execution since they have not recognized me as a family of the head of the family. Now, in the execution petition, my lord, he was neither a party in the original suit nor in the appeal. Now he filed
defendant
an
number
application at the instance of other trustees.
Defend number 38.
Milords,
Only
if I may
only
make
to
my
defeat
submission,
my
Milords, I
execution claim.
represent respondent number 2 to 6, Milords. I appear for the temple and the trustees. Milords, two courts, Milords, have held in favor of the petitioner and respondent number 1. Milords, the duty now, Milords, of the temple is only to ensure that the Archak duties are conducted, irrespective of who does it. Milords, now petitioner number 1 also claims that he has a right, and respondent number 1 also claims he also has a right. Milords, my job is to ensure that the Archak duties are done. Now, Milords, the OS decree and the RFA, Milords, confirms that the family will do the duties. Milords, that is all that my job is, to ensure the family does it. Now, Milords, there are 2 members in the family. Milords, the 2 members should have right.
As between them. The order of the commissioner.
Because what
has been
respond
passed.
number one, my lords, is trying to do is he be the sole Archak to conduct the sole Archak duty. He is the only one responsible, is what he's submitting.
He's
But
trying to
that
do,
is
yes,
not what is, that is not what the case is.
Correct.
My lords, the decree, my lord, says,
Will not be permitted to
No,
conduct
no,
like that.
no.
plus that
is
is
not
what,
the decree
plus that is what he has done in the executing court.
Yes.
Plus he files an
So
impleading,
without my presence, that cannot be
he
decided.
files an
That
impleading,
is why I
my
filed
That
impleading
is
application.
not the decree, your lordship can
Because
see
that is exactly
page
what the
number
decree says.
177,
Huh?
page number 177,
Yes.
point number 3. That exactly the prayer made in the execution petition.
All that it says, my lords, is the family will conduct Archak duties. That is all that it says.
Don't confuse this.
My lords, if the issue is only with regard to Archak duties, my lords, it is not at all material, my lords, as to who conducts it.
Yes.
My lords, petition number 1 and respond number 1 are duty bound, my lords, to do the Archak duties.
Your lordship
Now, my
can
lords,
see-
what respond number 1 is trying to do is to ensure that, my lords, he does it solely.
No, no, it is.
His
it is
impleading
not the-
application, my lords, is
Lord,
dismissed on this one ground.
Filing objection to my impleading application, my lord. If impleading
lord.
application is allowed, no hardship will be caused to the respondent.
My lords, even if the
So
impleading,
impleading application has to be allowed.
even if the impleading application, my lords, is allowed, my lords, all that the executing court will do, my lords, is to decide who the Archak duties will be done by.
That is not the.
My lords, even if the application is allowed, my lords, no harm will be caused to respond number 1.
What is a prayer made in the execution petition, my lord? That is in terms of clause 3, page number 179. Board of Trustees, defendant of temple shall recognize the rights of the family of the appellant and defendant number 38 and 196 to perform the duties of tantrikship, purohits and Purana Vachakas in accordance with law. Now kindly turn to the execution petition, my lord, which your lordship will get it at page number 185. It is in terms of the decree passed by the Honorable Court, 183, my lord. Direct the judgment debtors to recognize the rights of the family of the decree
Where is
holder.
that defendant number 196 in your execution petition?
Not
He
part.
does not mention that.
Why?
Because he has to get.
He wants to keep
Because he
petitioner
wants to
out.
get right.
196.
In your execution petition,
Yes, ma'am.
where is defendant number 196?
196, my lord. 196.
He's not a party. He is
Depending
purposefully, my
upon-
lords, not made a party.
No, no, no.
That is why
my
without
lord,
my presence, it cannot be.
Your lordship kindly see, decree holder, my lord. I am the one of the decree holder. Now, represented by Paryayadar Jayanta Acharya.
That's all right, sir.
Now, yes, ma'am. 196. My lord,
In terms of the directions issued by the court,
yes, ma'am.
which we have read out more than 3 times now.
Yes, ma'am. 196.
Defendant number 38 and 196
196.
has been mentioned.
Yes.
So I am asking you,
Yes.
in your execution petition, where is defendant number 196?
Not made a party.
196.
Why have you not met
He,
the party?
he has not come, my lord. He has not come.
What do you mean he has not come?
He has not filed, he is not joining
The execution has to take place in terms of the decree.
in terms of the decree.
196 also has got a right.
My lord, yes.
Then
but-
you should have arrayed him as
My
a
lord,
respondent.
my lord, he is not interested to.
Lords,
He
that is
not-
the
he
sole
may not be
reason, lords.
interested to join you
Yes.
as a
No,
petitioner.
if he is
If
interested.
he's
my
not
lord.
interested, then he will be a respondent.
No.
Lords, that is the
That-
exact
that has
reason,
not
lords,
been-
why the impleading
My lord,
application
he
was
is
filed.
not joining as a decree holder, my lord. Therefore, he was
Sir,
not. made as a
therefore,
party.
if he's
Let him
not,
file, let him file the execution petition, my lord.
Huh?
Let him file the execution.
no, 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 no,
So
no.
on the decree, we have the
196,
execution
no.
petition.
So far as 196
No,
is
no, no,
concerned, my
sir.
lord. Let him file the.
Lords,
Now the question before your lordship, what is the right of the petitioner before your lordship?
Sir,
He is a-
if you,
he is a third party altogether.
I'll
Family
make
member.
it clear in my order
Yes, my lord.
that the decree is in favor of the family.
Yes.
It is not in favor of Jayant Acharya.
No, no, no. I am not claiming my.
So
absolute right.
even if he has filed a execution petition,
Yes.
it is on behalf of the family,
Family,
including this person.
Yes.
lords, that is the reason, lords, the impleading application was
Whether
filed.
he is a family member or not, he was not a party to, it is a representative suit.
Sir, it's a family, sir. It is not by individual.
He was not a party. He was
If
decree.
if this is the contention, I'll allow the
Decree-
petition
My lord,
and I'll allow the impleading application.
No,
also.
my
if I kindly
submission,
be-
my submission
down.
to your lordship is, my lord, 196 is the party. I should have made him as a party.
The
My lord,
petitioner.
I will implead, my lord. I will implead.
Madi,
Yes,
Madi,
responding
you
number.
implead 196 also. It was your duty to have
that-
impleaded 196 also.
Yes, ma'am.
Already working as a Purohit. He is already working
My lord, 190, I am told, my lord, 196 is already working in the temple as Purohit. I will implead. I will
In
implead.
the execution petition,
Execution petition.
all those persons,
I will implead, my lord.
who are required for execution of the decree were necessarily to be impleaded.
We will implead, my
Yes.
lord. 196. That clarification, my lord, with that.
No, there's no question of him impleading the petitioner. The petitioner has already filed an application for impleading. That is rejected, my lord. There's
Anyway,
no-
it's all right. Now he is accepting, all right, you implead him also, there is no difficulty.
196. my lord.
ಎಲ್ಲವಾದ್ರೆ
6 also had to be
implemented.
196.
impleaded.
Yes.
So we will direct that also.
Yes.
The petitioner is aggrieved of the impugned order.
My lord, I will not implead the present petitioner before your lordship because I am disputing, my lord.
Your
His
conduct
right
may
over
kindly
the
be seen, my
property.
lord.
Sir,
196, I will implead, my lord.
this execution petition, interstate dispute is not going to be resolved.
Yeah, exactly, exactly. Exactly.
So
Decree holder, I will,
a decree has been passed in favor of the family.
yes, my lord.
So even if you have filed a execution petition,
Yes,
it will be on behalf of the entire family.
yes.
Not as an individual person.
No, no.
Therefore,
But decree passed by this honorable court, your lordship
it
kindly.
is
see,
in
my lord.
favor of the family, not in favor of you.
No, my lord. Kindly see paragraph number 3, my
Yeah.
lord. Board of Trustees, respond number 3 temple shall recognize the rights of the family of the appellant, defendant number 38 and 196. Therefore, decree is in favor of respond number 38 and 196. I will implead 196, my lord. He was not a party to the execution petition. Because decree is in favor of defendant number 38 and 196. Rest, his right has not been recognized by this
Yes.
court.
Sir, the rights of the family is recognized.
That I do concede, my lord. I do concede.
Therefore,
I do concede.
in this execution petition,
Yes,
the interstate dispute between family members is not going to be considered.
yes, exactly.
You are standing there representing the family.
Yes,
So therefore,
yes,
even if the impleading application is allowed,
yes,
it is not going to affect you in any manner.
Yes.
If there is any dispute, that is to be considered by the appropriate authority
yes.
under the provisions of the Endowments Act.
That he will have to,
So therefore,
yes,
I will make it clear by
Yes.
this order.
yes,
That I am also family
Of
member.
standing there in the execution petition,
as a family.
representing the family.
Yes, exactly.
And the decree passed by the court shall be implemented,
Yes,
executed.
yes,
For that purpose,
yes,
for that limited purpose,
yes.
let him also be there.
Lord,
No-
that he can't be, my lord. I am citing the Supreme Court judgment because he was not a party to the suit as well as in the appeal. Kindly see, my lord. This matter has been settled by the Supreme Court. He can't be impleaded at all. Kindly see, my lord. Yes, please. My lord, B, para B, my lord. Necessary party who is test for held are that there must be a right to some relief against such party in respect of controversies involved in the proceedings, or no effective decree can be passed in his absence. Allowing the appeal, Supreme Court has held that the question of jurisdiction of the court to invoke Order 1 Rule 10. Now he filed an application under Order 1 Rule 10 to add a party who is not a party in the suit, or the plaintiff shall not arise unless party proposed to be added has a direct or legal interest in the controversy involved in the suit. A person is legally interested in the answer to the controversy only if he can satisfy the court that it may lead to result that will affect him legally. A bare reading of Order 1 Rule 10 to CPC could not clearly show that necessary parties in the suit for specific performance of the contract for the sale are parties to the contract, and if they are dead, their legal representative also a person who had purchased the contracted property from the vendor in the equity as well as in the law. Contract continues the rights of
No need
also
to read the
regulate.
other portions. The principles that govern consideration of an application for impleadment
Yes.
is whether a person is a necessary or proper party to the proceedings.
Yes,
Isn't it? As you have read out now, if he is not a party to the original proceedings,
yes, exactly.
there is
That
no need to implead.
Yes,
But don't forget that the defendant number 38
yes,
is a family
yes.
and not an individual person.
No, no.
Therefore, he is alleging, although there is a decree passed in favor of the family, is information that you are now trying to claim the rights personally only in your favor.
No, my lord, no.
Therefore, in order to protect the interest of the family, he would be
Necessary part.
entering the controversy.
Yes.
Only to protect the interest of the family. If you give a statement, you make a statement that whatever you are claiming will be on behalf of the family, and any interstate dispute between the family members will be considered separately by the competent
Yes,
authority.
yes.
I will record this.
Yes,
thing.
ma'am, yes.
Therefore,
Yes.
any decree that will be passed will be only in favor of the family.
Yes, ma'am.
And not in favor of you as
No, no, no.
individually.
No.
That will satisfy his
Yes,
requirement
ma'am,
also.
yes.
Yes, perfect.
But my impleading application may be allowed.
Not necessary, sir.
Because
If he is making that statement, I'll record it. And in the final decree, even they can bring it to the notice of the court. In your absence, even the trustee members also can bring it to the notice of the court.
no, my lord, what
That
happens
there
is,
is such a order passed by this court and an undertaking given by this person, and therefore no orders will be passed by the executing court vesting any rights individually in favor of this person.
Exactly.
including the
Exactly.
petitioner anta barbo.
Exactly.
It will be in favor of the family.
Including the petitioner anta.
My lord, speaking for the trustees, my
Families
lord,
of
if I
family
may make a
members.
submission, my lord.
That we do not know. For that purpose,
So that is why execution, in execution, I
not
have to
here,
be
sir,
impleaded.
that will not be considered here. For that purpose, you will have to approach the competent authority. If there is any dispute,
He is trying
the
to dispute.
order that will be passed will be only in favor of the family.
Yes.
We will make sure that the decree will be executed by the executing court only in favor of dependent number 38 family and 196.
Yes.
Now respond number 2 to 6 is recognizing my right.
Any interstate dispute between you, family members, has to be considered by the competent authority.
Yes.
And they will also make sure that no separate rights will accrue to the individual.
Yes.
Barkul.
Lord, speaking for the trustees, my lord, if he admits, my lord, that they are family members and the dispute is only between him and respondent number 1, my lord, there is no harm, my lord, in if the application is allowed. Even if the application is allowed, my lord, all that will happen is they'll contest the execution proceedings. That is all that is going to happen.
They are
My lords,
colluding.
irrespective of what he submits, my lords, ultimately, my lords, this is an impleading application. My rights or his right will not be decided if the impleading application is allowed.
That's all.
No, they're making this
They are
issue, my
colluding.
lords.
It shows that
Lords,
they are-
even if I'm colluding, my lords, I am appearing for the temple and the trustees. I am ensuring, my lords, that the family members are given archaic duties. That is all that I'm trying to do. My lords, now, my lords, respond number 1, very conveniently, my lords, does not include petitioner. The petitioner is left out.
There is no need for him to implead all the family
My
members,
lords,
sir.
there is no need, my lords, but if the impleading application is not allowed, what will happen, my lords, is I would be in contempt, my lords, of the RFA and the OS judgment.
How?
Not because it is a binding order. The temple is given the duty to ensure that the family conducts the archaic duties.
That is
Now,
what
my lords, if his,
that is what the court is also going to do.
lords, if,
No individual rights will be.
but he has filed the execution, my lords, in his individual capacity, keeping out the petitioner.
No,
Your lordship,
please
kindly
see.
see.
You
Let
please
us
see
not
the
mislead the
Lords,
court, my lord.
if-
please see the execution petition.
Execution petition, your lordship, kindly see. I am not claiming my right at all.
Bhadra Narasimha Devaru,
Ah,
represented by its present Paryayadar, Sri Jayanta Acharya. That was the same description in the original suit also.
exactly, exactly.
Lords, my only submission is that, my lords.
I will make it clear.
Yes.
Barkle. The petitioner who had filed an impleading application under Order 1 Rule 10 of the Code of Civil Procedure to implead himself in the execution petition number 134 of 2022 before this court on rejection of the said application. We'll stop. Next para. The undisputed facts are that a scheme suit was filed in OS number 2 of 2017 under section 92 of the Code of Civil Procedure. For the management of Sri Venkataramana Temple in Car Street, Mangalore, and for the other reliefs such as appointment of administrator, bar receiver, etc. Stop. A judgment was passed by the Principal District and Session Judge, Dakshin Kannada on 30th of November 2020. By framing a fresh scheme for the management of the temple. Full stop. Dependent number 38. And who is this other party in the RFA?
They
196.
they are all
196.
196,
ಇದು
Pandit
appellate
M.
ಅಲ್ಲ.
Kashinath Acharya.
ಹೌದು 196.
196.
ಎಲ್ಲ ಕಡೆ ಒಟ್ಟಿಗಿದ್ರು ಇಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನಲ್ ಪಾರ್ಟಿಯೇ ಮಾಡಿಲ್ಲ.
Dependent number 38 and 196 filed a regular first appeal before this court in RFA 148 of 2021, challenging the judgment and decree passed by the district court. Full stop. The appeal was disposed of on 29th of June 2021. Upholding the scheme framed by the district court. Full stop. However, a direction was also issued that the board of trustees of the temple shall recognize the rights of the family of the appellants dash dependents number 38 and 196 to perform duties of tantrikship, bar purohits and Purana Vachakas in accordance with law. Full stop. Pursuant thereafter, execution petition was filed by defendant number 38. Full stop. The petitioner herein, claiming to be a member of the family of defendant number 38, namely Sri Bhadra Narasimhadevaru, filed an impleading application while alleging that Sri Jayanta Acharya, who has filed the execution petition on behalf of the family, is trying to create rights only for himself to the detriment of the members of the family. Full stop. The application has been dismissed by the impugned order. On the ground that the applicant has not made any efforts to get himself implicated as one of the parties to the proceedings before the district court or before this court. Full stop. Next para. During the course of the proceedings, learned counsel for the petitioner as well as ನೀವು ಯಾವ respondent?
Respond number 2 to 6.
Respond number 2 to 6, comma, the management of the temple have pointed out that in the execution petition filed at the hands of respondent number 1 herein, the petitioner has left out
Defendant number 190.
defendant number 196.
Yes.
Full stop. At that juncture, learned counsel for respondent number 1 fairly submitted that he would implead respondent number 196, comma, since a decree has been passed
In his.
by this court,
Yes.
even in favor of defendant number 196.
Yes.
Full stop. However, insofar as the impleading applicant bar the petitioner here is concerned, comma, learned counsel would submit that the petitioner never tried to implead himself during the course of the proceedings before the trial court,
Yes, sir.
nor before this court. Full stop. Therefore, comma, it was submitted that no infirmity can be found in the impugned order. Full stop. Next para. Having heard the learned counsels for the petitioner, comma, the respondents, and on perusing the petition papers, comma, this court is of the considered opinion that the decree passed by this court is in favor of defendant number 38, comma, which is
The first respondent.
Family of defendant number 38.
Shri Bhadra Narasimha Devaru,
Family of defendant number 38.
comma, which is a family represented by Shri Jayant Acharya.
Yes.
Full stop. Therefore, no separate or individual rights can be claimed by Shri Jayant Acharya. Stop. The execution court is required to take note of the said decree which is passed in favor of the family and ensure that no separate rights or individual rights are carved out in favor of Shri Jayant Acharya. Full stop. On the other hand, if there is any inter se dispute between the family members of Shri Bhadra Narasimha Devaru, comma, that has to be considered by the competent authority in terms of the provisions of the act. ಅದ್ಯಾವ್ದು ಕೊಡ್ರಿ ಅದು ದಿ ಹಿಂದೂ ರಿಲಿಜಿಯಸ್ ಎಂಡೋಮೆಂಟ್ಸ್ ಆಕ್ಟ್ ಕೊಡ್ರಿ. In terms of the Karnataka Hindu Religious Institutions and Charitable Endowments Act, 1997. ಅದ್ಯಾವ್ದು ಕಮಿಷನರ್ ಆರ್ಡರ್ ತೋರಿಸಿದ್ರಲ್ಲ, ಎಲ್ಲ ಓದಿದ್ರಲ್ಲ, ವೇರ್ ಇಸ್
Page number 20. Last 5 lines.
For that purpose, a reference can also be made. ಇದರಲ್ಲಿ ಇಲ್ವಾ ಸ್ಕೀಮ್ ಅಲ್ಲಿ ಅಥವಾ ಇದು RF ಅಲ್ಲಿ?
ಇಲ್ಲ ಇಲ್ಲ
ಇಲ್ಲ.
ಹಾ?
ಇಲ್ಲ.
ಅದೇ ಕನ್ಫ್ಯೂಷನ್ ಅದು.
Shall take note of the fact that the Commissioner of Religious and Charitable Endowments, Karnataka, has passed an order on 1/1/1994 in case bearing number ADM 7 AP 12/93/94. Full stop. Next para. The executing court shall take note of all these aspects before executing the decree. Full stop. The managing trustees shall also ensure that the execution of the decree will be in terms of the intent of the judgment passed by this court. Full stop. No individual rights shall be bestowed on Sri Jayant Acharya, who has filed the execution petition
On behalf of
the
temple.
family of Sri Bhadra Narasimha Devaru.
On behalf of the temple, my lord.
Huh?
On behalf of the temple. I am claiming a right of Archaka in respect of the temple as a head of the family. Even in the execution petition, I have stated family. It is clearly stated in the execution petition, my lord, as per the decree.
Full stop. Directions are hereby issued. Next para. To the first respondent who has filed the execution petition. Directions are hereby issued to the principal district and session judge, Dakshin Kannada, to ensure impleadment of defendant number 196, without whose presence the decree cannot be executed, having regard to the specific directions issued by this court. Full stop. The writ petition is accordingly disposed of.
Grateful, much.
My lords, one submission, my lords. Serial number 42.
Interim orders. As it is again, sir. There will be no changes, no damages. Same.
The extension.
Our matters will be listed next week. Next week. No dates, sir. Next week.
ಕೇಳಿಸ್ತಾನೆ ಇಲ್ಲ ಇದು.
Might be, maybe. Maybe, might be.
Next week.
Court officer, sir.
Interim orders previously ಏನಿದೆ ಅದು ಹಾಗೆ ಇರುತ್ತೆ. ಕೋರ್ಟ್ ತಗೊಂಡ್ರೆ ಮಾತ್ರ ಅದು ರೀಚ್
ಆಗ್ಲಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಇದು ಮಾಡಬೇಕಾದ್ರೆ ಬರೀ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಬಂದಿದೆ.
ಅಷ್ಟೇ ಹಾಕಿಲ್ಲ. ಇಂಟ್ರಿ ಆರ್ಡರ್ ಬರೋದಿಲ್ಲ ಅದು. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಬರುತ್ತೆ. ಈ ಕೋರ್ಟ್ ಏನೋ ತಗೊಂಡ್ರೆ ಮಾತ್ರ ಬರುತ್ತೆ ಅಷ್ಟೇ.
Court officer, sir.
ಮೇಡಮ್ ಹೇಳಿ ಮೇಡಮ್.
Sir, serial number 42 interim order extend ಆಗಿದೆಯಾ ನೋಡಿ sir.
42 ನಾ? One second. ಆಗಿದೆ ಮೇಡಮ್. 42
Thank you.
ಈ ಕಡೆನೇ ಬನ್ನಿ ಸರ್. ಈ ಕಡೆ ಬನ್ನಿ ಸರ್, ನಿಮ್ಮ ಮೆಮೊ ಅಲ್ಲಿ ಮಾತಾಡಕ್ಕಾಗಲ್ಲ ನಮ್ಮ ಮೆಮೊನ. ಸೀರಿಯಲ್ ನಂಬರ್ 2.
ಅಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂದ್ರೆ ಇದೇ ವಾರ ಬರುತ್ತೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ಸೀರಿಯಲ್ ನಂಬರ್ ಏನ್ ಹೇಳಿ? 49.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಅಲ್ಲ ಅದು ಇನ್ಫ್ರಕ್ಚರ್ಸ್ ಆಗಿದೆ. ಅದು OS ಇನ್ಫ್ರಕ್ಚರ್ಸ್ ಆಗ್ಬಿಟ್ಟಿದೆ. OS ಇನ್ಫ್ರಕ್ಚರ್ಸ್ ಆಗಿದೆ. ಅದು MML ನೀವು ಬಂದಿದ್ದೀರಲ್ವಾ, ಆದ್ರೆ ಅದು OS ಇನ್ಫ್ರಕ್ಚರ್ಸ್ ಆಗಿರೋದ್ರಿಂದ ಅದೊಂದು ಚೆಕ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದಾರೆ ಸರ್. ಇಟ್ ಇಸ್ ಬಿನ್ ಇನ್ಫ್ರಕ್ಚರ್ಸ್. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಒಂದು ಸಬ್ಮಿಷನ್ ಮಾಡಿ ನೀವು. OS ಏನಾಗಿದೆ ತಗೊಂಡು ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಅದನ್ನು. 49.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂದ್ರೆ ಇದೇ ಡೇನೆ ಬರುತ್ತೆ.
ಒಂದು ಡೇಟ್ ಇದೆ.
ಮೆಮೋಸ್ ಇಲ್ಲಿ ಬನ್ನಿ ಸರ್, ಅವ್ರು ಕೇಳಿ, ಅವ್ರು ಕೊಟ್ಟಿದ್ರ ಮೆಮೋ.
ಅಲ್ಲ ಬೋರ್ಡ್ ಅವರು ಫೈಲ್ ರಿಟರ್ನ್ ಮಾಡಿದ್ರು.
ನಾನು ಅದ್ರ ಬಗ್ಗೆ ಕನ್ಸರ್ನ್ ಮಾಡಕ್
ಅಲ್ಲ, ಒಂದು ಫೋನ್ ಮಾಡಿ ಹೇಳಿ. 3:30
ಫೋನ್ ಮಾಡಕ್ಕೆಲ್ಲ
ಹೆಂಗೆ ಸರ್ ಇದು?
ನಾವು ಅದನ್ನ ಹೆಲ್ಪ್ಲೆಸ್. ಐ ಆಮ್ ಸಾರಿ.
ಖಂಡಿತ ಆಗತ್ತೆ.
ಅಲ್ಲ ಮಾಡಕ್ ಆಗಲ್ಲ, ಅದು ಪವರ್ಸ್ ಇಲ್ಲ.
3:30 ಫೈಲ್ ರಿಟರ್ನ್ ಮಾಡೋದು.
ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್
69 next week ಅಂದ್ರೆ ಇದೇ ಡೇನೆ ಬುಧವಾರನೇ ಬರುತ್ತೆ.
ಇಲ್ಲ ಸರ್ ಬರುತ್ತೆ ಅದು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಎನಿ ಟೆಂಟೇಟಿವ್ ಆಗಿ ಬರುತ್ತೆ.
69.
ನೀವೇ ಪವರ್ ಹೆಂಗೆ ಸರ್?
Powers ಇದೆ sir.
ಕ್ಲೋಸ್
ಸಾಹೇಬ್ರೆ
ಮಾಡಿ 3:30 ಕ್ಲೋಸ್ ಮಾಡೋದು ಹೆಂಗಿದು? ಎಲ್ಗೋ ಬೇಕು ನೋಡಿ ಅರ್ಜೆಂಟ್ ಏನ್ ಮಾಡಿ ಸರ್?
ನಾವೇನು ಮಾಡಕ್ಕಾಗಲ್ಲ. ನೀವೊಬ್ರು ಒಂದ್ಸರಿ ಹೇಳಿದ್ರೆ ಅವ್ರೊಬ್ರು ಹತ್ತೋದಕ್ಕೆ ಸಂಬಂಧನೇ ಇಲ್ಲ. ನಮಸ್ಕಾರ ಅದು.
ಏನಾದ್ಮೇಲೆ ಅಸೋಸಿಯೇಷನ್
ಹಂಗಂತ ಅಲ್ಲ ನಾವು ಅಸೋಸಿಯೇಷನ್ ಅಂತಲ್ಲ ನಾವು we are not
ಅದ್ ಏನಾದ್ರೆ 4:45 ಕ್ಲೋಸ್ ಮಾಡೋದು 3:30 ಫೈಲ್ ರಿಟರ್ನ್ ಮಾಡೋದು ಈಗ ಎಲ್ಗೋಬೇಕು ನಾವು ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂತ ಅಲ್ಲಿ
ನಮ್ಗೆ ಏನ್ ಹೇಳ್ತಾರೋ ಅಷ್ಟೇ.
ಅರ್ಥ ಇದೆ ಇಡೀ ಹೈಕೋರ್ಟ್ ಕೂತ್ಕೊಂಡು ನಮ್ಗೆ ಯಾವ್ದು ಕೇಸ್ ತಗೊಳ್ಳಂತ ಡಿಸೈಡ್ ಮಾಡಿದಾಗ ಹಿಂಗಂದ್ರೆ ಏನ್ ಅರ್ಥ?
ಸರ್ ನಮ್ಮ ಹತ್ರ ಮಾತಾಡಿ ಏನು ಪ್ರಯೋಜನ ಇಲ್ಲ ಸರ್. ನೀವು ಇಟ್ಸ್ ನೋ ಯೂಸ್. ವಿ ಆರ್ ಹೆಲ್ಪ್ಲೆಸ್ ಫಾರ್ ಯು. ವಿ ಕ್ಯಾನ್ ಗೈಡ್ ಯು.
ಅದಕ್ಕೆ ನಾನು 4 ಗಂಟೆಗೆ ಬಂದಿದ್ದು ಮಾತಾಡ್ಸಕ್ಕೆ 5 ಗಂಟೆ
ಕೋರ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಬಂದು ಮಾತಾಡಂಗಿಲ್ಲ. ಅದು ಸರ್ಕ್ಯುಲರ್ ಇಶ್ಯೂ ಆಗಿದೆ. ಓನ್ಲಿ ಆನ್ ದ ರಿಕ್ವೆಸ್ಟ್ ವಿ ಆರ್ ಗೋಯಿಂಗ್ ಟು ಡು.
ಅದಕ್ಕೆ ನಾನು ಬಂದಿದ್ದೆ ಸರ್ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಕ್ಕೆ ಬಂದಿದ್ದು 3:30 ಮಾಡ್ತಾ
ಸರ್
ಇದ್ದಾರೆ.
ಅಲ್ಲಿ ನಾವು 1 ನಿಮಿಷ ನಿಮ್ಗೆ ಹಿಂಗ್ ಮಾಡಿದ್ರೆ ನಮ್ಗೆ ಇಲ್ಲಿ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ, ಅವ್ರಿಗೆ ಇವ್ರಿಗೆ ತೊಂದರೆ ಆಗುತ್ತೆ.
ನಾವ್ ಅದ್ ನೋಡಲ್ವಾ ಹಿಯರಿಂಗ್ ನಡಿಬೇಕಾದ್ರೆ
ಅಷ್ಟೆಲ್ಲ ಮಾತಾಡ್ಬಾರ್ದು. ದಟ್ ಇಸ್ ನಾಟ್ ವರ್ಕ್.
ಅಷ್ಟು ಮಧ್ಯದಲ್ಲಿ ಬಂದು ಡಿಸ್ಟರ್ಬ್ ಮಾಡ್ತೀವಿ ಹಿಯರಿಂಗ್
ಹೌದಾ
ನಡಿಬೇಕು
ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಮಾತಾಡೋದೇ ಡಿಸ್ಟರ್ಬೆನ್ಸ್. ದಟ್ ಟು ಮೆಮೋ ಇಟ್ಸ್ ನಾಟ್ ಅ ಸಿಂಪಲ್ ಥಿಂಗ್. ವಿ ಹ್ಯಾವ್ ಟು ಎಕ್ಸ್ಪ್ಲೇನ್ ಫಾರ್ ಯು. ಗೊತ್ತಾ ನೋಡಿ ಇಷ್ಟೊಂದು ಮಾತಾಡೋದಿರುತ್ತೆ.
ಪ್ರಾಬ್ಲಮ್ ಇರೋದಕ್ಕೆ ತಂದು